registered civil deed. We don't know. Kelly, no. Jeff, no.
I go. Yeah.
Hear ye, hear ye, hear ye. The State of Michigan Court of Claims is now in session. Presiding, the Honorable Christopher P. Yates. All persons having business herein draw near, give attention, and they shall be heard. God save these United States, the State of Michigan, and this Honorable Court. Please be seated.
Welcome back, everybody. Before we go on the record, let me make sure that Mr. Trudell can hear me and I can hear him. Mr. Trudell, how are you? Nice to see you again.
Doing well, thank you.
And I take it you can hear me just fine.
Yes.
Before we get started, I want to test the table mics to make sure that they're working. So Ms. Service, can you say something into your mic and make sure he can hear it?
Testing, testing.
I can hear.
Good? Okay. Marshawn, you want to try your table mic?
Yes, Your Honor. Thank you.
Sounds good.
All right, great. Let me call the cases now, and we're going to have a conversation about lots of things this morning. These are now two consolidated cases, and I'm relieved that we have consolidated cases. The first one is 25-000143-MB. The second one is 25-000162-MB. For ease of reference, I'm going to call the earlier case the PIHP case, and I'm going to call the later case the CMHSP case. I think we all know what those acronyms mean, but what brings us here today, other than the certain symmetry in my life, I was sitting in this very chair last Thursday and Friday wearing a completely different hat as the presiding judge on the Court of Appeals. But I'm back to being a trial judge again today, and so it's good to see you all. We had a conversation last Friday afternoon. We've had several conversations leading up to this. And we're going to have to talk about witnesses in just a moment because there are some complications that we need to see if we can iron out. But for the time being, let me just explain what brings us here today. When the case was started by the PIHPs, there were challenges to request, where is that thing? I have everything here somewhere. Give me a second. Okay, there was a request for proposal number 25 and then a whole bunch of zeros and then 2670. It was issued in August of 2025, and essentially it would restructure the process for delivery of public mental health services to Medicaid beneficiaries. I think, as I understand it, the RFP, as it's called, would make a transition from single source procurement to a competitive procurement system. And all of this was reflected in a very long document, which includes a statement of work. When I issued my ruling on the first round of motions in this case on October 14th, 2025, I said that the MDHHS has the discretion to move from a single source procurement system to a competitive procurement system. I know there's a motion for reconsideration, but as far as I'm concerned, we don't need to talk about this today. I also said that the MDHHS could reduce from 10 to 3 the number of PIHPs and redefine the regions. Again, motion for reconsideration pending, but let's not focus on that today. And then finally, I indicated that there were genuine issues of material fact as to whether the language of the RFP runs afoul of Michigan law in important respects. Now, at that point, the PIHP plaintiffs were not only making their own arguments, but effectively trying to carry water for the CMHSPs as well. Well, we don't have to worry about that anymore because the CMHSPs are now here to speak for themselves. And to the extent that there are challenges to be made, I think it's fair to say that the two categories of plaintiffs now represent the universe of claims that are being brought against the MDHHS in terms of this RFP. Is that fair, Mr. Marchand and your team?
Yes, Your Honor, except with the Region 10 case, there are 3 CMHs.
Yes, I did know that. Yeah, I knew we had some CMHSPs involved, but Mr. Cook, I think you now have truly taken up the cudgels on behalf of the CMHSPs. Is that accurate?
I have.
All right, and I think your collection of plaintiffs consists entirely of CMHSPs.
There's one county representative.
Okay, sorry, I missed that. You're right. I apologize. So, Mr. Marchand, I recognize that you certainly, along with the other lawyers on your team, I don't mean to diminish the significance of all the other terrific lawyers you have sitting there with you, but you're in the lead spot, and so I'm going to treat you as the pilot for the moment. You can make the arguments on behalf of the CMHSPs, and I've acknowledged that from the beginning. That's why we didn't have any kind of standing problem. All right, now, let me just explain how the delivery system works as I understand it. The current delivery system involves contracts with 10 regional PIHPs, which in turn administer Medicaid funds through contracts with the CMHSPs and other service providers. Each county in Michigan may establish a CMHSP, and obviously that's prevalent, either on its own or by joining with other counties in the local community. And what happened, boy, it goes back more than a decade now. There were 10 PIHPs formed for the 10 regions of the state. And those PIHPs have essentially been working on an interface with CMHSPs to deliver services. And it's fair to say there's an awful lot of money flowing through the system, including a substantial amount of Medicaid funding. So on August 4th, 2025, as I indicated, the DTMB, which is why they're named as a defendant, and the MDHHS issued the RFP, and it's for a period that begins on October 1, 2026. So, Ms. Service, we've talked about this. I'm grateful for the fact that there is some breathing room here because however the system gets restructured, the new PIHPs will have time to get their legs underneath them and be ready to start delivering services on October 1st, 2026. I have another case, which is, I guess, neither here nor there, where the funding was cut off at the beginning of this fiscal year, and so we have a true crisis there. Here, I know that time is important, but it's not absolutely of the essence. Is that fair?
I would say the reason it's of the essence is, I'm not sure if you can hear me, but the reason it's of the
You can
essence.
remain seated to stay on the mic if you want. It won't bother me. I won't take offense at all.
Just because there's so many steps that need to occur with the federal government to get things set up before the start date. So that would be why.
Right. And I understand that we can't drag this out. As a matter of fact, I know that you've postponed on at least 2 occasions the date for making a final determination. And at least as we sit here today, no final determination has been made. No contracts have been signed. Nothing's happened that locks in a system that I could then blow up in a decision. Is that fair?
That's fair.
Okay, thank you very much. Now, one of the things about the reorganization of these PIHP regions is that bidders can only bid if they can provide services throughout the entire region, which essentially, for Mr. Marchand and the other attorneys, makes it impossible for your clients to be bidders because they were structured in a manner that was coterminous with the boundaries of the 10 regions. And so necessarily by implication, not a single one of these 10 PIHPs is in a position where it could cover the entire boundary of any of the 3 regions. Accurate?
That is accurate.
All right. So when I made my decision in mid-October, what I said was, and I'll break it down into 3 parts. Well, let me back up and say that I granted summary disposition in part and denied it in part. The defendants had moved for summary disposition under MCR 2.116 C8 and C10. C8, of course, challenges the legal sufficiency of the complaint. C10 challenges the factual sufficiency of the complaint. And frankly, we had an evidentiary hearing. I had a lot of information in front of me. What I concluded was that it was satisfactory as a matter of Michigan law. It's not my decision to make policy. I've said before, I think this is crazy from a policy standpoint, but I don't get to run the MDHHS. It's not my job. That it was consistent with Michigan law to change the procurement system from single source to a competitive procurement model. And I said that it was satisfactory under Michigan law to reduce from 10 to 3 the number of regions. None of that is really in dispute at this hearing. Again, I'm well aware of the motion for reconsideration, but it's not my business to go back and revisit that. However, I said at the end of my opinion that I had concerns about 2 particular aspects of the RFP and the way that it might be incompatible with Michigan law. And to quote my own opinion, first, Michigan law does not empower the MDHHS to rewrite the mental health code by permitting a PIHP to directly provide or contract out services that a CMHSP is statutorily obligated to provide. And that has to do with allocation of responsibility. Particularly, the statement of work states that PIHPs, quote, are expected to provide managed care functions to beneficiaries, and those functions cannot be delegated to contracted network providers as a general matter. So that's one of the things, Ms. Service, I'm looking to see how you answer. The second is a funding issue, which I think is critically important. Nothing in the 2025 RFP itself or the attached statement of work requires a PIHP to provide Medicaid funds to a CMHSP for services that the CMHSP is obligated to provide. And this was something that both our senior research attorney and I flagged as especially problematic, because to the extent that the system counts on a flow of Medicaid funds down from the top, from the federal government to the state, and then from MDHHS to the PIHPs, and then from there down to the CMHSPs. If the money can stop at the PIHPs and they can do whatever they want with it, they can essentially starve the CMHSPs of funds, particularly Medicaid funds. Again, Ms. Service, I suspect you're going to have an explanation for all that. As a matter of fact, I know you do. But I didn't bring out all the briefs that everybody wrote. I will confess that this was one of the most challenging weekends of my career because, as you know, I didn't get back from oral arguments until almost 5 o'clock on Friday. We had an emergency call, and then at 5 o'clock, just coincidentally, they reset all of our computers, and I was frozen out of my computer when I went in at 6:30 in the morning on Saturday to try to get some work done. That was finally fixed on my laptop with the help from some very, very kind person from our IT division. At 9 p.m. on Saturday, I finally had access to everything. But as luck would have it, my laptop doesn't give me access to all the Word files and everything that I have in the archived materials for this. And beginning at 6 a.m. on Sunday, there was no power in the court building. And so I literally could not get into my office to get to my desktop where I would get these materials. And we were told the power would be out the entire day and it might not even be on until midnight. So here I am. I'm as prepared as I can possibly be under the circumstances. I can assure you, I did everything I could to get to what was out there, but technology sometimes has its limits. Now, let me pick up with what we need to do, because I don't mean to remonstrate about all the bad luck that befell me over the weekend, just coincidentally, because I'm ready to go. There was a stipulated scheduling order submitted by all the parties once the consolidation took place. And I want to thank the parties for working this out. We had talked at length about it. We had worked out a few of the details, but basically you did this yourselves, which is great news for me. Now, as I understand it, today, we're supposed to begin with opening questions from the court. And I view this as an opportunity to clean up some other things like the witness issues we have to deal with going forward. And then we'll begin with witness testimony. I do want to give you an opportunity, each one of you, to make some opening comments if you wish. I'm not going to insist on it, but I think it probably will do well to set the table before we get going. Then we're going to move into witness testimony after taking a short morning break. We'll take an hour at lunch, noon to 1, and then we'll be back and we'll go to approximately 5 o'clock. Our Director of Security is here helping out. We get only the best, right? So Mr. Flegel, so glad to have you here. He's been listening to me talk for the last couple days. So it's great to see you again. I promise we'll finish before 5 o'clock today. And then, because this is a home and home series, just like Michigan State and Michigan played in hockey over the weekend, the AG's office got their home game today on Monday in Lansing, and then we'll repair to Grand Rapids because that's the available courtroom on Tuesday. And then I'm afraid we're probably going to wind up having to go in Grand Rapids on Wednesday too. It was my preference to do this in 2 days, but events may cause us to have to go a third day. And so I'm going to try to book that courtroom on Thursday. Fortunately, Judge Redford's trial settled, so there's no oral argument there. There's an oral argument here on Tuesday and Wednesday, but we can go in Grand Rapids on Wednesday. So everybody plan to, if you're packing to come to Grand Rapids tomorrow, plan to pack for 2 days instead of 1. Okay, that's a lot to go over. But let's talk now first about how we're going to handle these witnesses, because as I understand it, the way you set up this system, there was supposed to be accelerated discovery, and I have no doubt that you engaged in that. Everybody looked exhausted when I saw you on Friday, so I know depositions took place. And I think the plan was everybody who was going to testify would be deposed, and then they'd be able to get on the witness stand and you'd know what was coming. Well, we discovered on Friday, and I'm not blaming anybody for this, but we have to fix this, that the state wants to call a couple of witnesses who have not yet been deposed. One is Mr. Haveman, I think, and then one is somebody from Hope Network. I forget the name.
Correct. Excuse me, Mr. Becker.
All right. And I presume that the Hope Network witnesses from the Grand Rapids area, is that accurate? Or am I not right about that?
He is from Grand Rapids, and I'm actually going to turn the mic over to Mr. Beach, who's going to talk to you about this piece of it today.
Okay, yeah, that's fine. Because I'm going to give you all an opportunity to explain what's going on, but I just want to make sure that I understand the nature of the problem. So I think, and anybody at this table can explain it as we go through it. I think the problem is that of the 3 witnesses that the state now intends to call, 2 of them have not been deposed. Mr. Haveman is one of them. I think I'm pronouncing his name correctly. Or has he been deposed?
No,
All right. And
Judge, he hasn't, no.
okay, and then the Hope Network witness hasn't been deposed. Okay, the 3rd witness is somebody who is local here. Is that somebody you wanted to get on and off the stand today? Because I said it accommodate people with travel issues, or are we just going to have the plaintiffs call witnesses and that's going to be it for the day?
The 3rd witness can testify tomorrow in Grand Rapids.
Oh, great. Okay. I think, Ms. Service, I can't remember. The candle was barely flickering in my brain by the time I talked to you on Friday afternoon. So I'm sorry if I can't
No
remember
problem at all.
everything that was said. Okay. So why don't I give you each an opportunity to explain what's going on, and then let me see if I can fix this.
Judge, thank you. I guess from the outset, something that we need to correct. It was never our understanding that everyone disclosed would get deposed. That was not our understanding.
Okay, it's
Um,
fine.
So I think that's a fundamental thing here. So the parties set the 4th for our final witness lists. I pushed back on that, Your Honor. I knew the 4th wasn't enough time if people wanted to take depositions, but that's what we agreed upon. You know, the court asked us to do our own scheduling order. So our understanding was that any individuals on the witness list on the 4th, that was fair game. I would say that the disclosures in this case were very broad. Everyone's disclosures, most in terms of plaintiffs, there were a large number of entities. It would have been impossible if we were going to try to take depositions of everyone that was on disclosures. So it was our understanding, again, it was the court's instructions for us to come up, for the parties to work together here.
Yep.
That's what we did. Maybe there was a misunderstanding, Your Honor, but our understanding is that we could add anyone on the 4th that we wanted.
And just to be clear about this, because we're doing this on such a compressed schedule, the disclosure of the witnesses who would testify did not occur until before 5 o'clock last Thursday, right? I'm not blaming any of you for
No.
that. I mean, we were working on the most accelerated timetable we could possibly put together.
Judge, and as just a little background, at that status conference in October, after you issued your ruling.
Yep.
You asked us to work together. It was your words, it's going to be an imperfect process.
Yes.
So
And
the
it has
parties
been, but that's nobody's
started
fault.
discovery right off the bat. You told us to do rolling productions. That's what we got started on a week after we got plaintiff's requests. But I can tell Your Honor, discovery's been very contentious in this case. Getting plaintiffs to do a rolling production was like pulling teeth here. We still don't know where documents came from. They dumped thousands of documents on us the Wednesday before Thanksgiving weekend at 5:30, which then we couldn't access over the weekend. And they dropped 20,000 documents on us on the Wednesday last week. So we've been working through discovery. It would have been impossible to know, you know, everyone that possibly could be a witness or coming up with just strategy. So this was always going to be an imperfect process, and we thought we had until the 4th. So that's why we disclosed Mr. Havman. I would note that Mr. Havman is named in one of the exhibits that's actually an attachment to the first brief that was filed by plaintiffs. So they know who this guy is.
Right. I mean, he's one of those people everybody knows
Yeah,
who he is.
I think Mr. Marchand has called him in the past before this case even started. So again, it was just never our understanding was that everyone that was disclosed would be deposed. And the parties agreed on this date on the 4th. I agree if we're going back in hindsight, that probably was not the best date if people wanted to take depositions of every witness. But that's what we agreed upon. This was very imperfect, and very little about this entire process followed the court rules. That's kind of our shock here when we heard they were trying to exclude witnesses is we haven't followed the court rules at all. We produced over 20,000 documents within 14 days. And this has been very rushed. It's been chaotic. So again, we acted in good faith. We thought we had until the 4th.
Right. Well, and Mr. Kitzmiller, I'm certainly not trying to exclude witnesses. Every single time I've talked to all of you, I've said that I want everybody to be able to make the presentation they want to make, and we'll do everything we can to ensure that that happens. I mean, of course, we haven't been able to follow all the details of the court rules. I mean, we're basically trying to run a case from start to finish in a matter of weeks rather than a year or two. And that's necessarily going to require us to expedite an awful lot that ordinarily would have come out at a very manageable pace. I mean, everybody knows how civil discovery works. It takes forever, and
Years.
nobody is ever surprised by anything by the time a trial occurs, if a trial ever occurs. But here, of course, we were doing the best we could to try to put material in each other's hands. And I don't fault anybody if there were some hiccups along the way. It's just the way it goes. Okay. So tell me, in terms of availability of these two contended witnesses, whether they would be available to be deposed, for example, on Tuesday afternoon, if I give you Tuesday afternoon off and then tell you we're gonna pick up again on Wednesday, or whether they could be deposed on Wednesday morning and then we could run the hearing on Wednesday afternoon. Because I think Mr. Haveman is not available on Tuesday at all. Is that fair?
He's not available on Tuesday. He is available all day Wednesday.
Okay, so it would not be unrealistic then for me to ask that the Hope Network witness sit for deposition on Tuesday afternoon, that Mr. Haveman, I never quite understood how to pronounce the name, so it's Haveman, is that?
Or Haveman,
I thought it was Haveman. I apologize if I have it wrong. Anyway, he could sit for a deposition on Wednesday morning. And then we could have him testify on Wednesday afternoon. Is that, he's available on Wednesday?
He's available if they would
Okay.
like to depose him.
Right.
I confirmed he's available all day
Right,
Wednesday.
because what I'm trying to do, and I know, again, this is going to be compressed, but I don't want to put them in a position where they have to fly blind. Frankly, it'll make the actual testimony much easier to follow if there's been a deposition. Now, I'm not naive enough to think that we'll all have a transcript in our hands if he's deposed on Wednesday morning when he takes the stand on Wednesday afternoon. But that is a possible schedule we could run.
That is a possible schedule, Your Honor, yes.
Okay. And I think your third witness has probably been deposed already, right?
Ms. Asman has been deposed. She was deposed on Friday.
Okay, so we're only talking about two people.
So we're talking
Okay,
about two.
great.
Yep.
And do you have any objection to doing what I propose and essentially moving what was going to be the Tuesday afternoon segment of this hearing into Wednesday afternoon and freeing you all up then to do depositions on Tuesday afternoon and Wednesday morning?
I don't have any objection, Your Honor, no.
Okay, believe me, I spent a lot of time over the weekend trying to figure out how to solve this problem, and I think that's probably the best way to do it.
Judge, and since we're making, just to be clear on the record, since we didn't file appearances, I'm Mr. Beach.
Oh, I'm sorry, Mr. Beach.
It's okay. There's a lot of attorneys here. I just,
There's so many people on my
I never
Zoom
entered
screen.
appearance and
I am so sorry, Mr. Beach.
no, not a
All
big
right.
deal.
Yeah, Ms. Service has been here through everything, and Mr. Damish has been here through everything. Yes?
Yep. Mr.
Okay, and Mr. Beach, glad to have you here. Okay.
Everybody's got a like
Right.
1,000-yard stare. What's the term there?
Yeah,
About
right.
the,
All right, so let me go to the other side now and see if we can live with this solution, because I think this is probably the approach that's fairest to everybody. All right, Mr. Marchand or anybody else at this table? I'm sorry?
It's Mr. Ryan who will handle.
Okay, Mr. Ryan, my proposal is that what we do, we let you call all of your witnesses today, not all, but as many as we can get through today. And then, one of their witnesses can be called and can testify tomorrow because you've already taken that deposition, correct?
Correct, Ms. Asman, yes.
All right, so my proposal then is that we take the block of time that was set aside for Tuesday afternoon. We move it into Wednesday afternoon. On Tuesday afternoon, you conduct the deposition of the Hope Network witness. On Wednesday morning, you conduct the deposition of Mr. Haveman. And then we have these witnesses appear for testimony on the record on Wednesday afternoon. So go ahead and react to that. I know you're not happy about this, but I am determined to give you a deposition before these people actually testify live.
Okay, and we certainly appreciate the opportunity to be able to depose them. Our concern is that if the depositions don't occur until essentially, well, no, not essentially, until after we have totally put in our case and called our last witness, and we have no idea what these two individuals are going to say. We've now planned our case, we've ordered witnesses methodically with a certain expectation in mind. And now we have two witnesses who the state is going to call. We don't know what they're going to say. I suppose in theory, we could call a rebuttal witness.
That's exactly what I was going to say.
My only concern on that is shortly we will ask for witnesses to be sequestered. And if we don't sequester a witness who we want to call, because because we don't know who these individuals are gonna say, I don't want to be precluded from calling a witness who wasn't sequestered because we didn't know that this individual was gonna be called.
Well, my view about sequestration and rebuttal witnesses is because you never know whether you're going to need to call somebody as a rebuttal witness. I'm not going to be strict about that sequestration requirement as a basis for precluding testimony for a rebuttal witness. This is a logistical problem that comes up in all kinds of trials all the time. So with that understanding, are you more?
I mean, again, we understand the court's ruling. I
Right.
think it's an accommodation that
I'm doing the best I can.
we understand. I do have a problem with the fact that there was no discovery produced by any of these individuals. I don't know if there were communications with these individuals. Ms. Asman, we asked her about it during her deposition, whether she searched for communications with these individuals. She did not. I have no idea whether the other witnesses did, because again, we deposed them before we knew.
Let me turn back to Mr. Beach for just a moment then.
Sure.
I would hope that the actual documents to be introduced as exhibits through these witnesses could be made available before their depositions. Can we do that?
That's not an issue, Judge, because we don't plan on putting any documents into
Oh.
the witnesses. So
Well,
it's
this
not
just
an issue.
became a lot easier.
Well, I mean, in a way, yes, but
I understand.
we would want to cross-examine them on potential communication that might impeach their testimony, et cetera.
I get it. I get it. Can you promise to give them whatever would be germane to the testimony that's being given? If it's the null set, it's the null set and there's nothing to turn over and that's fine. And the fact that you are telling me now that you're not going to try to introduce any exhibits through either one of those two witnesses gives me a great deal of comfort.
I don't think it's an issue that if there's anything that we would need to turn over, we just aren't going to put in any exhibits to these individuals, so it shouldn't be an issue.
Okay. I mean,
I understand. We understand the court's ruling.
right. Mr. Cook.
Thank you. I really don't have, I guess I do have dogs, I just want. Region 10 folks, but I just want to make sure that I have not really shoot on my testimony.
I'm sorry to interrupt, Your Honor, but I can't hear.
Oh, there's no mic for you, Mr. Cook. We need to pass that down. I'm sorry. We only have one table mic over there. And have a seat. He's going to pick you up much better if you're seated than if you're standing.
All right.
So
Thank
not only will I not take umbrage if you speak while seated, I actually am strongly encouraging you to do that.
All right, thank you. I just am so used to standing up in front of the court,
It-
so
I
it's
get
a
it.
habit.
It's fine.
What I was saying, Your Honor, is I just want to make sure that I have an opportunity to present, obviously, the testimony that's critical to the CMHs in this mix somewhere.
Of course.
And I know that things are fluid and nobody can really guarantee. But I have boiled down my witnesses, I think, from 6. I told the court last week I had 6 witnesses. I think I can do it with 3 witnesses.
Okay. Well,
So I'm prepared at any time to call those witnesses.
right. And what I said, and this is an accommodation to a concern Mr. Ryan raised that I think is valid, that originally it was going to be 135 minutes per side.
Yes.
I bumped the collective plaintiffs up to 270. So you each in theory have 135 minutes. Now, I don't care how you choose to allocate them between yourselves. But I'm sure Mr. Ryan and Mr. Cook, you can figure out how you want to do this, but you now have 270 minutes among all of your clients to present whatever you want.
Yeah, understood. And, I was gonna, if the court's ruling is to take these depositions, then it might make sense to see how far we get today with the testimony before we decide whether to not hold court on Tuesday afternoon. I mean, there's 5 lawyers on our side. The state has 5 lawyers. We could continue proceedings and taking testimony while somebody takes the deposition of Mr. Becker and Mr. Haberman.
That's fine.
Yeah.
What, maybe we make that decision at the end of the day, see how
Sure.
far we get.
Look, I am trying my best to be as flexible as I possibly can, and I will do whatever it takes to get us across the finish line in the next few days, because once that's done, I need to sit down and write an opinion as fast as I can get it out. My goal is to get it out after the weekend, because I'm quite sure I won't be locked out of my computer next weekend, nor will I be locked out of the building. So you can rest assured I will be spending next weekend almost entirely working on this opinion and another one that needs to go out in another emergency case. Okay?
Yeah, no, understood. I was just suggesting that might solve. a
Sure,
little bit
that's
of
fine.
time
That's great.
constraints too. Yeah.
All right. All right, Mr. Beach, I take it this is all acceptable to you. It looks like we're gonna try to do the best we can to finesse this any way we have to, but they're gonna get an opportunity to depose each one of these two witnesses. Fair?
Fair, Your Honor.
Thank you. And I apologize profusely for not.
There's a lot of attorneys involved in this
I
case,
know.
Your Honor.
I'm trying. Thank you. Okay, now I think we've arrived at the point then where I will memorialize my ruling on this. And I think, Vicky, we may need to get an order out today on this, but give me the name again, please, of the Hope Network person. I'm sorry, and spell it for the court reporter.
Timothy Becker, Becker.
Becker in the usual way, just like the Kent County prosecutor, right?
Yes.
All right, and then it's James, if we want to be formal about it, and Haveman, correct?
Correct.
And I think he's the former director, right?
Correct.
Yeah, we all know who he is. We can't figure out how to pronounce his last name, but we all know who he is, right? So we will get that out. What it will indicate is that Mr. Becker's deposition will take place tomorrow afternoon, beginning at 1:30.
Sure.
1:30 Tuesday. And then Mr. Haveman, 9 o'clock Wednesday. Okay, that's okay with everybody?
I think that works, Your Honor.
Yep, somebody will have a court reporter, I'm sure.
We will do that, making
Yeah.
sure my paralegal does, yes.
Okay, that's fine. Yeah, we can't press Mr. Trudell into service. He'll be busy with what's happening in the court. Okay, that order will go out probably over the lunch break today, so you can give it to everybody. Please tell me we're not gonna have subpoena problems with these two witnesses.
Are we gonna do those depositions at the Grand Rapids courthouse? That makes
I
it easy.
think that works, do them at the Grand Rapids Courthouse.
I'm happy to host it, like, we have plenty of conference rooms.
Well, we also have conference rooms in the same building.
Yeah, they're in the
I think that we
building.
can get in the same building, and I know
We'll
that
find
Mr.
a room, but
Haveman
plan
is
on
gonna
it
be
at
there
the-
at 9,
at the court.
so
Right.
we just have him go upstairs.
Right, at this point, I mean, you can use some of our space on the third floor. We have a huge conference room and there are about 6 of us on the floor.
In the hallway if we had to.
Okay, great. We'll make that work. Thank you very much.
Is
Oh.
there a specific time for Wednesday, or are we just?
I said 9 o'clock.
Oh, I'm sorry. I didn't-
Sorry, that's okay. 9 o'clock. Okay. Now, why don't we do this? Why don't we set the table by Ms. Service or Mr. Beach or anybody else from your side? You have lots of attorneys over there. If you'd like to make some opening comments, I'm bearing in mind that we have 2 motions before the court still. The first one is a motion for summary disposition by your side, and they've made a similar request under 2.116I2. And then we also have this preliminary injunction matter, although I think I've shown my cards on that. I can't imagine I'm going to issue a preliminary injunction against state officials. In the service, as I told you, I've never had noncompliance by anybody at MDHHS, and I'm going to continue to believe that's true unless I'm persuaded otherwise by events on the ground. Okay? So why don't I let you go first then, because you're the moving party under C8 and C10. If you don't want to say anything, if you want to move right to witnesses, that's fine with me.
I think before I jump into that, I heard Mr. Ryan ask about sequestration of witnesses.
Mhm.
So I believe that there's a live stream going on, and I know there's a lot of folks here in the gallery. I guess we would appreciate direction one way or the other from the court on how that's supposed to look, whether witnesses can listen to this part, but not the witness testimony of other witnesses, or if they should not be watching the live stream or present in the courtroom at all.
What I would say about that, I guess, is that I'd rather have blanket sequestration so that nobody hears the opening comments, nobody watches the live stream. Obviously, nobody's sitting in the courtroom if they may testify. Now, on your side, that's pretty simple because you only have 3 witnesses, and I think it's pretty easy to make sure those 3 people are not listening in. I expect you're more concerned about sequestration on the other side.
I actually think from both sides, because I know there's a lot of
Oh, right,
people
right. I
from the
mean-
department watching.
Right. The order will apply to everybody.
Right.
All right.
Maybe if it would help, I can just list off all of the witnesses who are either we've either told you are going to testify or might testify. So that if those individuals happen to be listening on the live stream or in the courtroom, they can excuse themselves or turn off.
Mr. Ryan, that's a great idea. Why don't you do that?
So that would be, Miss Lindsay, Mr. Mills, or Miss Mills, excuse me, Mr. Sedlock, Miss Go, Miss Postma, Miss Smith Butterwick, Miss Morningstar, Miss Coleman, Miss Parsons, Miss Sproat, Miss Terry Smith, Miss Danielle Walsh, Mr. Bill.
Dakota, I think.
It's spelled Chvojka. Miss Pamela Platt. I think Mr. Cook's witnesses were Chip Johnston, Nina Sork, Brian Babbitt. And then, do you want me to identify the maybes as well?
No.
Okay.
Oh, he's not on mic again, but that's okay. For the record, Mr. Terrell, Mr. Cook indicated that the three names mentioned by Mr. Ryan constitute the universe of likely witnesses Mr. Cook would call.
I think that's true.
Right. Miss Asman, Mr. Haveman, and Mr. Becker. There were three individuals that we had identified, Mr. Patton and Miss Van Warmer, who we do not intend to call.
Okay, that's
And then
fine.
there was a witness, Miss Kate Johnson, who we listed simply, she was the mayor call from the first hearing. She had signed in a declaration regarding the recording of Elizabeth Hertel at
Oh.
the rights conference. We listed her simply if we need to call her for authentication purposes. I have no idea whether she would be listening or not, but I'll leave it to your honor's discretion if she needs to be sequestered, given that her testimony would be for that.
I don't think she needs to be sequestered. We're gonna have that fight separately, I'm sure.
I
can't
think that's the
imagine.
universe, but maybe if Ms. Service can just confirm she doesn't have anybody else in mind that would need to be sequestered.
I agree. That's the universe of folks that if we're sequestering any witnesses, they should turn off the live stream and exit the courtroom.
Yeah, Judge.
Hold on, Mr. Cook needs to say something. We have to pass him the microphone. Sorry
Thank,
about that.
thank
Go
you,
ahead.
Honor. I take it that doesn't apply to clients though, because all
Right,
my
clients-
witnesses are
yeah,
clients.
Clients are
Yeah.
entitled to stay.
Well,
That is-
And what about
the
experts?
three that he's
Is
now gonna-
would experts be excluded under that?
No, experts can sit in.
All right, thank you.
Right, I don't know how an expert would testify without having heard the testimony. Right, fact witnesses.
So our question, Your Honor, is a definition of client. For example, Miss Lindsay is the head of Saginaw County Community Mental Health Authority. She is one of the clients here.
If she's the client representative, she can stay.
And Miss Mills is our expert witness.
Right, experts can stay. Look,
Okay,
I've never seen a situation where sequestration bars experts. As a matter of
Okay.
fact, in some trials, it's essential to have the experts present.
okay.
Mr.
So under that framework, the sequestration is applying to the state's witnesses for whichever witness is not their designated representative. Because the other witnesses that are testifying are our client representatives for specific.
Yep.
So I'm surprised to hear that Ms. Mills is being called as an expert because I don't recall seeing that on the initial disclosures or their witness list.
It was on the initial disclosures. We disclosed that we would have an expert as to that testimony, and the witness list that we disclosed expressly stated that she would have expert testimony. We stated the facts, opinions, and substance of those that per the court scheduling order. It is on our witness list.
Judge, if I could add here, we don't have a CV or a report or anything from Ms. Mills. This is the first time we're learning she's being called as an expert.
Your Honor, we discussed this at the status conference when we were negotiating the order about what the facts and opinions that we needed to disclose on the witness list. And we said, we don't want to have to go to an expert report. And Your Honor said, no, we're not dealing with expert reports. This is a sentence or
Right.
two about essentially what they're going to say.
Well,
And that's what we did.
At the very least, you have to give them a CV.
And so,
And as far as the expert report goes, what I didn't say you need a formal expert report. I said you need to give an indication of all the sorts of things that an expert will testify to.
which we did on the initial disclosures. And for the CV, Ms. Mills has had her positions at Newaygo since 1997.
Okay.
Like we stated, she's the executive director and she's going to rely on her roles as past CFO, COO, and her role as executive.
All right, do me a favor, don't call her today. Let's deal with her at some point when we have a break in the action. We'll figure out how we're gonna do that. I see how perturbed you, Mr. Beach. We're gonna get some materials in your hand that will indicate how she's gonna testify as an expert. Is she also gonna be a utility infielder in the sense she's gonna be both a fact witness and an expert witness?
She is both, Your Honor.
All right, that,
And so
yeah, that makes me a little uneasy too, but
so she's second on our lineup. It's given her knowledge and experience in analyzing finances and handling
Right.
public behavioral health financing.
I get that. Hold off on her, Joe, please.
Okay,
Okay, I mean, if they have to do a cross of an expert, I need to put some things in their hands before she takes.
I would just add, Judge, the first thing that would help would to know what the subject matter of her
course.
expertise is. I mean,
No,
that's what I would like to know.
I get it, I get it, I get it. We're not gonna hear from her today. I promise. We're gonna take that up at some
Yep.
point today. So are you gonna be the one who's gonna cross-examine?
Yes.
Okay,
and
we'll talk about this off the record first,
Okay.
see if we can work it out. Because look, Mr. Beach, I get it. It's quite different cross-examining an expert than a lay witness. And I'll make sure before we leave the building today, you have the materials you need to prepare to cross-examine her tomorrow, okay?
Thank you.
just to clarify, it's page 11 of our witness disclosure. It very clearly states she's an expert witness and she is the executive director of Newaygo. For her background since 1997 in executive, financial, and operational leadership roles, including chief financial officer, and has participated on multiple state CMH committees and state committees on financial related matters. We have a whole list of what that is.
Look, Mr. Marchand, I'm not going to try to prevent her from testifying as an expert. However, I want to give Mr. Beach an opportunity
And
to
that's
gear
fine.
up to cross an
Yep.
expert. It's a very different cross than of a lay witness.
Yes.
We can do this. Look, what I want to do is, who's going to handle the direct?
I will handle the direct for Miss Lindsay and Miss Mills.
All right, I'm going
So-
to need just a few minutes off the record with you and Mr. Beach to work out an agreement about what he's going to get before 5 o'clock today, okay? Or
Okay.
after 5, whenever,
Yeah,
before you leave the building today.
we
because-
can do that.
Right, I mean, we all know that it's quite different cross-examining an expert than a fact witness.
And I understand that, Your Honor. My question as I'm sitting here is, I don't know if there's a present CV, so I'd have to actually.
That's okay.
Okay.
The three of us can sit down and work this out.
Okay.
I'm quite confident of that. Mr. Beach, you're gonna get what you need. You're not gonna have to do
Okay.
that cross today, I promise you. Okay,
I would just ask Your Honor, I'm looking at their disclosures and I don't see the word expert used. So this is the same argument that they made against us though, and our witnesses. And so I don't know. We can talk about it, Your Honor, but maybe I'd like to depose this witness.
I mean, if we have to do it,
Yeah.
we have to do it, but
It says Ms. Mills will offer both factual testimony relating to Newaygo County mental health and opinion testimony under MRE 702. That's the rule of evidence relating to expert.
I got it. I understand. Mr. Beach, I'm not gonna put you in a difficult position. I understand that cross-examining an expert is much more of a challenge. Okay? An expert can do an awful lot that a lay witness can't do.
That's correct, Your Honor. I can do a lot.
Okay. Now, Ms. Service,
Thank you.
would you like to make some opening comments?
Yes, I would.
You
Thank
don't have
Your
to,
Honor.
but you may. And this time, would you mind coming to the lectern? Because I know we'll get a good, clean sound on that. Let me just make a note here about what we're doing next. Okay. Go ahead.
Thank you. I guess I'll put in my appearance for the record, just in case. Assistant Attorney General Stephanie Service, representing defendant State of Michigan, Michigan Department of Technology Management and Budget, and Michigan Department of Health and Human Services. With me today are my co-counsel, Assistant Attorneys General Brian Beach, Scott Damage, Tyler Kitzmiller, and we've got Assistant Attorney General Heather Seaton on the way.
You need reinforcements.
On the way, exactly, yeah, right. So appreciate the opportunity to be here today. I know this is a very important case and we really appreciate the court's flexibility and timing. The state was placed in an unenviable position in the fall of 2024 when 5 of the 10 then current PIHPs elected not to sign the version of the PIHP contract DHHS presented. So DHHS had to move fast to decide what to do. And what they decided was to move to competitive procurement and to reduce the number of regions.
And just to go back and plow some ground that we've already plowed, but to have a discussion that I think matters. The reason that you don't have a competitive procurement system is that you receive a waiver from the federal government. And there's no guarantee that the waiver would even be reinstituted. I just want to be clear about the fact that technically the state's been out of compliance for a long time, albeit with the blessing of the federal government. But to the extent that one would argue that competitive procurement is prohibited, it's quite the opposite. Competitive procurement is the rule and Michigan is operating under the exception.
I think that's fair to characterize. The other thing I would add to that is back in 2001, when the federal government approved Michigan's plan to waive competitive procurement, that approval was under old Medicaid waivers that the state was under back, 25 years ago. The state's moved to updated Medicaid waivers, new authorities, and the state's been doing it this way, for this amount of time. But it's certainly our position that we wouldn't need a waiver of a waiver to go back to the standard federal requirement.
Right. And that's the point I'm making, that to the extent that anybody would criticize MDHHS for deciding to make this transition technically brings you into formal compliance with federal requirements.
That is the standard federal requirement. I'm not necessarily going to say we've been out of compliance for 25 years.
No, of course, you've been operating with a waiver that they've given you. It's right. I'm not trying to trick you here. I'm just trying to state the obvious that the decision MDHHS has made is to come into full compliance with the federal requirements. And so you don't have to ask for a waiver every year now.
That's our position, yes.
Okay, go ahead. Sorry.
No problem. So, and the court's already ruled that, moving to the competitive procurement and reducing the number of regions conforms with the mental health code, whatever we looked at last time. So now coming forward to today, the first issue that we have to look at is whether plaintiffs' claims are even ripe at this point. So as the court indicated earlier, there's been no bids awarded, there's been no contract negotiation, no contracts signed, new contracts have not started. And so we're at this point in time where we've got current contractors filing an action without an actual injury yet at this time.
But just to be clear, I mean, they've sought declaratory relief, not monetary damages, and declaratory relief guides the party's behavior going forward so they don't run afoul of the law. I mean, I'm comfortable making these decisions. I'm not going to knock them out on a ripeness theory.
Okay, very good. I mean, just for the record, we think that if current contractors in this, state contractors were able to bring challenges at this early stage in the procurement is far from over. There's a whole process that takes place.
Right.
The state has discretion on how to run it. And so at this early stage, it could create a slippery slope. If all current contractors could file court actions to try to stop RFPs from coming forward, they get to keep their contracts while the court action goes on. And similarly, if prospective bidders.
But prospective bidders are different. They don't have standing, right?
Of course, that's our position.
Yeah, I'm
Yes.
pretty sure that if you have an existing contract and you're trying to assert continuing rights under that contract, that's one thing. If you're merely one of many trying to get a state contract, in my view, you don't have standing to challenge at that point.
And following that line of reasoning, our position is then that would kick out all of the CMHSP plaintiffs because we only have a contract with them for the general fund services, which are not at issue in this case.
I understand.
So, you know, in terms of ripeness, we do think it would be a slippery slope. And I heard what the court said. I just wanted to put on the record that we don't think that the claims are ripe at this point in time. There's been no actual injury.
But can we at least agree that standing and ripeness are both prudential doctrines? I mean, they're not jurisdictional, they're not mandatory, they're prudential, right?
I agree with that.
And they're two completely different concepts. I mean, standing, ripeness, and mootness are all of the same family, but they're not the same at all.
I agree with that. And one example would be, you know, we're saying plaintiff's claims aren't ripe. On the flip side of that, if a CMHSP or CMHSP regional entity won the bid, their claims, most of them would be totally moot.
I understand.
In terms of remedies, the plaintiffs have asked for, you know, a declaration that the whole RFP is illegal and asked for, you know, an injunction to stop the RFP in full. But we got into this a little bit the last time we were at the court hearing, which is that if the court does find that some particular term in the RFP does not conform with Michigan law, the court's remedy is to strike that term or declare that particular term, you know, in violation of Michigan law, not to stop the RFP in full. And that's because the state has discretion to run the procurement, to run the Medicaid program. So if there's a term that does not, that the court says is not illegal, then that must go through. And it would be up to the state with their discretion to determine if the RFP can survive with any terms that are stricken.
Right.
Of course, it's our position that no terms should be stricken.
I got it, but right, I understand what you're saying. If I find that something is at variance with Michigan law, all that I should do, the most I should do is just strike that provision from the RFP and let the bidding process go forward and let you pick the people, right?
Exactly. Okay. And then,
Yeah, severability except in contract, not in statutory interpretation.
yeah, I will say that the RFP does have a severability clause.
I know, I made a note of that. I get it.
And then, okay, so if we even get to the point where we're talking about whether any of the particular terms of the RFP do not conform with Michigan law, as I just said, it's our position that the court could not find that today. So initially, the thing I'll mention is that this is, and I've mentioned this in status conferences, I mean, this is really a pure legal decision. Do the four corners of the RFP conform with the four corners of most likely the mental health code? Hearing testimony from witnesses would be, you know, not adding to that legal determination. There's a lot of witnesses on both sides of this who have very strong positions, understandably. And I want to flag that for the record, that when it comes to witnesses, and especially we believe that the court's likely to hear from at least 3 witnesses, some PIHP and some CMH witnesses in the same PIHP region. You know, that would be duplicative and not really getting to the issue today, which is like the legal issues here.
I get that. I mean, at the end of the day, if I haven't made this clear yet, I want to make it clear now. I am not here to determine what good policy is. It's not the role of a judge to do that. All I have to do is determine whether the RFP now is in conformity with state law. And as you say, there's a severability clause, and so the remedy might well be sever that provision and go forward. I hear you loud and clear.
Similarly, we expect that plaintiffs will raise arguments about the process that the state used to create the RFP, whether the people drafting it talked to the right people along the way as they were drafting it. But again, those types of arguments are really irrelevant to the legal issue here, which is whether that final version of the RFP, however it came to be, conforms with Michigan law. So I wanted to flag that. And then the last thing, just kind of preliminarily before I get into the more meat and potatoes, is flagging the fact that, you know, several of plaintiffs' arguments that they've made in their briefing actually go outside of what they listed in their complaint. And that's particularly true for the Region 10 plaintiffs. Now, I understand the court's identified these issues and that's why we're here today, but I wanted to flag for the record that anything outside of the scope of their complaint we would say it should not be considered in this case.
But just to be clear, if I grant summary disposition because of the absence of that, whether under C8 or C10, then I have to give them an opportunity to amend under 2.116I5 unless it'd be futile. And if I find that there's merit to the argument, it's hard for me to say it would be futile. I mean, I'm trying to do this as quickly as I can, which means that we're essentially going to have to do that all at one time. If I think that the complaint is inadequate and so C8 relief is appropriate, but there's a theory that can prevail, I'm just going to go ahead and allow that to go forward under I5. Fair?
Understood. Just want to make a record.
I got it. I got it.
So now to the meat and potatoes of this fight, which is, it seems that both sides are approaching the intersection between the mental health code and the Medicaid managed care system very differently. So the state is looking at it like they are two completely separate frameworks. And they have to be two completely separate frameworks because the mental health code and its provisions existed long before Medicaid managed care came to the
Yep.
scene.
Agreed.
We have to assume that when the legislature enacted 400.109F, which is the statute creating PIHPs essentially, that the legislature did not intend the provision in 109F that says PIHPs shall manage services. We have to assume that that didn't intend to be a conflict with the mental health code provisions that talked about CMHs providing those services. So there's a real easy way to harmonize that, which is that 109F, 400.109F says that PIHPs shall manage the services. It also says deliver, but I'll get to that in a second. And that CMHSPs under MCL 330.11162B, which has been cited a lot in the briefing, and 330.1206, that CMHSPs are the deliverer of services. So when it comes to Medicaid managed care, their role is to deliver the services and the PIHPs manage the services.
Right. As I understand it, they're the front line of this provision process and the PIHPs are the management aspect of it.
So statutorily, the CMHSPs, their role is to deliver the services. What has been happening over the course of the last 2 decades is PIHPs have delegated much of the management functions down to the CMHSPs, which means the CMHSPs are essentially managing themselves, managing their provider networks. And then the PIHPs, they do have an important role in terms of flowing funding, but the management piece has been given down to the CMH.
So what's your view of how PIHPs are functioning now? Are they just basically pass-through entities where the money flows through, the Medicaid funds flow through down to the CMHSPs, but not only the frontline work, but the management work's being done there?
Generally, in most cases, the management work is being done by the CMHSPs across the state.
When you say management, are you talking about maintaining the network of providers and all of that? Or are you talking about something more than that?
Correct. It's like what we called in our brief, the administrative functions,
Right.
maintaining
Yeah.
the contracts, the payers, the oversight, reporting, kind of the administration. And the reason it's really important to separate out that kind of payer role of the PIHPs and the provider role of the CMHSPs is so we're not in a situation where the CMHSPs are managing themselves and setting their own rates and, doing things like that. It's important to separate that so that's statutory functions.
Is that why the RFP makes it look like there's going to be more imposed on the PIHPs going forward?
Correct. That's exactly right.
All right. So in other words, the system, in your view, is a bit out of kilter because too much management's being done by the CMHSPs and you're trying to restore that responsibility to the PIHPs.
Absolutely. We think that's also in line with what the statutes intend, given the timing of when those statutes were enacted. It seems that the plaintiffs are looking at this a little bit differently, where they're saying, there are two concentric circles and there's just a few places on the outside that don't quite line up. But other than that, you can stack Medicaid on top. But for the reasons that I just said, we don't think that you can do that because we have to look at the timing of when these statutes came to be. And we have to look at the fact that under Medicaid, those requirements are all set by federal Medicaid managed care requirements. It's a completely different framework. And if they were one and the same, that could cause a problem for state funding and things like that, because under Medicaid managed care requirements, the state cannot delegate administration or policymaking or things of that nature, you know, on down to providers, you know, 2-3 levels downstream. Like the state has to maintain control, and that's what the state is doing under both its federal Medicaid managed care statutory authority and then its state statutory authority to manage, to have PIHPs manage. And under MCL 330.1116, DHHS is given, we went through this statute last time, like significant power to administer the Medicaid program, administer mental health program in Michigan. So with all of those, I think you have to look at it as two separate frameworks and not a concentric circle. Doing the concentric circle is like fitting a square peg into a round hole, and you just can't do it. It definitely is the case that some of, actually a lot of the services CMHSPs provide end up being Medicaid funded. But just because that is the case doesn't mean that the statutes say it has to be that way. We're trying to restore that pure statutory function. And CMHSPs still have a very important role. First of all, the RFP requires the PIHPs to contract with CMHSPs. That's required part of the RFP. So Medicaid funds will still be flowing for beneficiaries who receive CMHSP services, which we anticipate will be most beneficiaries because the CMHSPs are currently set up to do that.
Well, I think one of the concerns they raised, though, is that the way the RFP is structured, the PIHPs could actually go out and set up their own contractor provider networks. Now, I'm not saying that that would make a lot of sense, but they could do that. And then all the Medicaid funds would flow to the provider network that they set up, cutting the CMHSPs out of the process. Now, I know you say that the PIHPs have to contract with the CMHSPs, but is it saying too much to say that the PIHPs under the RFP could, in fact, if they wanted, set up all their own providers in a separate network, operating independent of CMHSPs?
The RFP does allow and in fact require the Medicaid managed care provider contract management to be handled by the PIHPs. So funding contracts with providers who happen to provide Medicaid services would route through the PIHP. That said, right now under the current system, so the state pays the PIHPs, who pay the CMHSPs, who provide some services in-house, and then the CMHSPs flow that money down to their own providers. And so in our view, it really shouldn't be much different. If the money is flowing all the way down to the downstream providers who are actually providing the service, then this is a similar situation. The CMHSPs would keep the money for, you know, their own administration as long as it's within the bounds of other requirements, but then also the services that they directly provide.
Just to be clear, though, then the PIHPs would directly be paying providers. The money wouldn't go through the CMHSPs to the extent that providers are providing services rather than the CMHSPs themselves providing services.
That's correct.
Okay, I got it.
I think that was all I had for my opening statement.
That's great. Thank you very much. That helps a lot.
Thank you.
Mr. Marchand,
Morning, Your Honor.
and today you look like you're ready for a statement.
Yeah, no longer, you know, castaway there. My wife did appreciate it, though. So,
And just to be clear, you are primarily here on behalf of the PIHPs, although you have CMHSPs as party plaintiffs as well.
my direct clients are the CMHSPs, Your Honor.
Okay.
Mr. Ryan and Ms. Wixon, represent the PIHP.
Oh, okay.
Clients that, on that. May I approach? We have
Yes,
them
of
on
course.
for this.
Absolutely. Thank you. And just remember, you're not on mic when you're approaching, so go ahead back to the lectern and then you can pick it up again. Thank you.
So we have to take the state at its word. And the state has consistently said that these managed care functions are a core feature of the RFP. That includes the splitting between payer and provider responsibilities, and it includes what Ms. Service just acknowledged as the money not flowing through the CMH for contracted Medicaid services not performed by the
Right.
CMH.
I suspect that you would readily concede that the CMHSPs provide some services themselves. So in some senses, they operate as providers,
Correct.
but they also maintain this network of providers who provide services for fees, and that money is typically gone through the CMHSPs down to the providers.
Correct.
And so I think the way Ms. Service described it is a lot of those funds would flow independent of the CMHSPs under the new system.
Correct. And that's the heart of the financing
Right,
issue.
yes.
Of how it's implemented, because administrative costs, any CMHSP has basic administrative costs to run an agency. They have to have a recipient rights officer. You need to have HR functions. You need to have an executive director, and so those administrative costs are spread over all of the funding streams. And so when Medicaid is 95% of funding for a CMHSP, and general fund is the rest, general fund meaning money from the state. There's not enough through the general fund contract alone. When you take out that Medicaid money, there's not enough general fund for the CMH to perform all of its statutory obligations. Now, even if you say, well, they're still direct providing some Medicaid services, let's take out the Medicaid services for which they contract. Under that scenario, there's still not enough money left to cover the administrative costs. And so rural CMHs in particular can't function, can't set up an agency. They don't have enough money left. Other CMHs that are not in a rural area where they might have a more affluent county, those CMHs, they could perform some, but not all of their statutory functions. And so that's the heart of the financing issue. It can't be contracted around because the money, this is a core feature MDHHS has said under the RFP.
Right, because as I understand it, the CMHSPs are supposed to serve as one-stop shopping, basically.
Correct.
You come in, they have, for all practical purposes, a concierge.
Yes.
Who takes you, talks to you about all the various services, pairs you up with providers, either part of the CMHSP itself or outside providers who have contracts. And if we starve the CMHSPs, the effect will be there'll be no concierge service. People will essentially have to just go it alone.
Correct. So take it from the
Recipients,
example
when I
of
say
a
people.
recipient coming in for services. They are at their time of greatest need. The CMH is the one, it's the county level safety net that's there to say, we'll take care of you. We'll worry how we pay for this later. You need the help. What happens then is that a claim can only be billed once. And so someone needs it. You might, at the time of presentation, the CMH may not even know their name. It's that this is a human being who needs help. And so the whole point of an integrated funding model through managed care is that the CMHs manage all of these funds at that level so that you need the service, we will get you the service, and we'll pay for it in the least, and we'll take care of the payment.
Right,
And you
we might
never
do-
see the payment
Right.
side of it.
We might do it in-house, we might send you to somebody, but the point is you don't have to worry about that.
Correct.
You, the recipient.
You, the recipient, don't have to worry about that. And so when you extract and bottleneck those Medicaid funds for the provider network at upstream, one, all of those services can't be provided, but more so from the recipient standpoint, how does the CMH Medicaid is often retroactive. It can be retroactive up to 90 days later. Right now, it's going to be shortened. So when you come in for services, you may be Medicaid eligible, but we may never know your name. So we're guaranteeing payment of the claim regardless of your ability to pay so that you get the help that you need. But then it turns out under the RFP, if they're a Medicaid person, someone who's a Medicaid eligible individual and they have Medicaid coverage, we just violated the RFP because we can't contract for the delivery of Medicaid services. And so this is the core structural feature of the RFP. I would agree with you on severability as it relates to something like the where found model under the RFP. That relates to county of financial responsibility. The county's not financially, the PIHP that has that financial responsibility is derivative of where the county is. So which one of these mega regions?
All right, so
So-
I think where you're going is that this is such a core aspect of the RFP that if it's defective in the way that Medicaid funds flow and it starves the CMHSPs, the RFP can't stand.
Correct. Because that's that is one of their core features that they said, this is the architecture of it, it's not changing. No amount of contracts can, paper over that problem. And so with that, then you get into MDHHS kind of suggesting, well, we can do different bidders to address these problems. And that's where the piece of paper, the demonstrative that I shared with you, comes into play. Because under all bidders, you have nonprofits, you have public entities, which there are CMHs and regional entities, but you could have there's different public entities from that. Or you can have universities. Under that, we have issues not just with the funding, but we have issues on planning, linking, and coordinating and follow-up. Because if the CMH cannot contract for the delivery of service elsewhere, that prohibits them from fully being able to serve the individual regardless of their ability to pay, which is their statutory obligation. And then you have the issue of SUD's functions. SUD, there's a defined term under the code. I believe it's 330.1100A24, it might be 23. But it's Department Designated Community Mental Health Entity. And that is a CMH and one of its organizational structures, an agency, organization, et cetera, authority, or a regional entity. Now, that defined term, the RFP requires all bidders, regardless of who they are, to comply with all terms of Chapter 2A of the Mental Health Code. That's in Section 10B of the services. And the department has said SUD is one of their core services for the provision of public behavioral health services. So when you have that, and the only entities that can comply with Chapter 2A are these department designated community mental health entities, that knocks out every nonprofit, every public university, and every public governmental entity other than a CMH or regional entity. And so in theory, the RFP could still continue if those were the bidders, because those are the only bidders that could comply with 10B. But then even under that framework, we get back to the very core managed care functions that the department has designated under the RFP. And that is the split between payer and provider and the prohibition on contractor, behavioral health services. Because while a regional entity under 1204B can stand in the shoes of the CMH and has all the rights, powers, and privileges and authorities of the CMH, if it then becomes a super CMH for the mega region, it then violates the payer-provider split, which is the other core feature. So we have an unworkable RFP. And we have that unworkable RFP because the department, we can go into the why. The department wants the why, but I think it's, I would agree that why the department chose to competitively bid out the PIHPs, because the department admitted in sworn testimony on behalf of the department that they're underfunding the medically necessary Medicaid services. And so they were upset that the PIHPs tried to negotiate a reserve to actually do that.
Right, look, I understand that there's some history, some bad blood between the PIHPs and the MDHHS. I get that. But to some degree, I can't really think about that, can I? Because structurally, if they can reduce from 10 to 3 and they can go to a competitive bidding system, there's really, unless I want to somehow decide that I'm no longer a judge and I'm running the MDHHS, I don't know how I can stop that from happening.
And I'd agree. And I think that goes exactly to the relevance of Mr. Becker and Mr. Hoffman's testimony. you know, if we can't go into the why and that's not an issue here, then,
Right.
you know, why?
Right, right. I mean, right, even if it's purely retaliatory that they're doing this, it doesn't seem to me that that gives me a justification to stop it. So long as it conforms to Michigan law.
I don't know that answer from the standpoint of the retaliation. Just, I don't, like, I just haven't looked into if we proved retaliation, is that a violation, is that a separate violation of law?
Right,
I
right.
just don't know that part.
Right, but the problem then is that at most you'd have a claim for money damages for the duration of the contract, not
Right.
anything else. I mean, nobody has a right to have a continuing contractual relationship if it's done on an annual basis, right?
And I'd agree, contracts are negotiated,
Right.
yes.
Okay.
So, but my point is that there is not a way to fix the RFP based on what the
I got it.
court, yeah.
Right, and
Yeah.
that's why I'm glad that so many people are here speaking up for the CMHSPs, because it seems to me that they are imperiled by this system.
Yes,
Now, maybe impermissibly, maybe permissibly, but there's no question in my mind that the CMHSP's very existence may be put at risk.
correct. And there's nothing in the RFP that requires these new PIHPs to cover the CMH's administrative costs
Right.
that were otherwise spread over Medicaid. And we have from DTMB's contracting officer that the contract itself must mirror the RFP. The terms don't change for the new PIHPs that get a contract. It's what we're looking at here. And there's no requirement of all of these other administrative costs, which means the CMHSPs don't have an ability to perform all of their statutory functions. This opening part was intended as questions from the court as well. I'm happy to address any specific question that you.
No, I think that you and Ms. Service have done a really good job of framing the problem. The question is whether the fact that I'm concerned that it varies from what state law allows comes down to whether I strike a portion of the RFP, none of the RFP, or the whole thing. And Ms. Service is right, there's a severability clause in there. And so my first duty is, if I find something incompatible with Michigan law, to see if it can be severed. But I understand your
Right.
argument. And it's a powerful argument that if you have something that's so core to the functioning of CMHSPs, can the RFP stand at all?
Right. And going to 109F, the state likes to gloss over that the 109F says manage and deliver specialty prepaid, like these Medicaid services. And that's exactly what happened for years after 109F was enacted. We had a hub and spoke model where a CMH served the dual role of both providing the services and contracting for them and being the PIHP for themselves and potentially others.
Right.
Even today, we have PIHPs, 3 of them, Detroit, Macomb, and Oakland County.
Right.
The PIHPs in those counties are also the CMHs.
Right, I mean, as I understand it, the ability of CMHSPs to form these PIHPs was for administrative convenience, but it was always believed that the CMHSPs were essential to the operation of this entire system.
I would make one correction to that statement. The CMHSPs could always form the regional entity. And the PIHP is a separate kind of function.
Okay. I see what you're saying.
And so,
got
but
it.
I do agree
Yep.
with you
Yep.
that under
Right.
1116 2B, the state has the obligation to shift, not just the they want to say, well, it's the delivery of mental health services, and so that's just provider. No, under 1116, the CMHs have the duty to establish a comprehensive array of services and to have an adequate and appropriate system. You don't have a system if you can't contract or if you can't manage all aspects of the delivery of something. And so for years, we have had a managed care system where CMHs that has functioned. There's not been a conflict with federal regulations on what a PIHP can do. This is manufactured by a policy change from the department. If the department wants to make that policy change, that requires a legislative change. That's not But a policy change must be consistent with the existing law. And the existing law allows for the management and the delivery to be at the same point.
I understand.
Okay. Would you, nothing else? Then let's not waste
I'm
your
all
time.
set. No, no. Hey, look, this has been extraordinarily educational. I really appreciate the opening comments. They've been very, very helpful.
Thank you, Your Honor.
Okay, thank you, Mr. Marchand. Now, I don't know who wants to speak next. Mr. Cook, are you coming up next?
I'll just say brief.
You got to come up to a mic again. The same problem. Please come up to the lectern. I really want to make sure on arguments, we get a good, clean record. Sorry. It's hard to get into the game if you can't figure out how to get out of the dugout, right?
Good morning, Your Honor.
Good morning, Mr. Cook.
Chris Cook appearing on behalf of what I'll call the Central Wellness Plaintiffs or the CMH plaintiffs. And with me in court today, I have some representatives of some of our Northern Michigan community health organizations. Ms. Nina Sork from Northeast Michigan Community Health Authority. They have a geographical territory of Alcona, Alpena, Montmorency, and Presque Isle. Chip Johnson, Joseph Chip Johnston, Manistee Benzie area. Central Wellness is the facility. Mr. Brian Babbitt from North Country Community Mental Health, Sheboygan, Emmett, Charlevoix, Otsego, Antrim, and Kalkaska. And Trish Atremba from Wellvance, Ogama, Iosco, and Escoda. And Tess Greenhouse probably listening in on our live feed from Gogebic because that's in a different time zone.
Gogebic? I think from Detroit, you could get to Florida faster than you get to
I
Gogebic.
think so. I think so.
Judge, just as a point of order, I thought we were sequestering witnesses. Mr. Cook just identified all his witnesses as seated in the front row.
The clients.
Oh, I see. They're
clients.
client representatives. Okay.
So we can have Ms. Asman sit in court?
Sure. Yeah, if somebody's identified as a client representative, that's fine.
Okay.
Yep. Yeah, nothing I can do about that. You get one client representative.
Can we just clarify, is she in DHHS's fact witness? Because it seems like you have client representative, because it seems like you have a different client representative here.
I think we have,
You get one client representative.
excuse me.
Designators or client rep?
Yeah, we'll designate Ms. Osmond as our client representative.
That's fine. All right, now, Mr. Cook, I'm especially glad you're here because as I look at the legislative structure of all this, there's a fair bit of flexibility in the way that MDHHS structures the PIHP relationship. But I don't think that there's a lot of flexibility in terms of the way MDHHS structures the relationship with the CMHSPs.
That's true.
To me, the role of the CMHSPs is pretty clearly defined by statute, and it can neither be expanded nor contracted.
Extensively
Right,
described.
right, without running afoul of state law.
Oh, yes. And yeah, I agree 100%, Your Honor. I think that the mental health code, they developed the mental health code back in 1974
Yep.
with all of these strictures associated with what community mental health service programs have to do, shall maintain.
Right.
And it's a full network of services to satisfy the needs of the beneficiary. And my witnesses will testify to the court that should this RFP be put into place, it will essentially destroy their ability to follow the mandatory provisions of the mental health code in many ways.
For lack of funding or because the PIHPs have been assigned responsibilities that would no longer be assigned to the CMHSPs?
Both, because.
That's what I
yes,
was concerned about, but I wanted to
yes,
hear.
absolutely, because without the ability to contract with providers, how is it ever possible for them to provide a full array of mental health services to the needs, to the most vulnerable in the population, according to their needs? They simply can't do it. And I think Mr. Marchand had touched on some of the details associated with those problems, and my witnesses will talk about them as well. But things, for instance, like recipient rights, how could you ever call in a provider who has a contract with the PIHP, but you have a recipient rights violation internal to the CMH and you're under a statutory obligation to investigate that? How do you haul in Dr. A? and say, you have to come in here. Now, the only way to do that is if I have a contract that they've agreed to where we spell that out in their contract.
Right.
And there's,
As a third-party beneficiary, it's not gonna do you any good.
Exactly right.
For all practical purposes, you have no enforceable rights except if you want to bring a lawsuit.
Exactly right. And there's a series of statutes, I won't belabor the point, but we'll talk about them during the course of our presentation, that talk about the mandatory obligations of community mental health organizations to do a whole variety of things when it comes to provision of services. And those things will be taken away from the CMH, and there's no way that we'll be able to provide any of those services that are required in the statute. The other part of our problem is the lack of the Medicaid funding will decimate our organizations. Most of these organizations, 90 to 95% of the funds that they work with are Medicaid funds. They have a little bit of general fund money.
Right, but it's a small fraction.
It's a small fraction, and these places will be decimated. Even if they're allowed to survive, they'll be a very minimalist organization that won't be able to comply with the requirements of the statute.
And I presume what happens then is a recipient has to go to one of these super PIHPs and hope to get some help.
Oh, yes. And what if?
But it's not going to be local in any way.
It's not going to be local, and it's going to be, it sounds like it's going to be a fee for service situation when it comes down to the CMH level, because the PIHPs are going to retain the funds, the capitated funds, and they don't have to flow those down at all to the CMHs who ironically enough are the ones who develop the budget that brings down the capitated payments. They're the ones who have to look at the Medicaid lives in their area and format a budget. And finally, and I won't belabor this because we've got a couple long days, but I found it interesting to listen to the state's presentation because there's this discussion about this conflict between the payor and the provider. That seems to be one of the big issues here in their position. But I haven't heard a harm. I haven't heard it's causing what to happen. It's causing the beneficiaries not to receive services. That's what we're here about. We're here about the beneficiaries, whether or not they're receiving appropriate services. I haven't heard that. All I have heard is that there's this potential conflict in this payor provider role, and they're managing themselves. Where's been one example of where they're managing themselves in a way that is a pecuniary benefit to somebody in this organization? These are all people who are dedicated social workers that wouldn't be in this situation if they had some sort of profit motive, because you can't make money working for one of these organizations. And then even if you had, sorry, you can't. But even if you did have some money in reserve at the end, you're obligated under the law to return those funds. So those funds that are excess have to be returned back to the state.
But
So-
you are able to retain for administrative expenses.
For some.
Funding that you need to set up, just the organization. I'm not saying there's anything wrong with that,
No.
but I mean, some of the Medicaid funding winds up supporting administrative
That's true.
expenses for the CMHSPs.
That's true. There's a med loss ratio, and our med loss ratio for some of our,
Yeah.
my clients is about 3%.
I get it.
Under
right? I
the
mean, I'm not
RFP?
saying anybody's getting
Yeah.
rich off.
Oh, no, but just to follow up on what you said, Your Honor, under the RFP, the successful bidder is allowed to retain 15% med loss ratio. So here's the other kind of practical problem that we can't figure out is if we went to this kind of a system, although the PIHPs under the RFP have an obligation to contract with the CMHs don't have an obligation to contract with them. And so why would we take a Medicaid recipient where we know right off the bat we're going to lose money because 15% of the funds that would normally come through for benefits is now being retained for administrative purposes? That would-
At the PIHP
at
level.
the PIHP level. So that's just one of the little nuggets of problems that we spot. So I think, and our goal, Your Honor, is not to expand the record beyond what is necessary, but to talk about these issues as we go.
Okay,
Thank you.
thank you, Mr. Cook. All right, what I'd like to do now, I was thinking about just running this straight through to 12 so we could stay on schedule, but it's not fair to anybody. Let's take 10 minutes and we'll come back. I promise you, now that we have 3 days for this, I'm not going to short anybody on time. But I'm going to try to be humane about it. When I first started in the circuit court, I would just go till I needed a bathroom break, and I realized I was punishing people unnecessarily. So we'll be back at 1:45. Thank you, Mr. Trudeau.
Thank you.
Gonna need. Maybe you can recall.
Okay, if we could come to order, that'd be helpful. I need to get Mr. Trudell
Taking
on.
this.
Ah, there we are.
I'm gonna take her down.
Okay.
He wants to take her down, we're taking.
All right.
Oh.
Have a seat. Make yourselves comfortable. I don't care about people standing for me. Mr. Cook, but before we go on the record, Mr. Trudell saved this, okay?
Yeah.
We don't need to record this. You now have somebody you may want to call as an expert too? They just told me that.
No.
Oh, okay. Okay. All right, good.
So
So,
that's solved.
right, the problem is what we thought the problem was, and it's no greater than that.
Okay, all right.
Okay, all right, let's go back on the record and I'll say something about this now. Okay, Mr. Trudell, tell me when you're ready.
All set.
We're back on the record. We're a couple minutes delayed, but for a very good reason, and I'm glad we were able to do that. Mr. Marchand and Mr. Beach wanted to talk to me about the one witness who's going to be called as an expert as well as a fact witness. The agreement we've reached is that there will be a deposition of that person tomorrow, and then that person won't testify until Wednesday. The reason I called upon Mr. Cook was outside your presence, Mr. Cook, there was some suggestion you might be wanting to call somebody as an expert, but now you've told me that you don't want to do that. So the problem is limited to one person. We'll take care of that deposition tomorrow as well. And then, Mr. Beach, you won't have to cross-examine until Wednesday. I know we've now started to fill the third day, and that's fine. I just want to remind everybody that I am completely out of pocket on Thursday and Friday, so we have to finish by Wednesday. I haven't talked to the court security chief in Grand Rapids, and I don't want to impress upon him the need to go late into the night on Wednesday just to get done. So let's do the best we can and see if we can finish by 5 o'clock that day. You all have my undivided attention today, tomorrow, and Wednesday, and I'll be reading in the evenings. As a matter of fact, my commissioner is running off all the documents that I need that I wasn't able to get over the weekend. And so you can rest assured, I know you'll be working late into the night tonight. If it's any comfort, I will be too. Okay, we'll get this done, I promise. Now, I think what we agreed is that the plaintiffs would call witnesses today. And as I said, it doesn't matter to me the order in which you call them. The only thing that I would ask is if we have witnesses with geographic problems, we try to get the Detroit and Lansing witnesses on and off the stand today if we can, leaving as many Grand Rapids witnesses and as few Lansing and Detroit witnesses for Tuesday and Wednesday as possible. So with that in mind, either Mr. Marchand or Mr. Cook or anybody else sitting at table, would you like to call a witness?
Yes, Your Honor, we'd like to call Sandra Lindsay, please.
Very well. Please come on up.
And am I understanding the courtroom correctly? We're
Yeah.
using that spot right now?
Yes, she's sitting right there. There is no true witness box because you're in a court of appeals courtroom, not a trial courtroom. So you're gonna have to go around the back there to get to the spot, and I'm sorry about that.
That's okay, I can jump over.
You have everyone's exhibits up there
Thank
with you to
Yep, I do.
give you comfort to see.
I didn't have enough to read. All right, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please. Make yourselves comfortable. If you didn't pick that up, Mr. Trudell, she did say, I do. And before we get started, please tell us your first and last names and spell your first and last names for the court reporter.
My name is Sandra Lindsay. First name is Sandra. Last name is Lindsey. And I am the Chief Executive Officer at the Mental Health Authority in Saginaw County.
Thank you very much, Ms. Lindsay. And whenever you're ready, Mr. Marchand, you may proceed. And by the way, for the attorneys, you may either question from the lectern here or seated at table. I don't want anybody to feel the need to stand up. If you'd prefer to be at table with their table microphone, that's fine, as long as Mr. Trudell can hear you. Now, Mr. Marchand, you may proceed.
Thank you, Your Honor. I think logistically this still makes sense for me.
Yeah, I'm sorry, you can't turn that lectern.
Yeah,
That's the only
yeah.
problem.
Ms. Lindsay, what is Saginaw County Community Mental Health's role in the community?
Well, it's our statutory responsibility to assess the needs for public behavioral health services for persons living inside Saginaw County. and to provide an array of services that meet that community demand in whatever configuration and capacity may be required.
And do you know how the mental health services Saginaw CMHA provides are paid for?
Yeah, 95% of our budget is Medicaid. If I looked at the unaudited 2025 financials, which are under audit right now, the total budget was about 130,000. And 124 is Medicaid. So obviously 95% of its overwhelming revenue source is Medicaid.
And I thought you said, I might have misheard. Did you say 1,000?
A million, I'm sorry.
Okay.
Oh, I misspoke, gosh.
Yeah. So 130 million is
Oh.
your approximate
Yeah,
budget.
oh, that was a fatal sin. Okay, yeah,
Yeah, and then 124 million is
Correct.
funded.
That's the lady.
correct.
uh,
Well, I can say it again. Our
Everything.
budget is about approximately 130 million. And of that, 95% is Medicaid, which is 124 plus million dollars.
Okay. And how much of the Medicaid funding you receive do you then contract out for the delivery of that Medicaid service?
I think the value of just paid claims for our network, which is very large, is $72 million.
17 or
72 million.
72. Thank you.
Do you have so what's the other 6 million in funding? Where are those funding streams?
Staff, our staff. Things we operate directly. So we have about.
Oh, I'm sorry.
sorry.
I think you said you had $130 million budget and 124 is covered by Medicaid.
Mhm.
What is the other 6 million of your budget?
Oh, of the revenue?
Right.
About 1.6 million in general fund. There are grants in that arrangement. There is a county match in that arrangement. I know I'm leaving something out. Oh, there would be commercial insurance paid claims from coordination of benefits, either because recipients of service were either solely commercially insured or had commercial insurance, but Medicaid was a second payer and Medicaid is always a last payer. So it would have been those commercial paid claims that would be non-Medicaid.
And does Saginaw's CMHA's your administrative costs, do they exceed that the 1.6 million in general funds you receive?
Oh, yeah. Oh, yeah.
And so I want to talk about, you say revenue. I want to ask, does Saginaw CMHA make a profit?
No, not at all.
What does it mean to be a public CMH as it relates to holding money? As like any excess?
Oh, okay.
Yeah.
Just gonna object to the form of the question. Confusing, it's kind of compound, kind of clarify exactly what you're asking.
I'll tell you what, once you try it again.
All right. So, what happens if money is not spent? Where does it go?
Let's start with Medicaid, I guess.
Yeah.
That's the big pot of money. If we do not spend all of our Medicaid annually, ultimately it goes back to the department, but first it goes back to our regional PIHP. The regional PIHP will take a look at all of the unspent funds in the region, and they will then decide if it is allowable, depending on where their financial situation is, that some money might be retained in savings, some money might be able to supplement an internal service fund, or it might be money that is needed by other CMH affiliates in the region.
Mhm.
But after all of that, anything that's left over goes back to the state of Michigan.
Okay. So I want to talk about payer and provider functions.
Okay?
From a big picture perspective, can you tell me what they are?
Can you say it one more time?
Payer and provider
okay.
functions,
Okay.
what are they, just like high level?
Okay. Well, provider functions are the direct delivery of service.
Okay,
Not to be confused with payer functions, which is the payment to anyone delivering service, any organization or individual delivering service, usually through a claims process.
okay. Under the system as it is right now, who holds those functions?
Well, right now at Saginaw, we hold those functions. The payer responsibilities are delegated for the services that are delivered by Saginaw CMH, its staff and its network. And other managed care functions are as well.
Have you reviewed the state's request for proposal that's at issue in this litigation?
I have.
And what is your understanding of how the request for proposal treats those payer and provider functions?
Well, very differently than what's allowed now. I mean, I think they've made it very clear in their RFP. They expect the new regional PIHPs to be the payers of all claims, meaning that CMH would no longer be allowed to be a payer of contracted providers using Medicaid money. So that was the payer side. What was the other part of the question?
The provider, under the RFP, what's your understanding of Saginaw CMHA's ability to contract with other providers
Oh,
for the
okay.
delivery of a Medicaid service?
Okay. Well, presently, the RFP indicates that we cannot hold contracts. That suggests, and it doesn't suggest, I mean, the RFP, I think, is pretty clear that contracts will be held at the regional PIHP level and that CMHs will be providers alone inside the Medicaid program.
Does the RFP separation of those payer and provider functions impact the way Saginaw CMHA can fulfill its statutory obligations to provide mental health services in Saginaw County?
I think it does.
And how?
Well, I think the reason that since 2014 and even before that, I think the reason that many CMHs, can only speak for myself, but we really wanted the value of choice to be predominant in our community. So even though we've always provided services ourselves, I think we have about 20 different programs, but we have about 90 different contracts right now for services, different types of services, all of which are part of the Medicaid benefit. We consider that network, it's a very closely held network. And I say that only because of my familiarity with networks on the physical healthcare side, right? And that's because so much of the service benefit in the Medicaid world for the people that we serve with significant disabilities is very intertwined. And so we consider the management of the network as well as our board operated programs as the comprehensive way we deliver that service array under our statutory responsibility, certainly to Medicaid beneficiaries primary because it's such a dominant piece of our business, but for anyone else, anyone who may have other insurances or maybe between Medicaid eligibility, that we wouldn't want to interrupt the episode of care, which can be, unlike healthcare, not episodic, but pretty consistent over months and often years and sometimes a lifetime. So we think it's really important to have our arms, historically, to have our arms around the entire network. Our network uses the same EHR. So that means the authorities of the board at CMH can really see in real time what's going on with everyone and what their needs are and how those needs are changing. Holding the provider contracts are important to us too, because although we start with a base contract upon negotiations with different kinds of service providers, the needs of our consumers are fluid. And so sometimes those contracts, probably more than sometimes, often, depending on the service type, contracts need to be amended, sometimes to attend to the specific need of a consumer in a setting. For example, we might need to pay for enhanced staffing, which is different. So someone who might be living in a 6-bed licensed specialized residential setting might be having a very difficult time, maybe having medication adjustment problems, but in any case, maybe posing some difficulty for their management in the setting. And we may need to amend the contract so that there's additional staffing for the provider so that we can provide a remedy for the circumstance of that consumer in that setting and for their housemates, just as an example.
Yeah, so I wanted, you mentioned specialized residential services. What are they?
Specialized residential services, I think the term of art, most people in our business would say, refers to a congregate living situation, a licensed adult foster care setting that uses the specialized Medicaid billing code called community living supports. That's the service that pays for the staff in the home. But honestly, CLS can also be provided to people in their own home or in a family's home for a
Yeah.
disabled family member. But I would think most people, the term of art tends to refer to a congregate living situation.
Okay, and do you know whether Saginaw CMHA has an obligation to establish and administer a specialized residential program?
Yeah, I mean, I think that's pretty foundational to the identity of CMHs. All of us have specialized residential programs, either under contract or I guess in some cases provided directly by the CMH. It was foundational to sort of the birth and growth of the community mental health system.
And are those specialized residential services, are any component of that service, is that paid through Medicaid?
Yes, yes, the Medicaid does not pay for room and board. Okay, so for example, consumers either pay or they are entitlements, and a piece of their entitlement, it might be SSI or SSD, goes to pay for the room and board in the setting. But the actual staffing or the intervention, the supervision, the assistance that's provided by CLS staff in that setting is a Medicaid billable service.
Okay, and you contract for that service now, correct?
Yes, correct.
Okay, can your payer and provider functions for specialized residential services be separated?
Well, I guess that's what we're here to decide, but I mean, I think the RFP suggests that, yes, that's true.
Okay,
I'm going to object. This is calling for a legal opinion.
which attorney's handling this witness? Because Mr. Damage objected before, and so,
I'm gonna object that it asks for a legal opinion.
okay.
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 I'll tell you what, back it up and just talk about
Right.
the practical aspect of it.
Okay.
I'll sustain the objection.
All right, from a practical perspective, in Saginaw County, who has the obligation to establish and administer a specialized residential service?
Same
mean-
objection.
In your experience.
Community mental health. Saginaw
I'm
CMH in
not
my
talking,
case.
Mr. Beach, I'm not talking about from a or Mr. Damage, I'm not talking about from a legal perspective. I'm talking about on the ground, practical, based upon your experience.
Based
Go
on-
ahead.
Thank you, Your Honor.
And based on your experience, is part of establishing and administering a specialized residential service program, does that include both payer and provider functions?
Yes.
Okay, and can Saginaw CMHA, in your experience, can those payer and provider functions be separated in your administration of a specialized residential services program?
We do not separate them.
Okay,
From a practical point of view, these are the places where people live.
Mhm.
We feel the need to be a payer because we not only need to make contract adjustments, as I've already testified to, but other things happen, right? Natural disasters, those places lose power. The ability to act in real time as the payer is really important because if people can't live in that setting, even temporarily, they have to be moved. And if they have to be moved, it's usually, I don't know, most people have empty foster care homes around. They're all full. So if people have to be moved, they are moved to a hotel or a motel with their staff while whatever remedy happens to either restore power or create remedies to damages done by consumers that somehow makes the dwelling uninhabitable. I mean, you may think this is a rare occurrence, but it's not. And not only that, because Medicaid doesn't pay for room and board, when you move those people to a motel, then you have to figure out how you're going to pay for that because you're not using Medicaid, right? So you're going to be using general fund. If people have available entitlements, and they probably won't, the CMH is going to carry that. It's going to provide that safety net for those people in that circumstance. And that's just a single example of the nuance, perhaps, of providing specialized residential to the complexity of the disabilities that our customers experience.
And are there other reasons why payer and provider functions, in your experience, cannot be separated for specialized residential services?
Well, I think for the adequacy of the network, I think that's really important. So I believe I testified a few moments ago that spoke to really providing a service array that has the capacity and configuration to meet the needs of the community, in this case of Medicaid beneficiaries living in Saginaw County. And that's important to us. That planning piece is important to us. And that also includes being mindful of the training of the staff in the network, being the translators of public policy and regulation from the department. This is a complex, deep and wide benefit that we provide. There are changes often in how the benefit needs to be administered. That information comes to PIHPs, but it comes directly to CMHs as well. And it really becomes our responsibility to help providers who are impacted by whatever those changes or nuances may be, make the adjustments to be compliant with the provision of the service under whatever change the regulation or statute represents, or policy, could be any of those things on that continuum. So we fancy ourselves having been empowered as a public agency to really be that translator for the network, and to coach that network and support that network to be successful in carrying out the delivery of the service as the department directs. Because the last thing we want to have happen has people stumble down the road and have their claims of service invalidated because they weren't provided in the right way or to the specifications of the department. This is a very important piece of network management, is this interpretive piece, because the department doesn't speak to service providers. They speak to the public agencies, and we in fact translate for them and support them.
Now, earlier you testified about the electronic health record. In your experience as a practical matter, who uses Saginaw CMHA's electronic health record?
Everybody in our network.
Okay, and so
every organization in our network and their staff, to be more clear.
Yeah, so what happens if someone's not in your network because you can't contract with them for the delivery of a Medicaid service?
I think there are exceptions, and I can talk about those. So most of the services in our network are delivered inside the boundaries of Saginaw County.
Yep.
But we do purchase single case agreements from specialized residential providers that are outside of Saginaw. They may not be users of our electronic health record, but they could be. But because they're only serving a single client, that may be a burden to ask of them. So they may be downloading records into our system, or our staff, our case holders, may be working with that setting on behalf of that single client to connect them to the record, bringing documents and putting them in.
So I want to talk about your administrative cost. What if the department just requires a non-CMH provider to just use your electronic health record?
Well, who would pay that cost?
And so with that, how does the impact of losing the Medicaid funding that flows through Saginaw for the network providers that you have, how does that impact Saginaw CMHA?
Well, it's quite detrimental because the fund sources that would remain would need to bear the responsibility of the spread of administrative costs, right, as they existed in a much reduced circumstance.
Okay.
Much reduced in terms of funding.
Right. Now, does the Impact of, does the RFP's prohibition on Saginaw CMHA being able to contract with another provider to deliver Medicaid services impact an individual's recipient rights at all?
I'm gonna object to foundation.
Yeah, why don't you try to lay some, I
right.
think you can have that, but.
Okay,
Just
so-
get her to explain how she would know that.
Yeah. So do you know what recipient rights are?
Yes.
Okay, what are they?
They're statutory provided rights to the beneficiaries of the public mental health system. I don't know, I'm trying to remember what chapter it is in the mental health code, but it has a whole chapter dedicated to the protection of rights, sort of foundational. I mean, it's been around for a long time, even through the major amendments to the mental health code. But it is a series of requirements about the treatment and care and service to beneficiaries that really has the sole responsibility of protecting their personal rights and liberties. Every CMH has a recipient rights officer at least. Larger CMHs have multiple staff that report to that officer. Their responsibilities are to educate the network. And then when I say network, in my case, I also mean our own programs, to educate really upon hire almost what those rights are and how they have to be protected. And how, if you as a staff member inside our network see someone whose rights appear to have been infringed upon, it is your obligation to file a complaint. And you do that by contacting the recipient rights office at Saginaw CMH in our main building, either walking in or in person.
And does the recipient rights office at Saginaw CMH report directly to you?
It does.
Okay. Do you know whether they have the ability to require anything of your network providers?
They do. Upon investigation of a rights complaint, which has a very specific time frame in which it must be completed, there oftentimes is a substantiation of the complaint, and the report is issued with a demand for remedy.
Okay.
The demand for remedy can take different forms. It might be training, might be disciplinary action, depending on the severity of the finding. I don't know how we would have any leverage over providers for those remedies or those responses and the timeliness for participating in investigations if we weren't holding the contract with the provider.
Well, what happens if the state requires providers to set up their own recipient rights office or just contract with you for that service?
I'm gonna go ahead and put an objection to this question and previous questions are calling for a narrative response that is, we're getting hearsay statements, hearsayable statements in response here. So I'm gonna go ahead and put an objection for the call of a narrative response.
I'll rephrase. How would, in your experience, how would a network provider just having to set up their own recipient rights system, how would that be different for a consumer's experience of recipient rights as you deliver them now?
I'm going to object to the ability that she's able to testify on behalf of consumers' experiences. The consumers could speak on their own about their experiences.
Well, I'm not sure that that's what the question's getting at. I think what the question's getting at is whether CMHSAs can be effective in policing recipient rights if it doesn't have contractual relationships with the providers.
Thank you.
Right.
Okay, why don't
So-
you answer that question? I'm sorry, I didn't mean to recast your question, but I
I'm
think that's
happy,
what you're trying to
you
get
know,
at.
I'm happy to adopt your question. Can you answer the question the court presented?
Do you want me to ask it again?
Sure.
All right. If you do not, if a CMHSA does not have a contract with providers, is it possible, or how would you police recipient rights in the manner in which services are provided to recipients by providers with whom you have no contractual relationship?
I can't imagine how that would happen.
Now, I'd like to talk about probate court orders for a second. and
Okay.
What I will call civil admissions. Does Saginaw CMHA have to contract with anyone as part of the civil admissions process?
yes, in terms of determinations in pre-admission screening of persons that might require inpatient care. And so a contract would be required to be able to facilitate the admission.
And with whom do you contract?
We contract with 28 local hospitals across the state of Michigan. We do that because historically in recent years there have been bed shortages. Just to be really clear, I don't want to throw a lot of shade on local hospitals, but a lot of that's about staffing. It's not about that there aren't beds. It's about that there's not enough staff for those beds.
Okay.
So there have been some recent, issues in recent years post-COVID, but we contract with those hospitals also because people who have been found in pre-screening to need an involuntary order, or even a voluntary admission for that matter, not every hospital will do. We contract with lots of different hospitals because in addition to the psychiatric presentation that may require an inpatient stay, the people that we serve also have other comorbid health conditions. So things that are barriers are like, well, what if the person's also pregnant? What if they're on a PICC line? What if they require oxygen? What if they're part of a dialysis regimen? All right. So our selection of hospitals is to find the closest hospital if that's possible, so families can have access. That's not always possible, but we try our best to do that, but to be mindful of the entire presentation of the person. So holding those hospital contracts helps facilitate that. The other thing about the civil admission process, if I am understanding, I'll stop talking if I'm not getting
Let me
it.
ask.
Okay.
So do Medicaid beneficiaries go through the civil admission process?
Oh, yes, every day.
Okay, and when Saginaw CMHA contracts for services with these hospitals, what are those services?
They're largely two parts. I think the primary service that most of us purchase is inpatient psychiatric care.
Okay,
Okay, so this would be a patient who is entering oftentimes a med-surg hospital with a psychiatric unit, and in some cases, freestanding psychiatric hospitals.
okay. Does Medicaid pay, in your experience, does Medicaid pay for any portion of someone's inpatient psychiatric care?
Yes, I feel like I also missed the last part of your first question.
Oh, okay.
I wasn't done.
I'm sorry, I didn't mean
Okay.
to interrupt.
That's okay, but is that okay? Did I go ahead? Okay, so the second service that might be purchased might be partial hospital day.
Okay,
So in other words, the patient would go to the hospital with some intensity during the week, but wouldn't stay overnight. So
Okay.
it's not like inpatient, but it might be partial day. So not all hospitals offer that service, but they are offered among the 28 contracts that we have. Okay.
okay. And does Medicaid pay any portion in your experience of these services?
Yeah.
Okay. And so when someone presents to you and to go into your pre-admission screening unit, in your experience, do you always know at that point in time whether the person is a Medicaid beneficiary or not?
Not always.
Okay, so if Saginaw CMHA cannot contract for the delivery of those inpatient services or intensive outpatient care with Medicaid dollars, can you fulfill, what's your sense of your ability to fulfill your civil admissions obligations?
They would be challenged. When someone comes into pre-admission screening, we have the capacity to do Medicaid lookup. But that's not the end of the story because people may have multiple insurances and Medicaid is always the last payer. So they might, for example, have Medicare primary, Medicaid secondary. All right, we need to sort of ascertain that because the Medicare is going to pay for the inpatient stay. All right, so we need to figure that out. Or it might be a veteran who has status that would mean that he would likely need to be transferred to Battle Creek for an inpatient stay. Now, he may have Medicaid secondary, but we think it would be in the best interest to do that. So all of these combinations of insurance, I guess is my point,
Okay.
could be commercial insurance, right? I think it also depends if we're talking about adults or kids.
Okay. Tell me about kids. How is that different?
Well, kids who present for pre-admission screening, we can engage in that process with them. Up to, let's see, I think they have to be 14 years of age. But parents and guardians or guardians still have to sign off to approve the admission. Because for kids, there's no involuntary process. Everything is voluntary, right? Now, on its face, that may seem simple, but a lot of time is spent by CMH pre-screeners all across the state trying to figure out where the parents are. Sometimes parents bring them in and that's clear. Sometimes there's a guardian. Sometimes a child was visiting grandma in one county, but the parents are in another county and the child is acutely ill, right? So we spend a lot of time in the kids area finding parents, not because they're lost, but because we need them. We need them to sign for admissions. I think when kids are in foster care, the situation is, as you can imagine, also complicated because the foster parent may not have the authority to sign off on the admission. And the same thing would be true for kids who are living in child care institutions, some of whom are state wards. And then we need the department who acts as the parent, right, to be able to sign for the admission. All of this is time consuming.
Mhm.
Holding the hospital contract is important because unless you can guarantee payment for Medicaid, you're not getting admission. So these people are at the pre-screening site and those are in different locations depending on, you know, which CMH you're talking about. But in our case, we are at the Covenant ER, which is a level 4 trauma center in the city of Saginaw. And we are there. And those people that are coming for pre-admission screening who have been determined either to agree voluntarily or through a petitioning process involuntarily be admitted, we are seeking the bed, the appropriate bed for that person to receive their next level of care. But we have to be able to, and if we're not holding the contract and we're not the payer, we are not going to be able to say to the admitting hospital, this is a Medicaid patient and we're guaranteeing payment.
Can I ask you a question?
Yes.
If somebody shows up for pre-admission screening and they may be a candidate for involuntary commitment, who makes that decision about involuntary commitment? Is that you or is that, do you have to refer them out to a provider?
No, it's us. It's us. There's a certification process. So the first cert, okay, is done by CMH. All right. It's probably done in the emergency department. All right. And then that court order has a shelf life of 72 hours.
Yeah, very familiar with
Okay.
those.
All right. Well,
Yep.
I'm sure you are.
Yes, part
Okay.
of my life for a while.
Okay. Right. And then within 24 hours of admission, the second cert.
Right, yep,
Has
you
to
have
be
to get,
done.
right.
Right.
Yep. But in other words, you're serving a screening function. Somebody
Yes.
shows up for pre-admission screening
Yes.
and you're making a determination whether they're a legitimate candidate for involuntary commitment.
Yes.
And then, of course, you put the wheels in motion and they have to see a psychiatrist or a psychologist, and then they have
Yeah.
to see a psychiatrist on
Yeah.
the back end.
Second
within 24
cert,
hours.
right?
Yep,
Then
got it,
hearing in
right.
7 days.
Yep, right.
Right.
Okay, I got
But we
it.
may also be diverting. We may also be looking at the circumstance and saying, we really don't think your circumstance warrants an inpatient stay. And we, by the way, have all these other benefits downstream, and we're going to help divert you into an appropriate level of care that's not inpatient.
So is your role to some degree triage then?
Yes. Oh, yeah.
Okay, thank you. That's all I wanted to know. Thank you. Sorry, Mr.
No, rather answer your questions than mine. So, now that screening function, are you familiar with the phrase utilization management?
Yes.
Can you tell me what it is and it's whether that it has an authorization component is where I'm going?
Your Honor, I'm going to make an objection. Could we answer those questions in one at a time instead of a compound
Okay.
question and then a narrative response?
That's fair. Why don't you just explain to us what utilization management is, and then we'll go from there once you answer that question.
Okay. Utilization management is the managed care function that determines the level of care and the array of services that may be needed with a guarantee of payment and service authorization for payment. It's going to be directed at individual patients and their needs, but there's also a utilization management component that is about the grander need, right? The capacity of the service array to meet the needs of people who are eligible for the service. I think in our case, because Medicaid is a complicated world and it has several different kinds of authorities, Medicaid waivers or other authorities, it's also helping to parse out appropriate eligibility for certain sets of services. But there is a service authorization that really says, yes, these are the appropriate services in this configuration for this particular patient. And yes, we agree to pay.
You talked about the amount of work it takes sometimes for a child to get the authorization or the parent sign off. Is that a billable expense for you?
No, no. There is a billing code for pre-admission screening.
Right.
The problem is, if you're waiting for a bed because beds aren't available, or you're waiting for parents to sign and people are boarding in the ED, you've already made your decision. You need to make a decision about an inpatient admission within 3 hours. So you're mobilizing all of those resources, and that's really a pre-admission screening event. But now the decision has been made, right? Inpatient stay is needed. Now we start the work of the chase of the authorizer, of the parent, of the appropriate bed, right? With the person on the other end at the hospital admission saying, who's paying?
Given your experience, how do you feel about the RFP's impact on civil admissions?
I'm concerned. I'm very concerned. I'm concerned not because, an outside party couldn't do the authorization. For me, a lot of it is about when. When is the authorization going to come? That is about very busy emergency rooms. In my case, the last level 4 hospital from Saginaw north of the entire state. So you're talking about a hospital partner. And I only mention it, what do you care about the hospital? These are partners to our work on the ground in the community, just like law enforcement is a partner. But the timing of the payment, the guarantee of payment is important because you can't move people out. So you've got, gurneys stacked 2 in the hallway. If there were a serious accident or, I hate to say it, gang violence, multiple shootings. It's a very busy environment. And so moving behavioral health patients, which are potentially disruptive in an emergency department, forward onto the appropriate level of care as quickly as possible is important. So if this happens on a Friday and it's a holiday weekend, I just need to know that if I'm not going to be guaranteeing payment, somebody else is going to guarantee payment, and I'm not going to hear about it on Tuesday morning.
And if you don't hold the payer function, can you move the individual to
No.
their best setting?
No,
Okay.
not if they're Medicaid. If they're commercial, because hospitals have other relationships with payers, right? So
Right.
I don't think they see the risk as quite the same.
In your experience, does Saginaw CMHA have a planning, linking, coordinating, follow-up function?
Oh, yeah.
And if you're not able to contract with other providers to deliver Medicaid behavioral health services, will that have any impact on that function?
I have to think it would.
What would be the impact as it relates to coordination of care?
Well, if we just stay in the hospital world, utilization management, you asked me the definition of that. Utilization management happens in hospitals too, because decisions have to be made about what is the appropriate length of the hospital stay. In other words, is the patient continuing to benefit from the milieu of an inpatient setting? All right. Because if they're not, if they've maximized the benefit of that inpatient stay, they should be moved to a different level of care. Okay. So in the level of care determination, you would want to be able to meet with the hospital staff, which we do, oftentimes virtually, sometimes not, sometimes in person. But we go over case reviews and we talk about the benefit of that stay, right? And then we talk about from the time that they are admitted, what the discharge plan is going to look like. All right? So the coordination and the linkage and the brokerage just in the inpatient stay discharge plan is multifaceted. So CMH will really be directing through our utilization management staff, like, how's the patient going to get home? A lot of our consumers don't drive. There's no public transportation in the hospital. How's the psychiatric prescription? Because there might have been med adjustments during the inpatient stay, and that was the whole point of the stay. How are the prescriptions going to be filled upon discharge, right?
Well, you gave.
How
two-
and who is going to get this patient to their first outpatient psychiatric appointment? Because if we don't get that right, the chance of readmission is really high.
Okay, and if you're not able to contract for the provision of the Medicaid services, how does that inability impact those examples?
Well, if I imagine that my providers aren't being paid by me anymore, but perhaps they're under contract to the this new PIHP, I would hope that the PIHP would teach them or direct them how to do this work. This is not the work that they do. When people go into, from our network, when people go into the hospital, most of the contact with the hospital staff with regard to the patient is done through the utilization management process. We will keep the provider, case holder, right, therapist, whatever, we will keep that person informed, and we will do it through our electronic health record for the most part, right? Because we'll do notes in the record so they will know. But if they're not our providers, I guess there will be a steady stream of different providers that will be informing the new PIHP. It's hard for me to imagine the efficiency of that in an inpatient psychiatric hospital interface.
I'd like to talk about managed care functions for a second. Was Saginaw CMHA part of the 298 pilot?
Check the foundation.
Yeah, why don't you ask about what the 298
Yeah,
pilot
okay.
is to start with? Because I have to admit, I'm jumping in somewhere in the middle of this too.
All right, do you know what the 298 pilot was?
Yes, I do.
Can you tell me what it was?
Yeah, it was an opportunity directed by the department following a legislative mandate by a specific senator in our state. I don't think it matters who, but it really was an opportunity, a set of expectations about coming together with 4 CEOs from CMHs and Medicaid health plans to learn about each other's system. And my sense of it, I was one of those 4, to be really clear. And it really was about the feasibility of closer working relationships. I think what the department was hoping for was that there would be a meeting of the minds. I think sincerely their goal, the department's goal, not the legislation, but I think the department's goal, I
Well,
take it on its
hold on a
face.
second. So, how, you testified you were part of the 298
Yes.
pilot. How were the managed care functions for behavioral health treated under that pilot?
In the educational process between Medicaid health plans and CMHs, we explained the carve out. We explained our statutory responsibilities as CMHs under the mental health code. We talked about our payer function. This was, I think, new information. This is just my perspective. I can't speak to what other people thought or understood, but I think it was, I felt my time was well spent.
But tell me, under the current managed care program, when you're running Saginaw, in your experience, how flexible are the managed care functions that you have?
I'm gonna object, that's leading.
Tell me about your experience.
Wait, hold on.
Yeah,
I'll overrule that objection.
all right.
I don't think that was leading. Go ahead.
Thanks, Your Honor.
Yep, that's fine.
Could you say it one more time?
Under the current system, when you're running Saginaw CMHA, How flexible in your experience are the managed care functions?
Significantly flexible.
Okay. Compare that to your experience with 298, Senator Shirkey's pilot.
Could object to the foundation.
Compare it to your experience in the 298 pilot.
Right, you're right,
Thank you.
right. It doesn't matter whose initiative it was. I got it.
My experience was that it was, very different than managed care functions and utilization management in this case, as what your question is about, from the Medicaid health plans. They were in a quandary, but they wanted to learn more. And so we kept trying to explain.
So your experience from the 298 pilot compared to the managed care functions as they're set in the RFP, how similar or dissimilar are those?
Very similar, if not identical. Meaning that CMHs cannot hold service contracts with other providers, and cannot perform managed care functions, which is pretty much what the discussion was, at 298.
You've read the RFP, right?
Leading.
Have you read the RFP?
Yes,
And have you read the deposition testimonies from the state employees?
not all of them.
How many? Can you give me a couple examples?
I read Miss Morningstar's, I read, Raimi Possuma's,
Okay. Are you familiar with how Saginaw handles its financing? Financial matters? You testified to your
Oh, yeah.
budget, things like
Yes,
that.
yeah.
Based on all that knowledge, is there any way Saginaw CMHA can fulfill all of its statutory obligations under the RFP's framework? Thank you, Ms. Lindsay.
Okay, for the record, since I'm keeping time on everything, we started at 10:50 and it's now, oh, you have to stay for cross-examination.
cross-examination.
Sorry, I always forget about that part. How
And
about that?
it's now 11:41, and that means that we used up 51. And now it's time for cross-examination.
Thank you, Your Honor. All right, good morning, Ms. Lindsay.
Good morning.
Let me get started. You testified earlier this morning that 95% of your funding comes from Medicaid.
Yes,
Then why did you state in your brief that you filed for last week that only 61% of your funding comes from Medicaid?
I probably was in error. I talked to my finance officer and looked at what the revenue was for 25 and what was the expense of, the network. What was the number that was in the debt?
61% in your brief filed by your attorneys.
Okay.
And it cites to your own financials that say only 61% of your funding comes from Medicaid. That's what you stated to the court in your brief.
That would not be correct. I would tell you it's not correct. It feels like the number,
That's what
It
it
is
says in
the
your
amount-
financials, though.
from the discovery documents?
Yeah, wait, yeah, that's a good point. I think the court reporter is having trouble.
Okay.
Because you're away
Oh,
from the
I'm
microphone.
moving away.
Right, right. If you want, you can use the table mic and actually take it out and
Oh.
hold it.
That would actually be easier.
Okay.
Right,
Your own financials that you provided as an exhibit that you provided,
Okay, from the
they
audit.
say 61% of your funding comes from Medicaid.
That is not correct.
Okay,
That's not correct.
so your own financials are wrong?
No,
Is that
but
what you're testifying today?
I don't know what the source document was.
Hold on, there's an objection pending. Basis for the objection.
One, there's ask and answer. Two, he's being argumentative with the witness. Three, like, he hasn't shown her what she's asking. I don't know what you're referring to here. And so if he's going to ask a question, just show the part of the brief he's asking about.
Well, let's put it this way. He can certainly impeach without showing her something. Typically, you show somebody something to refresh their recollection, but if you want to do that, you certainly may.
All right.
You don't have to, though.
All right, I will show
But
her very
you,
quickly.
please stay on mic.
Okay.
That's the awkwardness of the way
awkwardness
courtroom's
of
set up.
Court of
Sorry about
Appeals.
that.
All right. I'm going to show you, ma'am, this is your brief that you filed, page 5.
What? I didn't file this brief.
It was filed by your attorney.
Oh, okay, okay.
Okay, and it's citing to your financials and it says that 61% of your funding comes from Medicaid.
All right, well, that's not, I don't think that's correct.
So your attorneys don't know how much of your funding comes from Medicaid?
Well, I don't,
Objection, Your Honor.
Right, I'll sustain that. Go ahead, just ask another question, that's fine.
And you're aware that your attorneys also, well, I guess I'll ask, did you read the brief before it was filed at all?
no,
So would it surprise you to know that St. Clair County gets 60, or St. Clair Community Health gets 65% of their funding from Medicaid?
Objection, Foundation.
Right,
Do you know how much funding St. Clair County gets from Medicaid?
no.
Would it surprise you to hear that they all get around 65%?
I don't have a, I don't have a construct for it. Because we don't really talk that way about, until this proceeding, we don't really discuss percentage to budget.
I guess I'm just confused. Do you have any documentation supporting that 95% of your funding comes from Medicaid? Where are you getting that number from?
Yeah, I'm getting it from my CFO.
Is that the
And were
same?
those, what was the year on that?
For 2024?
Oh, okay. That could have been true for 2024.
Okay.
I was talking about 2025 and you say, well, what is that big difference? At least some of that difference is going to be related to a special program for CCBHC.
And just so we're clear today, you're not an attorney, right?
No, sir.
And you worked for Saginaw CMHA? And that's part of Mid-State PIHP?
Correct.
How much are you paid a year?
$253,000 a year, I think.
So you
Might be a
can
little
make
bit
money
more.
in the system.
Objection, Your Honor.
well,
Well, making money at a reasonable salary is not a profit, sir.
Are you
Is that the
aware,
point? I mean, I'm trying to understand the question.
are you aware that your salary exceeds the cap of every state and federal employee that work in the Medicaid system?
No, I wasn't aware of that.
Are you more important than all the state and federal employees that work in the system?
I have no,
Objection,
I have no idea how to respond.
yeah,
to
hold
that
on, hold
question.
on. Yeah, I'll sustain that. Look, you certainly made your point.
Okay.
I get it.
All right. And based on your testimony, it sounds like you have a personal financial interest in the outcome of this litigation, right?
No, I don't have a personal interest. I have a professional interest.
Okay, but you also have a personal interest because you want to stay employed, making $250,000 a year.
Sir, I would have retired a year ago if we weren't in the middle of this PIHP change.
We could ask the gallery to please.
Right, yeah.
We know it's overwhelmingly plaintiffs.
No, I understand that. I mean, look, I appreciate their natural human reactions. I'm not looking to hold anybody in contempt, but for one thing, it makes it harder for the court reporter if there are substantial reactions from the gallery. So I'm not chastising anybody, just please. Thank you. Go ahead, Mr. Beach.
Is it fair to say that you want the status quo to stay in place?
Something similar to the status quo would be my preference, yes.
And just so we're clear on a couple more things, you're not involved in the DTM, or I'm sorry, the DTMB procurement process, right?
No,
And you're aware that's a fluid process?
yes,
And you're aware that there may be any number of changes to the terms of the RFP prior to any contract negotiation?
I've been told that that's possible, yes.
And you're also aware that there will be, at the time that bids are awarded, that there will be contract negotiations and there could be more changes that end up in the contracts, right?
Okay, I mean, I don't know that for a fact, but I don't know that it's not true.
Well, it's probably unfair to ask because you don't really know anything about the actual procurement process, right?
Right, I'm not a participant, right? Mhm.
And as you sit here today, you don't know who the winning bidders are going to be.
No,
It's certain, or I'm sorry, strike that. It's certainly possible that the winning bidders could be CMHSP or CMHSP regional entities like, just like Midstate, right?
I have no idea who bid. I have no idea what their status is or who they are.
But it's possible that a PIHP regional entity, just like Midstate, as long as it fit the geographic boundaries, could be an entity that submits a winning bid.
Objection foundation.
Right, if she knows, do you know?
I don't know.
Okay.
But-
It's fine.
And you don't know how many PIHPs are going to exist for each region, right?
Correct.
It's certainly possible that there could be multiple PIHPs in each region, correct?
I have heard that.
And if one was, say, a private entity, it's possible that the other one could be made up of CMHSP regional entities and basically have the same system in place, correct?
Did you say that one more time?
Foundation.
Right. If you know, you can answer. If you don't know, just say you don't know.
I don't know.
And just so we're clear, you have not seen what any contracts look like in terms of the
Only
new
what was in the
PIHPs.
RFP.
Have you read the entire RFP?
I would say, no. I'd have to say no to that because I did not read every word of the RFP.
It's true, the RFP only shifts managed care functions to the PIHPs, correct?
I'm sorry?
It's true that the RFP only shifts managed care functions to the PIHPs, correct?
Correct, yes.
Foundation.
She answered the question.
Oh,
As if she,
yeah,
as
I
if she
got it out
knows.
late.
Right,
Okay, I
yeah,
didn't know if
that's
you-
okay.
And you would also agree that CMHSPs can still perform their statutory mandated direct care functions and delivery of services without managing Medicaid dollars.
I don't know.
Well, we walk through here. The CMHSPs can still service individuals with planning and linking and coordinating, right?
To a limited extent and within the context of services and level of care considerations that are not being managed by the PIHP,
But they can still do those things, correct?
they can perform those functions sometimes, yeah.
And they can still contract with other entities, correct?
Not for service delivery.
But you contract right now
Yes.
in Saginaw County with police departments for crisis intervention services, right?
No, we do not contract with police departments. We have partners with police departments.
Do you contract with cities for crisis intervention services?
No, we do crisis intervention services ourselves. And no one else in the network does it. And that's pretty much the case at every CMH.
And under the RFP, the CMHSPs would still receive general fund dollars, right?
Would receive general fund dollars?
Correct.
General fund dollars have nothing to do with the PIP. Are you suggesting that the department would still pay CMH's general fund dollars?
No, I'm asking the CMHSPs would still receive general fund dollars.
Yes. Oh, in other words, no difference than now. than
Right.
Presently. Okay.
Right, so you'd still get those
I
general
was
fund dollars.
misunderstanding your question.
Yep. And under the RFP, the new PIHPs must contract with the CMHSPs, correct?
Yeah.
So Medicaid funding would still flow to the CMHSPs, correct?
Some Medicaid would, yeah.
And it is possible for the CMHSPs to broaden number of services they offer. And in that way, get more Medicaid funding, correct?
What do you mean by broaden?
Offer more services.
Oh, directly, you mean?
Yes.
Yes.
And the CMHSPs could bill for those services just like Any other Medicaid provider, correct?
Yeah.
So I want to talk a little more about your sources of revenue. What are your sources? Currently, your sources of revenue?
Well, Medicaid is predominant. There would be, commercial insurance billing, Medicare billing, state general fund. We receive non-Medicaid services from the state to deliver OBRA PASSAR services. We receive grant funds from grants issued by the state of Michigan sometimes, or other sources. We have are administering permanent supported housing grants under HUD. That gives you a flavor for it, I think.
And how do you currently account for administrative expenses?
Well, actually, it's a pretty prescribed standard cost allocation strategy that was developed to inform the actuary. I'm not a finance person myself, but I know that my CFO is using the templates provided by the department and or the actuary. I'm not sure where the authority is. I assume it's the department, but we're doing standard cost allocation. So standard cost allocation is looking at all the events of service and determining, what is the cost of delivering that service. And then certain kinds of administrative services are then allowed to be spread across operations.
Is it fair to say that general fund dollars are to provide for CMHSP responsibilities under the mental health code?
Yeah, in the broadest sense. I mean, I think, yeah, it is the broadest sense. It would be for the 10% cost of state hospital care and things like that. It would be for spend down to try to get people Medicaid eligible, but because they have a deductible at the front end of every month, unless there is an expense, getting people Medicaid eligible may require some attention to spend down. It may be for uninsured person. So not a lot of money, and it has to do a lot of things.
And that's actually the next point I was going to make. That's a limited pot of money, correct?
Oh, absolutely, sure.
And you have managed care functions that go above and beyond your statutory obligations under the mental health code, correct?
Foundation.
I don't understand that question.
Do you have any managed care functions that go above and beyond your statutory obligations under the mental health code?
Yes,
And you receive Medicaid subcapitation to provide those services that have been delegated to you by the PIHPs, correct? And you also need staff and resources to provide those services, correct?
yes,
And it's true that general fund dollars are not sufficient for you to have staff to pay for those managed care functions, correct?
oh, yeah. Nowhere near.
So to be able to perform the Medicaid managed care functions, you need to use the Medicaid subcapitation that you receive to support the operation of those functions, correct?
Yes,
And you're aware of the MDHHS standard cost allocation model?
yes,
And administrative expenses are to be reported separate from the cost of service, correct?
yeah,
You're also aware that per CMS guidance, MDHHS policy in both the PIHP and CMHSP general fund contract with MDHHS, the managed care functions are to be reported as administrative expenses, correct?
Compound.
I don't
think,
know.
I think I'm going to overrule that objection. I don't think it was
It's not-
compound. I don't pretend to
I thought there
fully.
were two different components
Right,
in
right,
there.
right. I was trying to piece it together in my head. Let's see if she can answer.
It's a little long, but it's not compound, Your Honor. So I'll ask it again. You're aware that per CMS guidance, MDHHS policy in both the PIHP and CMHSP general fund contract with MDHHS, managed care functions are to be reported as an administrative expense.
I'm gonna
Correct.
say foundation on this one, because he hasn't talked about CMS guidance before.
But let's see if she can answer the
I
question.
don't know.
Okay,
So
don't
make
know.
it
she
easy.
can't answer the question.
I-
so-
I- I don't
I had
know.
a feeling that might happen.
That wouldn't
Okay,
surprise me,
now-
but I don't know.
Now, if you want to try that again, Mr. Beach, to see if you can set it up, that's fine.
All right, that's fine, Ron, I'll move on. She doesn't know. And CMHSPs, they report total expenses, including cost of functioning, in the EQI as a cost of service, correct?
Correct, yes.
And the network providers report that bill and get paid for the services that they provide, correct?
I'm sorry, I didn't understand your question.
And the network providers,
Uh-huh.
they also report that bill or, strike that. The network providers bill and get paid for those services, correct?
They submit claims and we pay claims, yes.
What is your understanding of what the EQI is?
I have no idea. I mean, I wouldn't want to articulate that. I know the report, but I'm certainly not able to explain the elements of the report.
But what is your understanding of what it is?
It's a financial report.
And it's submitted to MDHHS, correct?
Yes.
Did you know that your EQI in Saginaw shows that other services are billed at 6,400% higher rate than the independent network providers?
Nope, I wouldn't know that.
Would it surprise you to hear that Saginaw County bills therapy at 448% higher than the network providers?
I don't know.
You know anything about the fact that your billing rates are higher than any of the network providers?
It wouldn't surprise me that my CMH rates are higher.
Are your rates higher because
That
of your
would-
staffing and your overall administration of managed care delegated duties are included in your costs of service?
Can you say that one more time?
Are your rates higher because of your staffing and overall administration of managed care delegated duties as included in the cost of service?
I don't know if the report reflects that formula, but that seems familiar. I mean, I would say that outside of the EQI, because I can't speak to the report, but I would say, yeah, I mean, I think our costs probably are higher because we have more going on. And in some cases are also serving a higher acuity patient.
And do you use Medicaid capitation payments to pay for non-Medicaid eligible expenses such as your requirement under the mental health code? Your testimony is that Saginaw County does not do that.
Do we use non-Medicaid revenue to pay for Medicaid expenses?
Do you use Medicaid capitation payments to pay for non-Medicaid eligible expenses?
No.
Beach, are you near the end of your cross-examination or not?
I got a few more questions.
Okay, I want to try to finish this witness if we'll do it in just a couple minutes, but if it won't, we'll just take our lunch break and pick it
Okay.
back up. You tell me.
You know, I probably get another 15 minutes, so. if you
Okay,
wanna
let's take our lunch
Okay.
break then. That sounds good to me.
All
Yeah, I'm not trying to rush you. I just,
No, that's fine. Let's take another 15 minutes.
okay, sounds good. Let's do this then. We'll break till 1 o'clock. And we'll come back again and pick it up from there. If you're not back in your seats by 1 o'clock sharp, I'm not going to be upset with anybody. So don't worry, if you get hung up at a lunch spot, it's not a big deal.
Court of Claims will now be in recess.
What? Oh, shit.
She gets $50,000.
Okay. All right. Everybody have a seat. Make yourselves comfortable. Thank you. I'm sorry. Emergencies keep popping up. Before we go on the record, among other things, I was trying to take a quick look at this. I got an amicus brief that just got filed. Did anybody know this was coming? I mean, it's not a problem.
Which one?
Amicus curiae brief of Disability Rights, Michigan.
Yeah, so what happened is it was filed, I believe Friday. And we
It's
filed,
just dated today.
so here's what happened. It was filed Friday. We filed a response to it last night.
Oh.
They filed a reply to it this morning, and then the clerk's office rejected all three because I think there was a fee payment issue, so then they refiled it again.
Okay,
And that's
Mr.
how-
Trudell, you don't have to worry about this. I'll tell you when we're ready to go back up. I didn't want you to feel like we just.
No problem.
Okay,
So we did file a response. My office is refiling it now, so.
okay, so you did know. Have you seen this? Do you know anything about this? Because I didn't know anything about this until Vicky handed it to me at about 12:59.
Thank you. Yeah, we knew about it. Don't really have anything to do with, in terms of if they filed or not, but yeah, I was aware it was coming.
Okay, all right, that's fine. So let me just see if we're ready to go back on the record officially. Are we all set now? Great. Mr. Trudell, you can pick it back up and I'll take us back up and say what I have to say to get us started again.
Okay, all set.
Thank you, everybody, for being so punctual, coming back from the lunch break. I was a couple minutes late and I apologize for that, but frankly, I was sorting through the sorts of things that seem to pop up anytime I'm in the middle of a hearing all day. Among other things, I received an amicus brief from an organization called Disability Rights Michigan. I was a little perplexed because it bears today's date and it says it came in at 12:06, but before we went on the record, Mr. Ryan informed me that this had been filed last Friday, and as a matter of fact, the PIHP plaintiffs had filed a response to it. And so now, since everything got rejected for some failure to make a payment or something, that's why they're being filed right now. So Mr. Ryan, I just wanted to make sure, are you satisfied that you've been able to get a response effectively filed that wasn't rejected by the clerk's office?
So no, and just to be clear, the response that we filed was not a response to the amicus. It was a response to the motion requesting leave to file the. amicus,
Okay, I
which
apologize.
we oppose, but so we will get that response filed.
Okay. All right, I see. So you didn't respond on the merits. You just said we don't need this support.
Correct.
Okay, my general rule is to accept amicus briefs from anybody who wants to file them and then read them for what they're worth. But if you oppose it, I'll take a look at that before I actually turn to the merits argued in here. Frankly, I've had cases where I get buried in these things. And so I do the best I can to work through them, but understand, first and foremost, I care what the parties say. Okay, thank you very much. Now, when we left off, Ms. Lindsay was on the stand. There you are. I knew you were here somewhere. Come on up. Make yourself comfortable. And when we left off. No, we're sorry. Sorry.
We did.
This unfortunately is not a trial court courtroom, so we've had to retrofit it, and in some ways it's a bit awkward. The other thing I should say before we get started is Mr. Flegel, who's the director of security here, I think has tried to set up something so it's a little bit easier to work with the podium, but I won't insist that you take advantage of that.
I'm gonna try it, Your Honor, and see how this works.
That's fine. Okay.
It's a little unwieldy, but.
That's okay. So Mr. Beach, when we left off, you were cross-examining and you may return to your cross-examination.
Thank you very much, Your Honor. So Saginaw CMHSP has, fair to say, two different components to it, correct? Or two different parts to it. It has a managed care functions half, and then it's got a CMHP or a CMH provider component as well, right?
Meaning providing services directly.
Yes.
Yes, that would be correct.
So fair to say it has like two different arms?
Yes,
Okay. And you're the director that oversees both arms, right?
Correct.
Managed care and provider.
correct.
And as director, you approve and pay for, and pay the CMH using funds from Medicaid, correct?
Correct.
Do you understand that the Federal Anti-Kickback Act prohibits the payment or inducement or reward of referrals for services paid by Medicaid?
I don't know that act, no.
And you're aware that's a criminal statute?
No, I'm not aware of that.
Do you think it's a conflict of interest that you oversee both the managed care, the flow of money, and the arm of your CMHSP that provides services?
No, because it is true that I oversee both. But I can tell you that the managed care functions that are connected to the network are completely separate from the board operated program. In other words, they're completely separate chains of command. But the heads of both report to me. What is the nature, perhaps you can help me with the nature of the conflict?
Do you ever approve payment for services that are being performed by your own CMHSP?
I pay their salary. I mean, the organization pays their salary.
So you use Medicaid funds to provide services through your own
Yes,
CMHSP?
yes.
And you acknowledged earlier that your rates for your CMHSPs are significantly higher than
Well-
other service providers.
Based on what numbers you mentioned, yes.
I'm going to jump around a little bit. You got to forgive me if I confuse you. I'm going to try to address some of the things you testified to about earlier.
Okay,
You testified about civil admissions earlier. Do you remember that?
yes,
Okay. And you do understand that under the RFP, civil admissions are part of the non-delegable PIHP functions. I can restate it. I'm sorry.
yeah, I'm, okay,
Okay. Under the RFP, civil admissions are excluded. And they are part of the non-delegable PIH, or rather they aren't part of the non-delegable PIHP functions, correct?
meaning that that function would remain with the CMH? Is
Correct.
that, okay, then yes, okay.
Okay. But you testified that you were concerned about when authorizations will come for payment as it relates to civil admission.
Yes, I
Correct.
think, yeah, I'm concerned because I think it's unclear how that's going to happen.
All right. And you testified that your concern was based on not knowing when the authorizations will occur.
Correct.
So it's possible that the authorizations could happen just as fast as they currently do, or even faster, right?
All of that's possible, sure.
So fair to say that you're concerned about something that possibly could happen rather than an actual legal concern with the RFP. Fair?
Okay.
Is that a yes?
Yeah, I feel like I want to qualify that, but yeah, I don't know different. So yes, but I am concerned.
And when you testified earlier about recipient rights, you also testified that you were concerned, correct?
Yes,
But you are aware too that the RFP doesn't make any changes to recipient rights, correct? As they're currently.
yeah, I think that's correct. And furthermore, I think it's unclear. It's unclear and uncertain, which is remarkable to me.
But again, you're not saying it's illegal. You're saying that you're concerned because it's uncertain. Fair?
Foundation, she can't make testimony as to a legal conclusion.
Well,
So,
I think you're just trying to clarify
I'm
what
just
she
trying to
means.
clarify that she didn't testify to any legal conclusions to the extent.
Yeah,
That comes up later.
Yeah, I'll overrule the objection. Why don't you go ahead and ask the question again, Mr.
Could you
Beach?
ask the question again?
Sure. What you testified earlier, though, was concerns about uncertainty with regard to recipient rights. With regard to recipient rights, rather than any type of legal concern.
Yeah,
Correct.
I mean, my opinion had nothing to do with the legal. It had to do with the operational reality that remains unclear.
And you're not an attorney, so you.
Correct.
Right. Where in the mental health code does it say that CMHSPs need to decide how much a provider should be paid?
I'm not aware of a citation inside the mental health code or administrative rules. I'm just uncertain. I would be uncertain. I can tell you that the way that we approach contracting is to be prudent purchasers with public money, Medicaid in this case. And then that's how we proceed. When we identify new members to join a network, that we need to be prudent purchasers.
But there is no specific requirement in the mental health code, as far as you know, that CMHSPs need to be the ones that decide how much providers get paid.
I'm not aware that that detail exists. I am aware that the charge to public community mental health programs in the mental health code is to create services that are available to meet the needs of the community in the configuration and quantity that are needed.
And it's true under the mental health code that CMHSPs are only required to be service providers, correct?
I don't know that to be a fact.
Well, are you aware of any requirement under the mental health code that CMHSPs manage a network of providers under a Medicaid managed care structure?
I'd say that calls for a legal conclusion, Your Honor.
I think he just asked whether she knows.
Okay.
My answer is I don't know.
Okay, that's fine. I had a feeling.
Yep. Are you aware of anywhere in the mental health code that requires CMHPs to hold all network provider contracts?
I don't know.
It's true that CMHSPs will still be able to contract with hospitals for general fund services under the RFP, isn't it?
Yeah, I think use of general fund is separate.
And you talked about some other types of services, and I think I asked you this before, but just like any other provider, your CMHSP would still be able to bill Medicaid for the services it provides, correct?
Yeah, correct.
And your CMHSP can still perform civil commitment and correction services through the general fund contract as well, correct?
Yes.
So is it fair to say that what you testified to today is about the impracticalities of CMHSP operations under the new RFP rather than any actual illegality with the terms of the RFP?
I think it's correct that I'm not offering legal opinion. I'm speaking to operations and experience of care for beneficiaries.
And you're speculating as to what's going to happen because you don't know who's going to be the winning bidders, right?
Correct. Oh, absolutely. I don't know.
All right. Thank you. No further questions.
Okay, thank you very much. Let me get the time down here.
1 second, please.
Yep, sorry.
I'm gonna pop out of this chair, Judge. I'm sorry.
Still have another round. All right, redirect examination, Mr. Marchand, when you're ready.
Ms. Lindsay, are you aware that Saginaw CMH has a waiver of the anti-kickback regulations?
No, I wasn't.
Okay. How do you make providers comply with recipient rights right now?
Well, I don't think there's a heavy hand here. I think there's been a long tradition of both staff departments as well as providers responding with respect to the timeliness requirements of recipient rights remedies. So
Do you know whether your CMH's Office of Recipient Rights, do you know how they get jurisdiction or the ability to oversee contract providers?
well, I assume it comes from the authorities of the chapter of the mental health code that deals with recipient rights. And if in fact services under the authority of Saginaw CMH require the provision of recipient rights investigations and conclusions, and all that that entails is where that lives.
Okay. And Mr. Beach suggested that the CMHs should just pull services in-house. Are you able to pull inpatient hospitalization or inpatient psychiatric care in-house?
I'm going to object to the misstatement of my brother counsel of what he stated as a question.
Yeah, why don't you take that assumption out of it and just ask the question?
Are you able
without it?
to, okay,
Your Honor.
are you able to pull inpatient psychiatric care in-house?
No,
Are you able to pull all the other Medicaid paid for services that you provide in-house?
it would be a really big deal. It would be possible.
Okay, thank you, Ms. Lindsay.
Okay, any recross examination?
I don't have any.
Thank you very much. Let me just quickly note the time here. And you may step down, Ms. Lizzie. Since we're nowhere near any kind of time limits, I'm just gonna compute at the end of the day how much time everybody's used up. I'm keeping detailed.
So, yeah, for our own benefit, Your Honor, so are we, given the extra day that's added, are we still subject to a tight 270 clock or?
We'll see where we are. I mean,
Okay.
you all agreed to 270 and 240 before we started, and I cannot let this thing run beyond Wednesday, but suffice it to say that whatever we can squeeze in today, tomorrow, and the next day, I'm happy to hear.
Okay.
So in other words, the 270 may be something that's subject to revision.
It might be squishy, but not,
Right.
not a standard deviation.
Right, let's put it this way. I'm not gonna sit there till 10 o'clock on Wednesday night.
Fair enough.
I'm patient, but even my patience has its limits.
The plaintiff's call Joseph Sedlock, Your Honor.
Very much.
You make it.
I can.
Okay.
I want to try the backside of it. It's got lots of room for stuff too, but you can be wherever you want.
We'll give it a go here, and if it doesn't work, I'll switch sides.
This is a really interesting social experiment. Please raise your right hand. Do you solemnly swear from the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. Please have a seat, make yourself comfortable. And before we start with questions, please tell us your first and last names and spell your first and last names for the court reporter.
First name is Joseph, last name Sedlock, Joseph. Last name Sedlock.
Thank you very much, Mr. Sedlock. And whenever you're ready, you may proceed.
Thank you, Your
so
Honor.
much.
Mr. Sedlock, you testified in the first hearing we had on this matter, correct?
I did.
All right. And so I don't want to go through all of your background again, but just could you remind everyone where you're employed and how long you've been there, please?
I am the Chief Executive Officer of Mid-State Health Network, which is a PIHP. I have been there for just over 11 years.
Thank you. As part of your work with Mid-State Health Network, are you familiar with SUD services?
Yes.
Okay. And what are SUD services?
SUD services, the acronym SUD stands for substance use disorders. And the services run a range from outpatient, including things like individual therapy, group therapy, to withdrawal management, to medication assisted therapy, to prevention of substance use disorders, to residential treatment of all sorts. So it runs that entire gamut.
Okay. Do you know what the funding sources are for SUD services?
I know the public fund sources, yes.
And what are those?
The public fund sources run the range from Medicaid, Healthy Michigan program funding. There are federal substance abuse block grant funds that are administered at the PIHP level. There are also many SAMHSA state administered grants that are provided by SAMHSA to the state, and then we're contracted to implement those provisions as well.
And when you say are we talking about Mid-State Health Network, which is a regional entity and a PIHP?
Yes.
Objection leading.
All right. Do you know what an SUD oversight policy board is?
Yes.
What is it?
A substance use disorder oversight policy board is a creation of statute that exists for the primary purpose of approving the use of liquor tax, or what is sometimes referred to as PA2 funding, and then has some other statutory roles, including advising the PIHP on policy matters for substance use disorder treatment in the region, network adequacy standards, and related.
You may have touched on this briefly, but what is the purpose of the SUD Oversight Policy Board in relation to funds for SUD dollars?
So they have exclusive province over liquor tax, or which are local funds, and they advise in all other fund sources.
In your experience, are SUD funding sources sometimes intertwined?
Almost always, yes, they are.
And can you explain how that plays out practically?
So funding is woven at the individual served level who may be eligible for certain programs, services, or supports in the beginning of the month and may not be at a different point in the month or at different points during the month. The responsibility is to apply the fund source with which the individual is eligible, and then to make sure that they get the services and supports they need by weaving those funds together to ensure that there's an uninterrupted episode of care.
So can and does a beneficiary receive services supported by more than one source
I'm
during
gonna-
their course of treatment?
I'm going to object and ask if the witness could answer those in two parts.
Right,
Can,
yeah.
then
That's
do.
fine.
That's
Thank
fine.
you, Your
Yeah,
Honor.
break that
I can
up. That's
split it
fine,
up.
Ms. Wixom.
Can a beneficiary receive services supported by more than one source during their course of treatment?
Yes,
And do they?
yes, often.
Can you describe the existing delivery structure for SUD services?
The delivery structure includes the fact that the regional entity or PIHP, in my case, Mid-State Health Network, contracts with licensed, accredited, and credentialed provider organizations or individuals, not only in our region, but across the state, because many services are of a nature where they are only available in different parts of the state due to the economics of setting up, for example, a withdrawal management program or a residential program.
To your knowledge, can a regional entity be a PIHP?
Yes,
And so Mid-State Health Network, it is a regional entity, correct?
yes.
Objection leading.
And what does that mean?
Hold on, just 1 second.
Sure.
That's okay. It was a leading question, but we already got the answer, so, right, try not to lead.
What does that mean?
I'm going to say it calls for narrative, and we've already experienced what sounds again, like the last witness where we just prop up a question and hear testimony with a bunch of hearsay in it. And I'm going to just lay the objection for open-ended question.
All right, let's see where this takes us.
Thank you, Your Honor.
You said, what does that mean? Are you talking about the regional entity structure, the
Your
PI? Okay, so why don't you go ahead and explain the regional entity structure?
Thank you, Your Honor.
Thank you very much, Mr. Stevens.
The structure of the regional entity as we are created, in my case, in the case of Mid-State Health Network, by 12 community mental health services programs who have adopted bylaws that were created by those CMHs and govern how the organization is governed, honestly. Secondarily, in our case, we have a operating agreement that addresses how the agency is managed, meaning how we finance the system, how we participate in decision-making and so forth.
Thank you. Do you know if a CMHSP by itself can be a PIHP?
Yes,
Have you reviewed the RFP at issue?
yes,
Do you know whether under the RFP, if a new PIHP has to be either a CMHSP or a regional entity?
no, it's open to many different kinds of bidders, to the exclusion of some, in fact.
Are you aware if under this RFP, are the new PIHPs required to meet the requirements of Chapter 2A of the Mental Health Code?
Yes,
And do those requirements include, to your knowledge, providing SUD services?
yes.
And based on your employment and service in your role as CEO of Mid-State Health Network, do you have an understanding of the mental health code?
Yes,
So within your understanding of the mental health code, if a PIHP is neither a regional entity nor a CMHSP, could that PIHP be a department designated community mental health entity?
not to my knowledge, no.
So if it cannot be a department designated community mental health entity, how, to your knowledge, could that new PIHP fulfill the mental health code's requirements regarding the provision of SUD services?
I don't think a different entity could, because the statute is very clear that the CMHEs must be a CMHSP or a regional entity.
What about obligations associated with SUD policy oversight boards and contracting requirements?
Objection. I don't even think it was a question.
I can keep going.
Okay.
Yeah, why don't you try that differently?
Sure. What about obligations associated with SUD policy oversight boards and contracting requirements for these new PIHPs under the RFP? Can they fulfill mental health code requirements?
Okay, object. It's compound. We talked, there's multiple parts of that question. Built upon assumptions.
I think she just asked whether they could fulfill the requirements. So why don't you answer that first if you can, and then don't give us a long explanation. Then I'm hoping she'll follow up with a more detailed
Thank you, Your
question.
Honor.
To my knowledge, no.
All right, now you can ask him why. If you want.
Sure, thank
You
you.
don't
Your
have
Honor.
to.
No, I appreciate that. And are you familiar with who could bid in this RFP?
Yes.
Do you recall which types of entities could bid in this RFP?
Public universities, private nonprofit organizations, and public bodies.
And to your knowledge and understanding related to the mental health code, if a bidder is a nonprofit or a public university, could that bidder provide SUD services?
Not as a community or as a department designated community mental health entity, no.
In your opinion, does the RFP's SUD provisions, or do the RFP's SUD provisions align with the requirements of Chapter 2A of the Mental Health Code?
Objection. She led the question with, in your opinion, and then followed with a legal statement and asked, is it true?
Right.
So
Right. Yeah, I don't think he can answer that question.
No.
I'll sustain the objection.
Thank you, Your Honor.
Yep.
You've reviewed the SUD provisions in the RFP, correct?
Yes.
And you have an understanding of the mental health code.
Yes.
Nadine? That's fine. I'm sorry. That's right.
I mean, we can keep.
I
going back
know,
and forth here, But
That's fine. Just doing my job.
do the SUD provisions in the RFP align with the mental health code?
Objection. Ask for opinion, legal conclusion.
I'm not going to take it as a legal conclusion, but I'll let him answer the question.
Thank you, Your Honor. I appreciate that.
Could you rephrase the question? Not repeat the question, please.
Do the RFP SUD provisions align with the requirements of the mental health code?
One more time.
Do the RFP SUD provisions align with the provisions in the mental health code?
Yes. In that they require the bidders to comply with the mental health code.
Your Honor, I'm going to object to that, the response there. Again, we're delving into legal conclusions here. I think you're saying that he's going to take it as such, but we're going beyond that a little bit more.
Right. I'm going to overrule that objection. I'll let the answer stand. Go ahead.
Thank you, Your Honor.
Yeah, thank you very much, Mr. Stevens. Appreciate it. Got it.
Okay. You've heard, and essentially this, what do the PIHPs delegate in terms of their managed care functions to CMHs?
We treat our community mental health services participants as comprehensive specialty services networks, meaning that they bring a network of providers, a continuum of care that for their entire community, their entire catchment area, to their contract with the PIHP. We delegate only those functions that are necessary for the CMHSPs to oversee that network effectively. And then we monitor their performance and hold them accountable to standards that we set for those delegated managed care functions. At all times, the PIHP remains responsible for everything that is delegated downstream, and we oversee it and hold our partners accountable for that performance.
Under the RFP's managed care functions, can CMHSPs independently contract with providers for services?
Under the current structure of the RFP, I do not see how that is permissible since there is an absolute prohibition on delegation of anything.
And do you know what a co-occurring disorder is?
Yes.
What is it?
In layman's terms, a co-occurring disorder is a condition that coexists with another. In the case that we're talking about, it's a mental illness that coincides with a substance use disorder. They occur at the same time, and it's not necessarily one is primary over another.
Under the RFP, how are individuals with co-occurring mental illness and SUD going to be handled?
I have no idea.
Based on your review, do you see that the RFP accounts for individuals with co-occurring disorders?
In the, I do not see how it's possible that the RFP can contemplate that in the exclusion of CMHEs who have responsibility for substance use disorder from the process.
I don't have anything further.
Thank you very much. Cross-examination?
Your Honor, if I may, Your Honor, I'm sorry.
Oh, you need to get on a mic. Sorry, Mr. Cook. I apologize. This is cumbersome.
That's all right, Your Honor. I hate to raise this as a protocol matter, but I think Mr. Domich is making the objections, then Mr. Beach is doing the examination. I think we shouldn't split up those responsibilities, especially with numerous attorneys.
Let me put it this way. I don't want multiple attorneys objecting, and obviously I don't want multiple attorneys conducting direct or cross-examination, but if one person objects and somebody else does the direct or cross, it really doesn't matter.
Mr. Cook has that big of a problem with it. I'll do both.
Yeah,
That's fine.
and I'll-
That's not that big of a lift.
Okay, that's fine. Thank you. Let's proceed with cross-examination. Mr. Beach, go ahead.
Thank you, Your Honor. All right, just to be clear from the outset, Mr. Sedlak, you're not an attorney, correct?
No, I'm not.
You work for the Mid-State PIHP, correct?
That is correct.
And what is your title?
Chief Executive Officer,
How much do you earn a year as Chief Executive Officer?
about $220,000.
And based on that, you have a personal financial interest in the outcome of this case, correct?
No,
Well, if.
I understand. I understand your question. I'm telling you, I don't have an interest.
If your PIHP doesn't exist anymore, you won't be earning $220,000 a year, right?
From this employer, probably not.
So you'd have to look for a new job.
Probably.
And you're not involved in the DTMB procurement process, right?
No.
And you're aware that it's a fluid process, right?
What do you mean by fluid process?
Subject to change.
Once an RFP is issued, my understanding is it stands as it was released.
What are you basing that knowledge on?
35 years of experience in this industry.
What experience do you have in the procurement process?
I have plenty of experience in replying to and participating in procurement processes as a bidder. I have operated as a PHP many procurement processes where we procure services and supports for the regional entity itself. And I may have been in other parts of my career involved in the evaluation of proposals under a procurement process.
But you've never worked for DTMB, correct?
No, I have not worked for DTMB. No.
Can you tell me where in the procurement manual does it say that they can't change the RFP?
I told you what my understanding was. I have no idea what's in the manual.
And you're aware there's any number of changes that could occur with the RFP or the terms of the RFP prior to any negotiations, right?
I think that's your assertion. That is not my understanding.
And you don't know who the winning bidders will be, correct?
I have no idea.
It's true that in March of 2025, the Mid-State PIHP explored submitting a bid, correct?
Yes.
And it's possible that as long as they fit the geographic boundaries, the winning bid under the procurement could be a CMHSP or CMHSP regional entity or combination thereof, correct?
I'm sorry,
Just
I lost
object
the
to
first
it
part.
being compound, Your Honor.
Well, I'm going to overrule that objection because I think if we split it up into parts, you could ask whether either one individually could.
I
be
can split it up. Your Honor.
A bidder. Yeah, all right, let's do that just to keep it simple. I know what you meant, Mr. Beach.
It's possible that the winning bidders could be made up of CMHSPs or CMHSP regional entities, correct?
If any submitted a bid, I suppose they would be considered, but my understanding of the RFP requirements is they have to serve the entire region, and regional entities are not permitted to operate outside of their existing regional boundaries, neither are CMHs.
But if, say, two regional entities came together and they met the boundaries, they could be the winner, right?
Objection calls for speculation.
No, I let him answer the last question. I'll overrule it and let him answer this one too, because this is something I wondered about myself, and I know his answer isn't definitive, but it's something that I've been contemplating.
It's certainly possible, isn't it?
In their current legal form, I do not think that is possible. They would have to create a separate entity under the Urban Cooperation Act or another type of vehicle to qualify to be awarded a bid under the terms of the RFP as I understand it.
But that's just as you understand it, right?
Correct.
And you're not an attorney, right? And you don't know how many PIHPs are going to exist for each region either, do you?
No,
It's possible that there's two, right?
it's possible that there could be 50.
Yeah. And it's possible that one of those PIHPs could be made up of CMHP regional entities, right?
If they were permitted to bid and submitted a bid for that met the bid specs, yes.
Where in the RFP does it say that they're not permitted to bid?
I don't think it says explicitly that they're not permitted to bid. It says by defining criteria that cannot be met by those entities, that they are thereby excluded.
Where does it say that?
Would you like to bring out the RFP and I can go through it one by one with you if you wish?
Did you read the entire RFP?
I did.
You testified earlier about SUD services, correct?
Yes, sir.
But what you testified to was completely speculative, wasn't it?
Can you be more specific about my testimony?
Well, that you seem to be speculating that the CMHSPs wouldn't be able to deliver SUD services, correct?
That is not my testimony.
Well, could you clarify what your testimony was for me?
Can you ask me a specific question to respond to?
Well, the PIHPs, was it your testimony that they would not be able to deliver SUD services?
Can you repeat that, please, Mr. Beach?
As to the PIHPs under the RFP, was it your testimony that they wouldn't be able to deliver SUD services?
If they are not a department designated community mental health entity or eligible to be a CMHE in my words, yes.
But that's something that could be resolved through contracts, isn't it?
No.
Why?
The statute, in my reading of it, is very clear that it can only be a department designated community mental health entity can only be a CMHSP or a regional entity. The statute does not contemplate any other type of organization, including the types that are included in the RFP eligibility.
But the PIHP, under the RFP, the PIHP could contract with the CMHSP for those services, correct?
I suppose other configurations are possible. Your question was, can the PHP awardee be a CMHE? And the answer is no.
But it could contract with CMHSPs.
I don't know if that's permissible or not. That's not my, I have no idea about that.
Well, you don't know because you're speculating today, right?
You're asking me questions that require me to speculate. I don't know what's possible.
And it is possible that if they could conform the geographic boundaries, that the PIHP could be a regional entity, just like Mid-State, and then they wouldn't have the issues with being the CMHE, right?
Could you ask a question again, please?
It could be that if Mid-State, hypothetically, were to submit a bid and along with other entities and meet the geographic boundaries, that as the PIHP, it would be able to be a CMHE, correct?
That requires some speculation on my part, but I think the answer to that would be yes.
Actually, don't think I have any further questions.
Okay, thank you very much. Redirect examination, Ms. Wixon.
Mr. Sedlock, there are witness minders next to you. And specifically, is it okay if I approach the witness yonder to speed it
That's
up a
fine.
little bit?
Yeah, as long
All
as
right.
you're on a mic, whatever you want to do is fine with me.
Thank you.
Which mic?
Volume 3.
Thank you. Okay, Mr. Sedlock, the exhibits are tabbed. And if you could turn to the podium. Exhibit 124, please. And Mr. Sedlock, do you see where it says 330.1210 Community Mental Health Services Program election to establish coordination of services?
I do.
And then below that, it says there's a number 2. Do you see that?
I do.
Okay. And is this number 2 what you were referencing with your prior testimony?
Yes.
And what does number 2, in your understanding, stand for?
Stand for?
Yes. What does it mean?
It means that only a community mental health entity can coordinate the provision of SUD services as that term is defined in the statute.
And if you then will turn to Exhibit 106, please.
Just a point of order, are any of these exhibits being admitted or are we just looking?
I don't know that we need to admit them because I'm identifying them. We put them in our binders for ease of everyone's reference.
Sure. Obviously, I suppose if you want to admit them, we can admit them, but there's no reason that we have to admit Michigan statutes. I have all of them right here.
I was just looking for clarification, Robert.
That's fine.
Okay, Mr. Sedlak, do you see on Exhibit 106 where it says 330.1100A definitions?
Yes.
All right. And then if you turn to the second page with me, please, to number 24.
Yeah.
Do you see that?
Yes.
And what do you recognize number 24 in the definitions list to be?
Your Honor, I'm going to object. I think the document speaks for itself, because it's a statute.
Right. Right. You can certainly talk with them about the statute, whether this document is admitted or not. It's certainly before the court for all purposes. And I think what you're directing his attention to now is the definition of, quote, department designated community mental health entity. Is that correct?
That's correct, Your Honor. Is this the entity type that you were referencing in your prior testimony?
Yes, it is.
Thank you. I have nothing further, Your Honor.
Any I'm sorry, recross examination.
There's no recross.
Thank you very much. And I don't know what you want to do with these statutes. It's very obviously helpful to have them. I'm glad they're here, but for what it's worth, I certainly consider every single statute in the state of Michigan to be something I can study on my own and take judicial notice of if necessary. So I don't know that, I mean, if you want to move to admit them, I can't imagine why anybody would oppose that, but I don't think there's any need to do that.
I don't think we need to admit them either. It's solely for ease of reference, Your Honor.
All right, that's fine. Thank you very much. I appreciate it.
Nothing.
Sorry.
Your Honor, plaintiffs call Marissa Gove, who's already seated on the witness podium.
Very well. Sorry to make you stand up now, but I have to swear you in. You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yeah.
Please have a seat now and make yourself as comfortable as you can be in that odd configuration. Please tell us your first and last names and spell your first and last names for the court reporter.
Sure. Marissa Gove, Marissagove.
Thank you very much, Ms. Gove, and now you may proceed. Thanks for your patience.
Thank you, Your Honor. And for the court's awareness, we are calling Ms. Gove under the adverse witness statute, and so intend to ask leading questions.
Okay, that's fine. And
Ms.
can you just quickly establish why she's an adverse witness? You can just ask her where she works. I have a feeling I know what the answer is going to be.
That'll be my first question. Ms. Gove, where are you employed?
State of Michigan, DTMB.
And so, Your Honor, as a party who is an employee of the adverse party, I'm requesting permission to call her under MCL 600.2161.
That's, you may ask leading questions.
Thank you, Your Honor. Okay, so you're employed at what I will call DTMB, is that right?
Yes.
As a category specialist?
Yes.
Meaning that you handle procurement of goods and services for the state of Michigan?
Correct.
Does this include requests for proposals,
Yes.
also known as RFPs?
Yes.
And specifically, are you the solicitation manager for the RFP at issue in this litigation?
Yes.
Now, as solicitation manager, I'm sure you had a lot of responsibilities, right?
Yeah.
But I'm going to focus in on just a few of those responsibilities with you today, okay?
Okay.
As part of your role as solicitation manager, was it your job to review the RFP language?
Yes,
Okay, to make sure that the RFP language was complete,
yes,
that the RFP language was accurate,
yes,
that the RFP language complied with DTMB rules and requirements?
yes,
Okay. And that's because RFP language, you'd agree with me, is important.
yes,
Okay. RFP language gives potential bidders information about how to build their bids. Is that right?
correct.
And RFP language is reflected in contracts if they are rewarded or awarded.
Yes, the RFP is the basis of the contract.
Right. And the contract and the RFP mirror each other.
Yes,
All right. Now, there are circumstances when RFPs have issues. Is that right?
correct.
And DTMP has corrective actions. Is that right?
Yes,
There are a few options that DTMB can take when there are problems with RFPs.
correct.
For example, DTMB can issue a notice of deficiency.
Yes,
And notices of deficiency are for violations that can be fixed during the procurement process.
the notice of deficiency typically comes in when we've already received proposals.
Your Honor,
So-
just a point of order real quick. Have you found an appearance in this case?
Yeah, Aaron Lane, Miller Johnson. Yes.
An appearance of an attorney from one,
Right,
Okay.
Correct.
right. I'm sorry, why don't you state your name for the
Certainly, Your
record, just simply so that Mr. Trudell has you down. We have so many
Absolutely.
attorneys here. I
Yeah,
know who you
honestly,
are,
it's just,
but-
it's just,
No. Hello, everyone. My name is
thank you.
Mr. Damish. Hello. My
Hello.
name is
I know,
Aaron
thank you.
Lane, like Lois Lane, no relation.
Well,
And I work at Miller Johnson.
Thank you, go ahead.
Thank you. Okay, now back to the exciting stuff, notices of deficiency. So these happen when a notice or the bid is in process, the RFP has gone out. Did I hear you correctly?
Yes,
Okay, and the violation or the issue is amended, right?
yes, the notice of deficiency happens after a bid deadline, essentially.
Right, and whatever issue can be fixed without having to take option number 2, which is pull the RFP.
Yes,
Okay, so the second option in a violation circumstance is to pull back an RFP, right?
that is an option.
What was that?
It is an option.
It is an option,
Yes.
okay. And then potentially reissue the RFP.
Yes,
Okay, and a RFP pullback would be when there is a material, serious issue with the RFP that can't be resolved through a notice of deficiency process.
I would say, yeah, it depends.
Okay, but that would be the option in a more serious circumstance.
That could be an option, yes.
Your Honor, I have no further questions.
Okay, thank you very much, Ms. Lane.
Thank you.
Cross-examination, let's see. Sorry, we need to get everybody on the record here, so why don't you go?
I realized as I made that objection, we brought someone else back up, so. I
It's
apologize.
fine.
Yeah.
I know who everybody is here, but for the court.
Mr.
reporter.
Kitzmiller, Your Honor.
Yeah, right, and I'm sorry, I had that all messed up
It's
earlier.
fine,
As
it's
soon
fine.
as Mr. Beach straightened things out, I knew who you were. Thank you, Mr. Kitzmiller.
Good afternoon, Ms. Gove.
Good afternoon.
So you had mentioned that you worked for DTMB and you're the solicitation manager for DTMB, correct?
Yes,
And you're one of many solicitation managers over at DTMB, is that fair?
yes,
Do you go through any training as the solicitation manager?
yes. We have like an AMP training.
Sorry, what was it?
We have an AMP training.
AMP training.
Mhm.
And what does that training consist of?
It goes through like the MPPM and just standard practices in procurement.
And do you have to complete that training before you are able to work as a solicitation manager for DTMB?
Yes,
You have to complete that training before you handle any RFPs that are administered through DTMB?
I mean, it's done pretty quickly after you're hired in. So I don't know if it's that you have to have it done to do a solicitation, but
Sure,
sometimes scheduling might be a little off.
sure. But as far as training, you're trained through DTMB to be able to handle these RFP processes.
Yes.
And as a solicitation manager, we've clarified that you handle these RFPs. When you become involved with an RFP or get assigned, when you first become involved with an RFP, can you explain what that process is from the first point of your contact with that RFP? And we'll assume that it goes all the way through to successful contracting.
Yes. So sometimes we're given a heads up that a solicitation is either like coming over. For the most part, they're planned projects. So my manager would assign the project to me, and then that's when I would reach out to the agency, whoever's contract it's for. And I would receive the requirements from them. We would start putting requirements into our DTMB's standard templates, and then work on the development of the RFP. Once that's finalized and pushed out through Sigma to the public, after the bid deadline, we receive the bids, we go through evaluations, and then negotiations. And then once we award the contracts, we do like a contract integration.
Okay, so let's just run through that. So you get assigned the RFP and you then work with the state agency that is seeking a good or service. Is that fair?
Yes.
And through that cooperative agreement, you then develop the RFP, the request for proposal.
Correct.
And when that request for proposal is finalized and ready to be publicized, that gets issued out to the public through Sigma, you had mentioned.
Yep.
And just briefly, what is Sigma?
It's just like the system that the public has access to. So they'll receive like, typically once they're signed up through the commodity codes relating to that RFP, they'll receive an email where they can bid on the RFP.
And between the time that it's posted until then you receive, or until the deadline of receiving bids, is there anything else that occurs in that time period?
Yes, question and answer period.
And is there also a bidders conference as well?
Yes.
Okay. And you then have the bid deadline by which you have to receive proposals by. That occurs next.
Correct.
And after you receive bid proposals, you then have the evaluation process.
Yes.
And then you have an award recommendation if there's bidders that are able to be selected and awarded a bid.
Correct.
And then after you award bids, is there a negotiation period?
It would be before award. We do
Before.
negotiate. Yes.
Okay. So there's negotiations made that occur before an award recommendation is made.
Yes.
And then after you recommend an award, is that when a contract is entered into?
Yes.
And is there any other negotiation after the award recommendation until the contract is executed?
Sometimes there can be. Yes.
Okay. Now, plaintiff's counsel asked you about some ways in which an RFP can be amended or changed after it is issued. And they had mentioned, Ms. Lane had mentioned notices of deficiency are one way to make changes to an RFP. Is that fair?
Yep.
And there are also two other ways, at least two other ways in which changes can be made to an RFP. Is that fair? Or maybe you can tell me what other ways
yeah.
are there to change an RFP?
So prior to the bid deadline, we can do amendments. And then after bid deadline, we have notice of deficiency. And then the other option to just being like, depending on what the issue was, kind of just keep letting it go as is. It just kind of depends on what exactly it is that the issue is.
Okay, so you had mentioned there's there's amendments that can be made. There's also the notice of deficiency. And did you mention it? So is there another one?
Besides like polling the RFP, if there's something major.
What about after a contract is executed or entered into? Is there any way to change terms at that point?
Yes, through a change notice.
Through a change notice, okay. So the amendments that occur to an RFP, those occur when any corrections or revisions need to be made to that publicly posted solicitation. Is that fair?
Yes,
And those occur before the bid deadline.
yes.
Can they occur after the bid deadline?
Then it would be considered the notice of deficiency.
Then it's just a change of term, but
Yes.
it's a different term. When an amendment is made to the RFP, is that made available publicly to notify bidders of changes?
Yes,
And is that made publicly through an addendum, what's known as an addendum to the RFP?
yes.
And just to, I know you testified about this, but so the notice of deficiency then, that's another way to change the RFP, and that's a way to change it after the bid deadline has passed.
Correct.
But similar to an amendment or an addendum issued before the bid proposal deadline, it still is amending the terms of the RFP.
Yes.
Now, as it relates to this RFP that's at issue in this case, have there been any amendments made to the RFP?
Yes.
So there have already been amendments made to change what may have been the initial terms of this RFP when it was initially issued.
Yes.
And how many amendments at this point have there already been?
I believe there was 5.
5. And have there been any notices of deficiency yet at this point?
No.
Is it possible that there still could be a notice of deficiency issued?
Yes.
In fact, there could be multiple notices of deficiency issued as the process moves forward. Is that correct?
Yes.
Now, you also mentioned the change notice, and this is, we're kind of jumping ahead in the RFP process, right, until after a contract is executed. But a change notice, can you just briefly explain what that is?
Yes. So if there were changes needed to be made to the contract, we would do a change notice. So that's where we could change requirements, add requirements, remove them. There are a lot of variables with change notices, adding money. That's kind of where we just make any amendment to the contract.
Sure. And those change notices, let me back up a little bit, I guess. You had testified earlier, Ms. Lane had asked you about the terms of the RFP and the eventual contract that is entered into, that they mirror each other. Do you remember that?
Yes.
When you say they mirror each other, when a contract is entered into, it's entered into after amendments have already been made. Is that right?
Yes.
And a contract is entered into after notices of deficiency have already been issued. Is that right?
Yes.
So when you're testifying that a contract mirrors the RFP, you're talking about it mirroring the RFP after all of these changes that may need to be made have occurred. Is that correct?
Correct. We also do like, we have a contract integration phase. So that would be after awarding the contract. And sometimes we integrate, it could be like responses from bidders into the requirements. So there are some changes, but mirroring in the fact that it sets the basis of the contract.
The RFP terms kind of set the basis for the contract that's entered into.
Yes.
Okay. And so this then gets to my change notice questions, right? So those change notice that occurs after a contract has been entered into. And a change notice then can even further change what maybe was incorporated into the contract initially. Is that accurate?
Yes, we can make changes within scope.
Within the scope. And when you say the scope, what do you mean by that?
Within like, I guess what the contract is for and the requirements. So if there are changes needed to be made or requirements added, they can be done within scope.
And the scope of this contract is seeking entities that serve as PIHPs or prepaid inpatient health plans for specialty behavioral health plan services. Is that somewhat accurate?
Correct.
All right. And so as long as it's within that scope, changes can be made to this, to the eventual contracts that are entered into when needed.
Yes.
So is it fair to say that the terms of the RFP as it exists today may not be the terms of the RFP as it exists when it is incorporated into an eventual contract, if we are able to get to that point?
It could, yeah.
And at no point, back up a second. There's no requirement that just because terms need to be changed in an RFP, that it must be canceled. Is that correct?
Like the RFP must be canceled?
Right.
Correct. We can,
Sorry, go ahead.
yeah, we can update like requirements and stuff.
Is it accurate to say that DTNB would make changes to the RFP terms as long as it's within the scope of the RFP before resorting to canceling an RFP?
Yes.
And any of these changes that we talked about, amendment, and at this point, a notice of deficiency, or eventually potentially a change notice, those changes could be made if it's determined that a term of this RFP does not comply with the law. Is that possible?
Yes.
No further questions, Your Honor.
Thank you very
Thank you, Ms.
much.
Hope.
Any redirect examination? Ms. Lane?
Okay, Ms. Gove, I do have a couple follow-ups for you based on what you just went over with the state. So let's first talk about terms of the RFP. You remember before you appeared in court today, you sat for a very long deposition with Mr. Marchand?
Yes.
Okay, so I want to just clarify a few things that I heard from you today and that I heard from you during that deposition.
Sure.
So you would agree with me that the RFP language can't have placeholder language, right?
I think it depends on the context of what that requirement is.
So if it's an essential requirement of the RFP that bidders need to know about and have clarity about, you can't have a placeholder in the RFP. It needs to be accurate.
I think object, this is outside the scope of direct and cross.
This actually goes to the heart
Yeah,
of what
right.
was discussed
Yeah, I'll allow
during
that. I'll
cross.
overrule the objection. You go ahead.
Yeah.
I don't see a scope problem here.
Thank you. So if it's an
Take that.
essential component of the RFP, the language needs to be accurate. That's what you testified to today with me just a few minutes ago. Is that right?
I think that the language needs to be clear.
Clear.
Yes.
And it needs to be accurate.
It should be
correct?
accurate.
It
yes.
should be accurate. Okay. And there can't be placeholder language in the RFP. You've testified to that before, right?
I have testified to that. Yes.
Okay. All right. So these changes that you've talked about are not material changes to the language of the RFP. They're within scope, correct?
Could you repeat that? Sorry.
Changes have to be limited, correct?
But yes, they have to be within scope.
Yes, have to be within scope and limited in not changing the essential language of the RFP, the essential requirements, that's a better word. The changes can't change, the changes to language cannot change the core requirements of the RFP. Would you agree with me?
Objective foundation, Your Honor. Not sure what core requirements are.
So I'm using language that she used
Right,
during
right,
cross.
right, that's fine.
So core requirements would be.
I should say, I'll overrule the objection and let you proceed. Right, we've heard that terminology already.
Thank you, Your Honor. But I'll tell you what I mean by core requirements, the essential components of the RFP, okay? Changes in language cannot change the essential components of the RFP because that would make it out of scope, right?
Yes, we can't make changes out of scope, but I guess without knowing exactly what the requirement is that is needed to be changed, it's hard to say yes or no, that can't be taken out.
Right, this
'Cause
is a
we can,
hypothetical.
yeah, because we can make changes to the requirements.
But there is a scope, so changes have to be limited to the scope.
Yes.
Okay. As the RFP solicitation manager, you'd agree with me that all direct bidder communications about the RFP had to go through you or that official question and answer forum. Is that right?
Correct.
Okay. And you're aware that Director Hertel made comments.
Outside the scope of direct and broad.
It's not. She was asked about communications on cross. I
Right,
didn't ask her about it on direct.
Right, that's fine. I'll overrule the objection. You can proceed.
Thank you, Your Honor. So you're aware, and you've been asked before, that Director Hertel gave comments about the RFP when the RFP went live. It was already advertised on Sigma, right? You've heard this.
Objected it assumes facts, not in evidence.
You're gonna try to put that in evidence, aren't you? All right, I'll allow, I don't want any questions about what Director Hertel said. You can set this up.
Correct.
But I don't want any questions about what Director Hertel said. That's gonna have to come in on its own merits.
I agree with you, Your Honor.
Okay.
And I don't even think you maybe know what she said. So not the content of the conversation. The fact that Director Hertel made comments about this RFP outside the official question and answer forum violates the Michigan Procurement Policy Manual policies.
Your Honor, I'm going to object that this is outside of the scope of this hearing.
Right.
We're talking about the legality of the RFP.
I really don't want her to answer
Thank you,
that
Your Honor. I
question
appreciate
because as
that.
far as I'm concerned, she doesn't have the authority to say
Thank you.
that.
Thank you, Your Honor.
No further questions.
Okay, thank you very much.
Thank you.
Now, any recross examination.
Just briefly, Your Honor.
Before you do that, can I ask you one question? I just want to try to understand the distinctions here. Let's just say, let's try a wild hypothetical where all of a sudden the executive branch unilaterally cuts the Medicaid funding for Michigan in half. And so the whole RFP is built upon a certain level of funding, which no longer exists. What happens to the RFP in that circumstance?
Gosh,
Is it a change? Is it a pullback?
I have no idea. I'm not sure how, I guess how that would change the RFP.
Well, I mean, if it requires a whole the successful bidder to do a whole bunch of things and now there's only half as much money available.
Yeah.
Let's say they just cut it completely. Just a wild hypothetical. The executive branch decides, we're done with Medicaid. You don't get any money. Michigan doesn't get any money. Massachusetts doesn't get any money. We might give some money to Alabama and Mississippi. Maybe.
I have no idea.
Wild hypothetical.
I would say, I don't know, a contract probably wouldn't exist. I have no idea.
Okay, in that case, would you have to have look, all I'm trying to understand is the difference in degree between an amendment and a pullback.
And I think that really just depends. And I think I would probably lean a little more heavy on management to help with that decision because I haven't ever had experience in having to pull back an RFP. Usually,
Okay.
if there's anything deficient, we would do the notice of
Okay,
deficiency.
I'm sorry, I don't mean to put you on the spot.
That's
But
fine.
you've used these terms and I'm just
Yes.
trying to figure out
Yeah,
where the gradations occur. That's
Yeah.
all. I'm not trying to be difficult. Okay, go ahead, Mr. Kitzmiller.
Thank you, Your Honor. Ms. Gove, you were asked about placeholder language. Is it fair to say that there is no prohibition against placeholder language in the RFP process?
I don't think that there's anything in policy around that. I don't know.
Have you had RFPs outside of this one where there may have been placeholder language included?
Well, yes, in the sense of like capitation rates.
And why might something like capitation rates have a placeholder language?
Sometimes those aren't set until way later in the process.
Sorry, I don't mean to cut you
Yeah,
off.
that's all.
Is it something that may be negotiated as part of the contract?
I don't do the negotiation part of that, but it could be, yes.
Is it something where if something like payment rates or payment for a contract, those are subject to negotiation when you're going through that process of awarding a contract. Is that fair?
Yes, it could be.
No further questions, Your
Okay,
Honor.
thank you very much. Thank you, Mr. Kitzmiller. What do you think? Next witness, or you want to take a break? Next witness, let's go.
That's it.
Yeah, you get it. I thought she had more questions.
Okay, that's fine.
Oh, Your Honor, can we discuss whether or not the witness is released and able to?
Oh, sure.
Everybody who's
The-
testified.
Yeah, right. You're no longer, right. Particularly since you're not going to have any rebuttal witnesses, everybody is released from the obligation not to listen to or speak about the matter.
Can I be released, Your Honor?
No, you're here for the duration, Ms. Lane.
Oh, what happened?
There's somewhere.
There it is.
Oh, she has been called. Okay.
Yeah. Sorry, you have to run the gauntlet just to testify. Okay, before you sit down, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
You may have a seat, make yourself as comfortable as you can be there. And then before we get started, tell us your first and last names, and please spell your first and last names for the court reporter.
My name is Raymie Postema. First name is Raymie. Last name is Postema.
Thank you very much, Ms. Postema. And whenever you're ready, Ms. Lane, you may proceed.
Thank you, Your Honor.
Just a real quick order of business. I'm not going to be doing the objections because I have prepared to cross Ms. Postma. So
Oh,
if that's okay,
No.
then Mr. Reese is going to do objections this time.
yeah, that's fine. It's totally fine.
No objection. Ms. Postma, where are you employed?
I am employed with the Michigan Department of Health and Human Services.
And Your Honor, given the fact that Ms. Postma is a state employee, I similarly ask permission to treat her as an adverse witness. and
Okay,
ask-
that's fine. You can ask leading questions. That's
Thank
fine.
you. Ms. Postma, specifically, are you the director of the State Office of Recipient Rights?
Yes,
And you've been in that position since 2020, am I correct?
correct.
But you've worked in the field of recipient rights in the state of Michigan since 1997.
For the state of Michigan since 1997.
Thank
correct.
you. So you have about 3 decades of experience. I
Yes.
say in the most honorable way, 3 decades of experience in recipient rights for the state of Michigan,
Correct.
in the state of Michigan.
Yes,
Okay. And would you agree with me that Michigan has a recipient rights system, not merely a recipient rights office?
correct.
Would you also agree that the foundation of the public health system services rests on the protection of recipient rights?
Yes,
Now, I'd like to ask you some foundational questions about recipient rights for those of us who don't have 3 decades of experience. The recipient rights has some very specific requirements under Michigan law. Is that correct?
Yes.
In the mental health code, for example, a recipient, so the word recipient is an individual receiving mental health services from the department, correct?
Yes.
Or from a provider under contract with the department.
Correct.
And under the mental health code, recipient rights are a required service.
Yes.
Would you agree with me, or are you aware that section 1755 of the mental health code is the part of the law that governs community mental health service providers' Office of Recipient Rights?
Yes.
And this includes, this provision, the statute has several obligations for the CMHSP service providers.
Yes.
Okay. Specifically as in regards to the recipient rights program.
Yes.
Is one of those several obligations that in each contract between a community mental health service provider and a provider, there's a requirement that the provider and their employees receive recipient rights training.
Yes, there's a requirement.
Okay. And is there another obligation under the same section of the mental health code that the recipients be protected from rights violations while they are receiving services under this contract?
Correct.
Now, shifting gears slightly, are you familiar with MDHHS, their current procurement for PIHP, so the RFP at issue in this litigation?
I have not reviewed the RFP.
Are you aware of its existence?
Yes, I am.
Have you reviewed any portions of the RFP?
I reviewed a portion of the statement of work.
Okay, and maybe a portion that related to
Recipient rights.
Okay, great, because that's what I want to talk to you about. Now, you first learned of the decision to competitively bid the PHIPs back in early August of 2025?
Correct.
But you were not involved in developing this RFP, is that right?
Correct.
Sorry.
Correct.
You had no role in drafting the RFP language, right?
No.
Okay. You didn't review the RFP before it went live.
No.
And you didn't provide revisions to the RFP before it went live for bidders.
No.
But you have reviewed that one or portions of the RFP related to recipient rights after it went live, after it was posted for potential bid.
Correct.
Okay. When you reviewed that, I'll call it pertinent portion of the RFP, did you have some concerns about the language?
Yes.
Am I correct that you expressed or had concern that the RFP as written removes CMH's ability to contract for delivery of services with providers of mental health services?
That was not my concern.
What was your concern?
My concern was that the recipient rights system is established for the department, MDHHS, for CMHSPs and for licensed psychiatric hospitals. And currently the PIHPs contract with the CMHs for services. Therefore, the recipient rights system there's no gap in that process. But my concern was for any PIHP that was contracting with non-CMH providers and how recipient rights was going to be addressed for those non-CMH providers.
Understood. So the way that the RFP is currently written, in your experience, there could be a gap in recipient rights services.
There could be, it wasn't clear.
It wasn't clear, and that gave you concern.
Correct.
Okay. Currently, CMHSPs provide and conduct trainings, is that right, for non-CMHSPs, beneficiaries of Medicaid services?
They're required to ensure that those trainings
They're,
are received.
they're statutorily required.
Yes, not to provide them, but to ensure that they are taken, that they're received.
Right. And they are also statutorily required to conduct recipient right services. So maybe take complaints and follow up on those complaints. Is that
Yes.
also correct?
Yes, they are required to either do that or ensure that rights protections are there. Yeah.
Okay. And the way that the language in the RFP is currently drafted, those requirements aren't clear with potential successful bidders.
Can you repeat that question, please?
Sure. The way that the RFP language is currently written, you identified a potential gap in recipient right services.
Objection as to foundation.
Sorry, objection, what?
Foundation.
Oh, okay. I thought she already said that.
She did, and I did set up the,
Right, right.
the
I'll
knowledge,
overrule it.
the
Right.
status.
She just said exactly that.
I think the earlier testimony was she didn't look at the whole RFP.
No,
So
no,
I don't
but
know that
she, right, but she said she identified a gap. I mean, it's almost, I think the question is almost verbatim what the testimony
It
was.
is, I'm glad I'm re-asking it because apparently there is confusion. So I will ask you the same
Right, no,
question again.
I'll overrule the objection.
Thank you, Your Honor. The way that the RFP language that you reviewed is currently written, there's a potential gap in recipient right service.
Yes, there's a potential gap.
Okay. Did you raise these concerns for MDHHS leadership?
Yes.
But as you sit here today, do those concerns that you have about recipient right services in the current RFP, do you still have these same concerns?
I haven't been made aware of any changes.
Thank you. No further questions?
Very well. Cross-examination.
Hi, Ms. Postma. How are you doing today?
Good.
Finally nice to see you in person. Again, we met before, Scott Damage. So a few follow-up questions here. Housekeeping matters. You're not a lawyer, right?
Correct.
Okay. And you have three decades of experience with recipient rights within MDHHS or DHS, whenever it was that, correct?
Yes, almost 3 decades.
Okay. How many decades of experience do you have with DTMB?
None.
Okay. Okay, and when it comes to, so have you ever handled a procurement of a state contract before?
No.
Have you ever been part of the process of one?
Yes.
Okay. Do you remember there being what's what's called a contract integration phase?
No.
No. Are you familiar with the fact that after a bidder is selected, that there can be changes made to the underlying contract?
I am not familiar with the process.
Okay. Would it make you would it lessen your concern to know that the RFP in its current form can be changed?
Yes.
Okay. Would it also lessen your concern that the contract might not exactly mirror the RFP? And in fact, it might include some of the areas of your concern, right?
Yes.
Okay. Now, you had previously testified the RFP doesn't, you didn't review the whole RFP, correct?
Correct.
Okay. Would you have any reason to dispute the statement that the RFP doesn't have anything to do with recipient rights?
Can you repeat that?
Yeah, sure. Do you have any reason to believe, or any reason to believe that this statement is not true? That the RFP doesn't have anything to do with recipient rights?
Yes, if I'm getting the double negatives
There are
correct.
a lot of negatives in there. Right.
So the current, I believe the current RFP does have language in it that refers to recipient rights.
Okay. Now, do you believe that the CMHPs will still handle, the CMHSPs will still handle recipient rights?
I don't know.
Okay. Is that because you haven't reviewed the entire RFP, you think?
I don't know because there could be options depending on whether the RFP is changed, whether there's contract negotiations, whether there's changes in language.
So there is an option from the RFP, correct?
I believe there are some options that recipient rights could be addressed in the RFP.
And could that be through contract changes?
It could be.
Okay. Um, okay. Is there any, have you been told that you're going to not be involved in the solicitation process or the formation of the contract after a bid's selected?
No.
Okay. I have no further questions, Your Honor.
Okay, thank you very much, Mr. Damish. Appreciate it. Any redirect examination? Very well, let me just check the time. There we are. Thank you very much. Ms. Postman, you may step down. Thank you so much for being here. She doesn't know. Okay, at this point, everybody tell me when you want to take a break, because I can keep going for a while or not. It's up
The
to you.
next witness, I don't think will take very long, Your Honor.
Okay, how about a break after this witness? That's good.
Great.
Thank you for the help.
You're welcome.
I didn't want to launch into a 2-hour witness at this
Understood.
point.
Okay, we'll call Angela Smith Butterwick.
There you go. They might be trying to make some. Yeah, sorry. This is cumbersome.
Should I try the other side this time or? stay
You
over
can
here?
try wherever you
All
want.
right.
It's kind of like a pommel horse. People can work it. Would you please stand and raise your right hand? I'm sorry about that.
No problem.
You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Before we get started, please tell us your first and last names and spell your first and last names for the court reporter.
Angela Smith Butterwick, first name Angela, last name SMITH-BUTTERWICK.
Okay, thank you very much, Ms. Smith Butterwick. And whenever you're ready, you may proceed
Great,
with
thank
direct
you.
examination. Thank you, Ms. Workman.
Ms. Smith Butterwick, what is your role with MDHHS?
I'm the Division Director for Substance Use Gambling and Epidemiology under MDHHS.
Okay, and Your Honor, just to clarify, I'd like to treat her as an adverse witness.
Yes, that's fine.
Thank you. Were you one of the subject matter experts for the RFP?
Yes,
And were you specifically one of the subject matter experts for the RFP as it relates to SUD services?
yes,
In fact, did you serve on the core team that drafted and revised the RFP SUD language?
yes,
Is it your understanding that SUD services in Michigan are governed under the mental health code?
yes,
And is that chapter 2A?
yes,
Would you agree that SUD services must be provided for by a department designated community mental health entity with assistance from a community mental health services program provider network?
The SUD services do need to be provided for by a department designated CMH entity. However, then the PIHPs or those CMH entities then contract with a provider network of licensed SUD providers. Those could be CMHSPs, but they're not always.
And they could be CMHSPs or regional entities, correct?
For the community mental health entity that's department designated, yes.
In fact, they have to be either a regional entity or a CMHSP in order to be department designated, correct?
They have to be a regional entity or department designated, yes.
And you testified in deposition that you, as the subject matter SUD expert, never considered the department designated community mental health entity mental health code language when reviewing the RFP. Is that correct?
That's correct.
I believe you also testified that MDHHS has not begun to figure out how to operationalize SUD services under this RFP. Is that right?
That's correct.
Is it your understanding that the plan calls for 2 PIHPs per region?
Yes,
Is it also your understanding that universities cannot receive SUD block grant funds under the CFR?
Yes,
And that nonprofits may, but that splitting funds across two PIHPs would be very difficult?
yes,
Is it also your understanding that beneficiary routing between two PIHPs is unpredictable, requiring constant contract amendments to rebalance funding and maintain 12-month coverage?
I don't have any information on that as I don't do the Medicaid contracts.
Do you have information on what happens if a PIHP doesn't accept block grant funds under this RFP?
Yes,
And what happens if it doesn't accept those block grant funds?
they're still required to provide the services to uninsured and underinsured.
And so they would be required to provide services without receiving payment for those services?
Correct.
And is it accurate that MDHHS has never operationalized this two PIHP funding split, nor developed a plan to do so?
Not that I'm aware of.
I don't have anything further.
Thank you very much.
Thank you.
Cross-examination, please.
Good afternoon, Ms. Smith Butterwick. How are you?
Good, how are you?
Good. So I understand that your involvement, as you had testified, from the DHHS side was with the core team, correct?
Correct.
And you were the SUD subject matter expert.
Correct.
And SUD is substance use disorder is what it stands for as an acronym,
Yes.
right? Now, plaintiff's counsel has made a point of asking about how SUD services will be administered under this new RFP, and if it's successful, the new PIHPs that are selected through this competitive procurement process. And plaintiff's counsel was asking, you had indicated these department designated community mental health entities are the entities that are funneling through these SUD funds. Is that correct?
That's correct.
And a regional entity can be a department designated community mental health entity. Is that right?
Yes.
Can a CMHSP be a department designated community mental health entity?
Currently, only the 3 single county CMHSPs can.
So only in Wayne, Macomb, and Oakland
Correct.
counties. Is it possible that this, under the new system, that the state, well, let me back up. Are there, let me go forward with that. So under the new process, is it possible that the state could contract with CMHEs and still be able to administer SUD services?
Yes.
And there was discussion about nonprofits or public universities potentially not being able to be a department designated community mental health entity. Do you agree with that?
The Code of Federal Regulations prohibits a public university from being awarded our block grant funds.
Okay. And what about nonprofits?
The Code of Federal Regulations is set up in such a way as to make it very difficult for a for-profit organization to be awarded our funds because it has to be offset by any money that they take in.
Okay. And under the RFP, as it is currently structured and has been issued, bidders can be either a nonprofit, a public university, or a public entity or governmental organization. Are you aware of that?
Yes.
Okay. So it's possible that a public entity or governmental organization is awarded a bid and able to administer these SUD funds in the specific regions that they're assigned. Is that
Yes.
fair?
Yes.
And examples of those public entities or governmental organizations could include even the CMHSPs or regional entities. Is that fair?
Yes.
There was also discussion about the SUD block grants not going to universities. And so you had mentioned it's possible under this new RFP that there could be 2 PIHPs per region under this new RFP process, correct?
Yes.
In fact, there could be more than 2 potentially.
Correct.
So if say a non-university is selected as a PIHP for the new northern region under this RFP process, so a non-university that can administer SUD funds or SUD block grants is selected, it's possible that a university could still be selected as a PIHP, hypothetically, for that same region, but not administer SUD services. Is that theoretically, hypothetically possible?
Yes, they wouldn't be able to administer SUD block grant services.
Okay. And as of today, are you aware of whether any contracts have been entered into with any entity under this new RFP process?
Not that I'm aware of, no.
As of today, are you aware of whether any bidders have been selected for the award of a PIHP contract under this RFP?
No, none have.
And is it fair to say that to your knowledge, there has been no decision as to what entities, university, nonprofit, public or governmental organization, there's been no decision as to what entities will be selected to serve as a PIHP in any of the new 3 regions?
That's correct.
And because no decisions have been made as to what entities will be selected to serve as a PIHP in these regions, DHHS so far, at this point, has been unable to determine exactly how these SUD services will operate in those new 3 regions. Is that correct?
Yes.
In fact, decisions about how those SUD services will operate cannot be determined until DHHS knows who those new PIHP entities will be. Is that right?
Yes.
So it's fair to say that as of today, any concerns related to this administration of SUD services being contrary to law or illegal is completely speculative at this time.
Correct.
No further questions, Your Honor.
Thank you very much. Any redirect, Ms.
No,
Whitson?
Your Honor.
Thank you very much. Very good. You may step down. Thank you so much for being here. Now, I think we've reached a good point to take a break. Why don't we do this? It's 2:50. Why don't we come back at 3:05? Is that?
I've got one small housekeeping matter.
Oh, yeah, of course. Go ahead. Sure, of
For
course.
just break. We talked about it earlier, but is it the court's intention to adjourn at noon on Tuesday? Or do you want to run through?
It depends what you all can tolerate. If you can walk and chew gum at the same time, in other words, if people can do depositions while the hearing's going on, I'll be there and available.
Okay.
So to the extent that you have a scheduling order that says something contrary, that was just my understanding of what worked best for you.
Right.
If what works best for you is just to keep going while you have people warming up in the bullpen, that's fine with me.
Okay.
I'll sit out there for 3 full days if that's what it comes to.
Okay.
Okay?
Fine, just. wanted
Okay,
some
yeah.
clarification.
I mean, obviously, I'm keeping track of time here. I haven't any idea
Right.
when we're ultimately going to hit the top for anybody, but we're nowhere near it right now.
I mean, with the weather, I think it might make sense to keep running it, but
Sure, that's fine. Whatever you like. Right.
Okay.
All right, I don't have anything else. That
Okay.
was just, I was just getting. some
No, that's fine.
clarification.
And at the end of the day, I'll give you a minute count, but everybody's really being responsible with their time. We're not running into any problems at all. So thank you very much.
Yeah. Okay, so Andrea's
I'm just thinking like in terms of witnesses. And get their attention. We have to decide on those other ones. Yeah, but.
Thank you.
So actually, you guys.
Virginia Court of Claims now in session.
Okay, thank you very much. Mr. Ryan, I see you standing at the lectern. Does that mean you have the next witness?
I was just keeping it warm. Yeah, no, I do have, I do have the next witness. Your Honor, plaintiff's call, Kristen Morningstar.
Welcome.
Chris, yeah, we call Kristen.
Welcome back, Ms. Morningstar. You spent a lot of quality time with us a few weeks ago. Yes, that's fine. Mr. Shuriel, how are we doing?
You can
Good?
throw them all in my black thing. if you
All set?
want.
Also,
All set? Okay. Please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you very much. Please have a seat. Although you have graced us with your presence once before in the course of these proceedings, please tell us your name again and spell your first and last names for the court reporter.
Sure. Kristen Morningstar, KRISTEN MORNINGSTAR.
Thank you very much, Ms. Morningstar. And Mr. Ryan, whenever you're ready, you may proceed.
Thank you. Ms. Morningstar, we've met before at the last hearing, correct?
Yes.
All right. I'm going to ask you some questions today. We've already taken your deposition, so we've got a lot of the testimony already, but I want to highlight some things for the judge, okay?
Okay.
Can you state your occupation and your employer?
I am a state bureau administrator for Michigan Department of Health and Human Services.
Judge, just for the record, I do intend to ask her leading questions.
That's perfectly fine. Thank you.
You oversee all aspects of the PIHPs and their compliance with state contracts, true?
I do.
You are the program manager for the PIHP procurement, correct?
Yes.
And you have the authority over what constituted managed care functions under the RFP and whether those could be delegated, didn't you?
Yes.
The managed care functions are one of the core features of the RFP, true?
Yes.
Changing that feature would change the structure of the RFP, wouldn't it?
I'm sorry, can you repeat that?
Yeah, changing that feature, the managed care functions, would change the structure of the RFP, wouldn't it?
Yes.
Under the RFP, those managed care functions cannot be delegated by the PIHPs that are chosen, correct?
Correct.
A CMHSP under the RFP cannot independently contract with a provider for Medicaid specialty behavioral health services. Isn't that true?
Can you repeat that one?
Yeah, under the RFP, a CMHSP cannot independently contract with a provider for Medicaid specialty behavioral health services. True?
I don't know that we said that that was absolutely true. We were talking about managed care functions.
Yeah, but under the managed care functions, a CMHSP cannot independently contract with a provider for Medicaid specialty behavioral health services, correct?
I don't know that that's true. So we talked about that and I said that I would need additional counsel on that, but we also talked about the managed care, the core managed care functions that couldn't be delegated.
Can I
And
approach the witness, Your
ability to contract wasn't, oh,
Yeah, you may approach, but everybody has standing authority to approach witnesses if you want to. Just don't do it in a menacing way and be
you know.
Chris?
Just to be clear, I take it we're about to impeach with deposition testimony. And so these would be prior inconsistent statements under oath admissible as substantive evidence as opposed to mere impeachment, correct?
Correct, yeah.
Right.
I don't need to answer for Mr. Ryan.
Right, but, right, as long as it's a statement made under oath, it's substantive evidence. Just wanted to be clear. Sorry, Mr. Ryan. Mr. Marchand did a nice job
Sorry,
of
man.
handling
The page, I figured.
an evidentiary issue for you.
But you know the page number. What? 99?
I've turned the binder to
Okay.
exhibit 99. Can you turn to page 57, please?
This is her deposition, I presume.
It is. And I just want you to read to yourself lines 17 through 23. And then let me know when you've done that.
Sorry, you said you were on. This
Page
is
57.
page 110.
Nope, 57 is what I want you to turn to.
While she's doing that, Mr. Marchand did a nice job of agreeing with me that this is prior testimony under oath, so it's substantive evidence. It's not just for impeachment, so you don't have to refresh. This comes in as substantive evidence.
Appreciate that. Thank you, Mr. Marchand.
You're welcome, Mr. Ryan.
For the
Okay.
record, I did not approach her in a menacing way.
I know. So noted.
Okay, I'm not finding this. Are these in numerical order here?
Oh, I'm sorry. Let me help you.
This page, so it's like 110, 111. Okay,
You were
what
asked,
was the line again?
yeah, so you were asked, line 17 through 23, you were asked, under the RFP's managed care functions, a CMHSP cannot independently contract with a provider for a Medicaid specialty behavioral health service, right? And your answer was,
My answer was correct.
can you turn to the other binder in front of you, tab 136, please?
This is binder number 3, right?
Yeah, volume 3, yes,
Say the number again. I'm sorry, Mr. Ryan.
136.
Thank you.
I'd like you to flip to the second page of that. MCL 330.1309. Do you see that?
I do.
You agree with me that that statute requires specialized residential services to be provided by CMHs?
I'm gonna object, this, ask her to speak to a statute, what it says. So it'd be a little, the document speaks for itself as well.
Right, right. I mean, I don't know that she has to agree with this. Why don't you just direct her to the provision you want to discuss, Mr. Ryan, because I don't think this is even debatable. What we're looking at now, I think, here is the entire mental health code section dealing with state and county financial responsibility, right?
Okay, here's the question, Ms. Morningstar. You don't know how a CMH is going to be able to fulfill its statutory obligations under section 1309 if the CMH can't contract for Medicaid specialized residential services, do you? You don't know how
I don't know
CMH
how.
can fulfill its role, do you?
In terms of the mental health code here?
Yeah, the provision in 1309 that requires specialized residential services to be provided by CMHs, you do not know under the RFP how the CMH is going to be able to fulfill that obligation, do you?
Explicitly, no.
Exhibit 138, please.
Tab 138?
Correct.
Okay.
That's MCL 330.1422. You also don't know how a CMHSP can fulfill its role, its statutory obligation under section 1422, given the RFP statement that a provider contract has to be performed by the new PIHP. Isn't that true?
I'm gonna object to S for legal inclusion, statute written in front of her, and he's asking her a set of facts and say it's true.
Well, I'm not. I'm asking, she doesn't know how they can fulfill their
Right.
obligation.
Based upon our experience, do you know how they could?
Figure.
And if so, can you explain how they would?
Right, no.
You're familiar with minor screening functions that need to be performed by CMHSPs, aren't you?
Yes,
And that would include suitability of a minor for hospitalization, correct?
yes,
And those CMHSP duties are not referenced as an exception to the non-delegable managed care functions in the RFP, are they?
no.
If the department is allowed to proceed with this RFP, you don't know how a CMHSP can still comply with its managed care functions required by the statutes relating to minor screening functions, do you?
Explicitly, no.
You can't say whether the RFP impacts CMHSP's emergency services for civil admissions functions, can you?
Under the new RFP, no.
In fact, you're not able to say whether the RFP takes anything away from CMHSP statutory functions, are you?
I'm sorry, can you repeat that question?
You're not able to say whether the RFP takes anything away from CMHSP's statutory functions, are you?
No,
SUD services are a core service under the RFP, aren't they?
yes,
And the new PIHPs have to meet the requirements of Chapter 2A of the Mental Health Code, correct?
yes.
I know that you were sequestered, but I'd like you to assume that Ms. Smith Butterwick testified that the department doesn't know how that to operationalize the SUD provisions of the Mental Health Code after if the new RFP goes through. Would you agree with that?
Were you asking me to assume that that was correct?
I'm asking whether you would agree if that was her testimony.
I wasn't here to hear her testimony.
I understand.
I don't have any reason to doubt that.
In other words, you don't know how SUD services are going to be operationalized under the RFP if the new PIHP is not either a CMHSP or a regional entity. Isn't that true?
As I sit here today, no.
MDHHS didn't conduct a complete analysis about whether the CMHSPs can fulfill their statutory obligations without Medicaid funding before it issued the RFP, did it?
No.
In fact, you don't know what analysis has even taken place, do you?
In terms of ability for CMHs, I mean, our understanding and our intent was that CMHs would retain functions.
Whether they actually can or not, the department hasn't done any analysis on that, have they?
I don't know.
And those obligations of the CMHSPs would include providing necessary services without regard to the individual's ability to pay. Isn't that correct?
Can you repeat that one?
Yeah, the obligations of the CMHSPs include providing services to individuals without regard to that individual's ability to pay for those services.
Correct.
Ms. Postma, Ramey Postma is the director of the State Office of Recipients' Rights, correct?
Yes,
She reports by law to Director Hertel only, correct?
I believe so. Yes,
Aware that she's worked in the department for about 30 years, correct?
yes, longer than I have.
She's the subject matter expert on recipient rights.
Correct.
Are you aware that she raised concerns about the RFP as it relates to recipient rights after the RFP was issued?
I'm going to object to the relevance of this line of questioning, whether what concerns were raised internally within MDHHS is not really relevant to what's at stake here today. So I asked.
I think that's fair. I mean, her testimony stands on that question. Now, it may be Ms. Morningstar will confirm that same testimony, but
Yeah, part of the relevance, Your Honor, is she's the architect of this RFP.
I
And,
understand.
and so whether there are concerns raised by the subject matter experts within her own department, I think is highly relevant to whether the RFP complies with the law.
Well, let me put it this way. Why don't you ask her the question first, whether she shares the concern that Ms. Postma has? Because if that's not her area of expertise, I don't want to put her on the spot here and ask her whether Ms. Postma is right or wrong. That seems an odd way to do it.
Thank you. Your
Let
Honor.
me ask you
Right,
this.
look, but my point, Mr. Ryan, is Ms. Postma has already said what she said, and I think everyone seems to agree she's the subject
Okay.
matter expert.
Fair enough. Ms. Postma wasn't the only person that raised concerns about the RFP. Isn't that true?
I'm sure that's true.
Did the MDHHS's consultants, Milliman, raise concerns?
Yes, they had questions.
You recall writing an email to Ms. Asman stating, quote, Milliman highlighted language that could be problematic.
I don't recall the exact email, but yeah, that sounds familiar.
Under the RFP, the new PIHPs are going to handle utilization management, correct?
Yes,
In other words, they're the ones that will decide whether to approve or deny services that are requested by individual recipients, right?
yes, in the broader managed care function, yes.
And the new PIHPs, the way that the RFP is set up, they're going to get to keep a portion of savings under that contract. Isn't that true?
Yes,
So the new RFP sets up a system where the new PIHPs have a direct financial incentive to deny services, don't they?
I'm gonna object to lack of foundation.
I'll overrule that objection.
Thank you, Your Honor.
It seems to me, right, it seems to me that she may be able to answer this.
Well, she designed the RFP.
Right,
so,
no, I got
Yep,
it, I got it,
yeah.
right. That's why I'm overruling the objection.
Thank you.
Fine.
Go ahead.
I'm sorry, can you repeat it?
Sure.
Thanks.
The new RFP sets up a system where the new PIHPs have a direct financial incentive to deny services, don't they?
I wouldn't consider it in that way, but yes, they could, right? But there are other mechanisms to prevent that from happening.
If they deny services and money doesn't go to pay for services, and they meet their medical loss ratios, they get to keep a portion of the proceeds. Isn't that right?
That's correct. However, there are other avenues to prevent that from happening.
You've never been a part of any conversation where CMS asked MDHHS to seek any changes to the mental health code. Isn't that true?
As far as I can recall, yes, that's true.
CMH has never threatened to revoke federal funding if existing PIHP boards were not reconstructed. Isn't that true?
Okay, object, I'd like, you said CMS?
Yeah, I think you just said CMH.
CMS?
Let me try again.
Yes.
Okay. Yeah, repeat, please.
CMS
Okay.
has never said anything to you in terms of threatening to revoke federal funding if the PIHP boards were not restructured. Isn't that true?
That is true.
And they've never threatened or even suggested that they'd revoke Medicaid funding for any reason. Isn't that true?
That's true.
You can't answer whether a CMH's statutory rights are violated by the RFP's provisions, true?
I'm not an attorney. No,
The answer is true.
I'm sorry. The answer is true.
You don't know how the department plans to address statutory conflicts between the RFP and the mental health code, do you?
As I sit here today to go through each, no.
The procurement process started in what, February 2025?
I would have to go back and look at exact dates.
You started talking about going to competitive procurement though back in October of 2024. Isn't that true?
As an option, yes.
So in terms of how the RFP is actually going to be put into place, we're 14 months after October of 2024. And you would describe it as still what, a work in progress?
I would say there are still details that need to be addressed. Yes,
Work in progress. True.
correct.
And MDHHS is supposed to sign contracts in February of 2026, correct?
That was our original timeline.
That's about, what, 2 months from now?
Yes.
Bidders haven't even been selected, have they?
No.
Any idea when that's going to happen?
I don't have an exact answer for that.
This drafting of the RFP was fast paced, wasn't it?
I would say probably.
Ultra accelerated timeline, as one witness put it. Do you agree?
I don't know if I would agree with that, but it was,
MDHHS didn't build in any time for relevant areas of MDHHS to review and provide feedback on the RFP, did it?
I'm gonna object to the extent that feedback on the RFP doesn't really address the legality of the face of the RFP itself. So I don't think this is really relevant.
Mr. Ryan, this is obviously really important testimony, but I'm going to sustain that objection. I'm
Thank
much
you.
more concerned about what we have before us now in the RFP than how it was developed. I get your concern about the fact that it was rushed through.
Suffice it to say, this RFP was put in place to force a change that MDHHS wanted to see. Isn't that true?
I'm gonna.
I think that it was a result of a change.
The annual impact of the RFP is about 6.4 billion. Is that right?
Check the foundation.
You want to see if she knows that number?
Do you know whether the financial impact is about $6.4 billion
It,
per year?
it fluctuates every year. Right now, we're at about $6 billion.
Nothing further.
Thank you very much. Let me just get time on here and we'll get started with cross-examination. I'm sorry to hold you up, Mr. Beach. Okay, sorry, I apologize.
Hold that title.
Okay, Mr. Beach, whenever you're ready.
Thank you, Your Honor. Ms. Morningstar, are you the architect of the RFP?
The sole architect? No.
Are you the RFP's designer?
No. Sole designer? No.
Mr. Ryan gave you a little bit too much credit there when he asked the question.
Yes, I would say so.
And it's true, he asked you a lot of questions that you didn't know the answer to, both today and in your deposition, correct?
Yes.
And the reason you don't know the answer to that question is because you don't know who the entities are that are going to win the bids, right?
That is correct.
And you don't know what their contracts are going to look like either, do you?
Not exactly, no.
And you also have a fairly large legal team that when you're drafting the RFP, gives you input on the legality of various terms, correct?
Yes, correct.
And that's not part of your role to analyze it from a legal standpoint, correct?
No, that is not my role.
And you don't know, standing here today, what, if any, contracts will be needed to effectuate the terms of the RFP when it goes into a contract, a final contract, correct? If there will be, this is a compound question, I apologize, but if there'll need to be any additional contracts when the bidders are awarded contracts.
That's correct.
Can I ask you a question based on your experience? Will all of the contracts between MDHHS and each one of the new PIHPs be exactly the same, or will they differ from PIHP to PIHP?
Yeah, that's a great question. I think depending on the type of entity, we're going to have some differing contractual requirements. It might be the same contract with some applying to different entities. I'm not exactly sure what the end result would look like, but
But it doesn't have to be uniform.
it doesn't
across all-
have to be uniform.
Thank you.
Mm-hmm.
And I think we already covered this, but in terms of you not knowing the answers to things, but you were asked about whether there was any analysis by DHHS about CMHSPs and their ability to provide services. Remember being asked about that?
I do remember being asked about that.
And you testified that you didn't know, but it is possible that other people working on the RFP or at DHHS could have done that analysis, correct?
Speculation.
I'll let her answer as to the possibility.
I
But
would just.
I don't want you to go from the possibility to the assumption that it occurred.
Right.
You understand?
I understand.
And that's not what I was asking, Your Honor, if I
Okay, that's fine.
awkwardly worded.
Oh, try again then, Mr. Beach.
Okay.
That's fine. Thank you.
And you wouldn't know, correct, if other people from MDHHS did any analysis regarding the ability of CMH SPSs to provide services.
I would not necessarily know.
And you were also asked if there were concerns that were raised by Milliman. Do you remember that?
I do remember that.
Is that part of the process that you seek input from entities like Milliman as you're drafting about various terms?
That was certainly part of the process that I was leading. Yes, getting additional input.
I'm sorry to interrupt, Mr. Beach, but can you spell that Milliman or Malaman, please, for the court reporter?
I can, yes. It is Milliman.
Thank you.
You're welcome.
And what is Milliman?
It's our contracted actuaries.
I got it. Thank you very much.
Yes.
Sorry, Mr. Beach.
And you were also asked about CMS. Do you remember that?
Yes,
And you testified that CMS expressed concerns to you about the current system.
I did previously testify that they have expressed concerns.
And today you were asked if CMS ever threatened you, correct?
Yes,
And you testified that they never threatened you.
right,
But
correct.
just like the same question that I asked before, you don't know if CMS threatened other people at MDHHS, do you?
I don't know that.
All that you can testify as to strike that. The only thing you can testify is to your interactions with CMS.
Correct.
And it's true that some of the current PIHPs don't have contracts, correct?
Yes,
And they're currently under a transition clause, correct?
yes.
Are you aware that the transition clause in the current contracts is set to expire soon?
I am.
And to your knowledge, do federal regulations require that contracts be in place?
Yes,
Is there a risk of loss of federal Medicaid fundings if there are no contracts in place for PIHPs in Michigan?
yes.
And what steps would MDHHS have to take if beneficiaries in half of the PIHP regions in Michigan suddenly were not enrolled in a PIHP?
We would have to take immediate action to figure out a way to make sure that they are enrolled in a PIHP.
How many of the PIHPs are shortly going to be operating without contracts?
Yes, so it would,
10 now, right?
yeah, there are 10 PIHPs. 5 did not sign their 24 contracts, but only 4 did not sign their 20. I'm sorry, I think I misspoke. 4 did not sign their current fiscal year 26 contracts.
Judge, did you follow up to that or was that the question?
No, that's fine. Thank you. I'm just trying to understand. I know there was some discussion about this.
Um, And just to clarify, to your understanding, they're currently under a 2-year transition clause?
That's correct. It's the language in the contract says up to 2 years. So that was the deadline that we were operating against.
And can you tell us when is that set to expire?
Yes, September 30th, 2026.
And just one final question to make it clear for the record. You are not an attorney, correct?
I am not an attorney. That's correct.
All right. Thank you.
Thank you, Mr. Beach. Redirect, Mr. Ryan?
Very briefly. This Morningstar, gotta believe if CMS issued a threat to one of your colleagues in the department that they might pull all of the Medicaid funding for the state, you'd probably know about it, wouldn't you?
It's probable that I would know about it.
Okay. The contracts that you say aren't in place, there are contracts in place. You're operating within the 2-year transition clause. Isn't that true?
Correct.
Right. And can you flip to tab 89 in binder? It's volume number 2.
You said volume 2?
Correct.
Okay. And what was the tab again? Sorry.
89. There are actually 5 PIHPs operating under that transition language, not 4. Isn't that right?
From the 24 contract?
Yeah.
Yes, that's correct.
Right. And 89, Exhibit 89 is affidavits submitted by every single one of those 5 who said that they stand ready, willing, and able to continue providing services beyond October 26 under the status quo, correct?
Yes,
You've seen those before, correct?
I have seen these.
These were filed, given to the department on September 29th of 2005 or 2025, correct? Approximately.
That I have no reason
Has the
to disagree
department
with
reached
that.
out to any one of those PIHPs to say, hey, look, we got this impending deadline. We want to extend the contracts a year?
Your
Have they
Honor, I'm
done
gonna
anything like that?
Your Honor, I'm going to object to this because again, your order specified we're dealing with the legality of the RFP itself. This line of questioning is going outside the legality of the face of the RFP.
I don't
Well-
disagree with that. It's just Your Honor actually asked the witness questions about this deadline.
Right,
And so
well,
I'm-
right. All I was trying to understand is, I knew there was tension between some, but not all of the PIHPs and the MDHHS. What I was trying to figure out is, for those operating under the transition clause, when they bump up against a hard deadline, and I think you've now answered that by saying it's the end of the fiscal year in which we now find ourselves.
Yes, that's
Okay.
correct.
Yep.
And Ms. Morningstar, that deadline could be extended if the department worked with those PIHPs to extend that 2-year period, couldn't it?
I don't know that that is a possibility.
Why not?
If they aren't signing our contract,
If the department approached those PIHPs and said, hey, we want to extend this an additional year. Let's create a 1-page amendment to the contract that says we're changing the transition language from 2 years to 3. Why couldn't you do that?
that would be a procurement question. I'm not sure that we can do that.
Done it in the past, haven't you? Extended contracts when there's been contract negotiations, you've done 1-year extensions, haven't you?
We operate on a new contract each fiscal year
Really?
for our PIHPs.
Yeah, for the PIHPs. You're saying no PIHP has ever had extensions to their contract?
I can't speak to if that's ever happened. I don't know if that's happened.
Okay, that's all I have. Thank you.
Thank you. Let me get the time on that. Any recross examination?
I don't have any recross, no, Your Honor.
Okay, thank you very much. Let me put that time in here. Ms. Morningstar, you're free to go. And I
Thank you.
expect we will not call you back again.
Okay, thank you.
Thanks. I think twice is enough.
There's new.
I'm not ready. We're not ready.
I take it you have the next witness.
I do. And it will be.
No, you can't go down. We're making this as challenging as possible.
Look at me.
I can't blame everybody for
The
being
first test.
confused. Okay, before you sit down, ma'am, I need to swear you in. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I did.
Thank you so much. Please have a seat. Make yourself comfortable. Once you're comfortable, please tell us your first and last names and spell your first and last names for the court reporter.
Okay, I'm getting there. Your seats are kind of low.
Sorry.
Okay, my name is Jacqueline Coleman. First name, capital JACQUELINE. Last name Coleman, capital COLEMAN.
Thank you very much, Ms. Coleman. And whenever you're ready, Mr. Ryan, you may begin.
Thank you. Ms. Coleman, you're employed by MDHHS?
Yes,
Your Honor, I'll plan to ask some leading questions.
That's fine. You can certainly ask leading
Thank you.
questions.
Ms. Coleman, Ms. Postma testified earlier that she's been employed by the department for about 30 years, but you've actually got her beat. You've been with the department for 37 years, isn't that right?
yes,
All right. And you're currently the federal liaison for the Medicaid program, is that correct?
correct,
You've served in that role since 2009, correct?
correct,
You're responsible for all the waivers that the Medicaid program employs, correct?
correct.
You serve as the central point of contact for submitting documentation between Medicaid and CMS, correct? Or excuse me, between Michigan and CMS
Depends on the documentation. Can I? Yeah.
for behavioral health services,
Well, not all behavioral health services.
for the waivers.
For the waivers.
Thank you. All communications to or from CMS relating to those waivers are within your scope of knowledge, correct?
Correct,
And you'd expect to be involved in communications with CMS relating to conflicts of interest under the Medicaid behavioral health waivers, isn't that correct?
correct,
And you'd expect to be informed if CMS had ever threatened, suggested, or even hinted at revoking Medicaid funds, correct?
correct,
You've never been informed that CMS has even remotely suggested revoking Michigan's Medicaid funds for behavioral health services due to conflict of interest, isn't that true?
that's true.
You cannot even recall CMS ever saying there were impossible conflicts of interest in the current system, correct?
That is not a correct statement.
Do you recall CMS ever saying that there were, well, I'll strike that. You have no recollection of any communications about CMS requiring MDHHS to separate payer and provider functions for all Medicaid behavioral health services beyond the existing conflict of interest regulations, correct?
Correct,
CMS approved the HCBS waiver for behavioral health services in late 2004, correct?
yes,
That was a 5-year approval with the existing PIHPs, correct?
correct.
No further questions.
Thank you very much, Mr. Ryan. Sorry, let me get the time down here. All right. Okay, cross-examination, please.
Hi, Ms. Coleman. Nice to see you again. Are you the only person that would hear from CMS?
No, I am not.
Okay, so there could be other people within the department that could have heard the
Yes.
concerns of CMS. Okay, do you remember testifying about a document that was submitted by, I believe it was, I forget to say it, not providers, but advocates?
Yes,
Can you talk about that document for a little bit?
Advocacy group sent CMS a letter.
Okay.
It was in March of 2024. It went to Centers for Medicare and Medicaid Services state lead.
Okay.
The state lead turned around and submitted that memo to the Medicaid director.
Were you the state lead?
No, CMS is state lead.
Gotcha. Okay.
CMS has a
Gotcha.
state lead. So the letter went from the advocates to CMS state lead.
Okay. And do you remember if seeing a document where CMS had expressed any concerns with the document?
They expressed concerns with the document, so that's why they sent it to the Medicaid director, and they wanted to obtain the state's feedback to determine if what was being sent, if it was true, and why would the advocates send that to CMS.
Okay. And what happened after that?
After that, an internal meeting was held, and then a meeting with CMS was scheduled to discuss the memo.
Okay. Do you remember seeing a copy of this memo or the advocate letter with comments on the side from CMS?
I don't recall.
Okay. I don't have any further questions. Thank you.
Thank you. Any redirect examination?
No, Your Honor.
All right, thank you very much. You may step down. Thank you for being here, Ms. Coleman. I appreciate it. Schedule.
Sure, I guess I'm up to bat.
What? Okay, have we exhausted all of the witnesses for all of you?
Well, we have Ms. Middleton's depositions tomorrow.
Correct, right, yes, yes. I just meant for the day.
Sort of, we.
Sorry, I shouldn't have been clear.
Yeah, so there are some witnesses that we may end up calling, but we told the state they're gonna be Tuesday witnesses. We moved a little bit more efficiently this afternoon than we had anticipated, so Mr. Cook's gonna call a witness so we can use this time.
That's perfectly fine. No, I will never be disappointed to find out that we're running ahead of schedule.
Miracles happen.
Yeah, I've been in touch a long time. I don't think I've ever complained about that once. All right, Mr. Cook, come on up. All right. It's gonna get even more challenging to get the witnesses to the witness box. Before you sit down, please raise your right hand. You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth. Thank you so much. Have a seat, please. Before we get started, please tell us your first and last names and spell your first and last names for the court order.
Yes, my name is Nina Sork. First name is Nena. Last name is Sork, Sork.
Thank you very much, Ms. Sork. And you may proceed with direct examination.
Thank you, Your Honor. Good afternoon, Ms. Sork.
Okay. Good afternoon.
Could you tell the court, please, how you're employed?
I am the CEO of Northeast Michigan Community Mental Health Authority.
And where is Northeast Michigan Community Mental Health Authority?
We cover 4 counties in northern Lower Peninsula. We cover Alcona County, Alpena County, Mount Morenzi County, and Presque County.
All right, and just for the court's edification, I do have an exhibit book. It was in the pile there somewhere, but and it's much more skinny.
Oh, it's hiding. Great, thank you.
And with the court's permission.
Yes, absolutely.
Thank you.
Just for a little bit of understanding of the territory that you cover, is it illustrated there on our exhibit
Yes.
1 in the book?
Yes, it is. It's identified as C.
All right, and C is
Mhm.
the identification for it, all right. And how big of an area is that geographically?
It covers 4 counties. Well, I can't think of the square mileage, but I know it's larger than 3 states.
And how many beneficiaries do you service in that community?
We have 63,000 people in the 4 counties.
And tell us a bit about your organization. How about your physical plant? Where are you located? Where's your home office located?
We have our main office. We have 2 offices in Alpena. Our main office exists in the Alpena, town of Alpena. And then we have an office in Presque in Rogers City, an office in Mount Morency County in Hillman. And then we co-locate with a FQHC in Alcona County in Lincoln.
And do you have employees?
Yes.
How many employees?
When I'm fully employed, I have about 420 employees.
And can you tell the court a little bit about the scope of your employees? Are they professionals? Are they?
Everything. I own and operate 8 group homes for AFC, for intellectual and developmentally disabled people. So that's a large percentage of my staff. And we employ anyone. We also employ people that we serve. So people without a high school diploma or a GED, all the way up to medical doctors.
And what kind of services does Northeast Michigan Community Mental Health Authority provide for the community?
We provide crisis services, pre-admission screening, which was discussed earlier. In addition to that, we provide services to seriously, persistently mentally ill, children with serious emotional disturbances, autism, also intellectual developmental disabilities.
All right. And can you tell us, please, the size of your budget?
It's about $39 million.
Can you tell the court how much of your budget is comprised of Medicaid dollars?
I believe it's 87%.
And what is the mix of funding after that?
Variety of things, some grants, third-party insurances, local match money, general fund dollars.
And what are general fund dollars?
Those are dollars that come directly from the state. I receive of the 39 million, 1.2 million in general funds.
All right. And do you have any other local funds?
Yes.
All right. And what are those?
Each year, the 4 counties together, this was decided back in 1998 when we became an authority. They contribute about $244,000 a year. That's between the 4 counties together.
So if you didn't have any Medicaid money at all coming into your organization versus capitated payments, how much money would be available for you to service your beneficiaries?
Probably about 1.5 million, probably.
And tell us a little bit about how that money works within your organization. How is that money flow to you? How does that work?
Well, we're in a capitated system. So we get a monthly payment from our PIHP based on that projected budget or our projected revenue, and then the other supplemental pieces that we have to it. And then we bill for services. So that Medicaid dollars comes back to us, well, through the capitated system. We have the monthly amount, and then we bill the services per month.
All right. And so the capitated payments that you receive currently come through the regional entity, right?
Correct.
Is that right? And that regional entity that you participate in, how many CMHs are in that regional entity?
There are 5 of us in that region.
And then do you contract with other providers besides your own employees?
Yes, about 38% of my budget is for contracted services.
And who do you contract with to provide these services?
A variety of local mom and pop adult foster care homes that we will contract with to provide AFC services. And our most expensive contracts are contracted residential for specialty and also inpatient hospitalizations. We contract with outpatient therapists also, OTs, speech therapy, all types of services.
How about your residential services? Do you ever find it necessary to go outside the county to provide those?
Oh, absolutely. For all my seriously, persistently mentally ill people, that have to be maintained in a specialty AFC for mental illness. We have to send them outside of our region even,
And where would you send these folks?
all over the state. We have contracts with Premier Care in the Bay City area. We have contracts with Hope Network, with Flat Rock in the Flint area. We have contracts all over.
Are there special challenges for this vulnerable group?
Yes.
What are those challenges? Tell the court.
Well, there's not enough beds in the state to try to get somebody in an AFC home. We just this week had somebody in a hospital in Tawas that we've never known, brand new to us. Adult Protective Services involved. And so she was removed, an adult ADD person. She was removed from her father's care for alleged abuse. And we had to try to find an AFC placement somewhere in the state. And there's no beds, but we thought we secured placement on Saturday, had someone, and then they refused to take them at the last minute. So when I left Sunday morning, we were still working on calling providers, trying to find a home.
And just to be clear for the record,
Yes.
AFC is adult foster.
Adult
care.
foster care,
Sorry.
licensed
Right,
adult
yep,
foster
yep.
care.
I know what you mean, but the
Okay,
record
yeah.
doesn't. Thank you.
So how long have you been searching for a bed for this person?
Your Honor, I'm going to object to this as relevant to the purposes of what this hearing's for today. I think this goes way outside the scope of Your Honor's order about what we're here for today, and what you're trying to decide with facts.
I think the court's order was also the impact on the beneficiary should the Medicaid funding not change, funding stream change.
Yeah, I don't have a problem with that as long as it's limited. I don't want the hearing to turn into a whole discussion of that.
Thank you, Your Honor.
Understood.
I mean, I get that there will be a substantial impact on beneficiaries.
All right. How long have you been trying to find a bed for this beneficiary?
Multiple days since we learned about them in the hospital. The hospital needed the bed for medical reasons, so they were very upset trying to force us to find a bed for her, but we're not a placement agency, so.
All right, thank you. And if currently you have the ability to contract, is that true?
Correct.
And you talked a little bit about the contracts that you have.
Yes.
Under this new RFP, are you aware that you would no longer have the ability to contract?
Yes, I am.
How would that affect your ability to deliver services to this beneficiary group?
It would be very detrimental. We would not be able to develop a network that would be able to provide services. When you have a contract relationship with providers, you know each other, you trust each other. And so you develop that relationship that is very beneficial in getting people served.
And as it pertains to this one example that you gave us, is it under that circumstance, because you have an ability to contract, does that facilitate your ability to find a bed for this person?
Yes. Yeah, people returned our calls because we contract with them.
What what services are you required to provide in your community under the mental health?
I object to last for legal conclusion.
Sorry?
I asked for legal.
Yeah, why don't you ask what she's done in the past? Because she certainly can talk about that.
Well, are you familiar with the mental health code?
Yes.
All right. And how long have you worked as a CEO?
I've been the CEO for 7 years. I've been employed at this community mental health for 17.
All right. And prior to your being a CEO, how were you employed with this community mental health organization?
With this community mental health, I was an outpatient therapist and then the supervisor of our crisis services, our outpatient services, and our access services, those 3 departments. Then I became the chief operation officer and then the CEO.
And prior to your employment at Northeast Michigan Community Mental Health, how were you employed?
I spent 23 years in the private sector as a master's clinician, social worker, doing outpatient psychotherapy, inpatient psychiatric therapy, outpatient SUD services, inpatient SUD services, and then I owned my own private practice and worked in private practice for a number of years.
And what's your educational history?
I have a bachelor's degree in social work.
Your Honor, are we going for an expert here, or what's the relevance of this right now?
No, that's okay. I mean, look, I think I may have redirected Mr. Cook that in a way that led him down this path, because I think his original question was what kind of services were provided or something like that.
Under the mental health code.
Right,
So,
right.
yeah.
And then, since you objected and I sustained it, I told him she can talk about what in her experience she's done.
Right.
So now
almost
we're on
done.
this detour down our experience. It's a long way of laying foundation, I think. Let me put it this way, Mr. Cook. If you want to ask her questions about what in her experience falls under coverage under the mental health code, that's fine with me now.
All right, thank
We
you.
have more than enough foundation.
Thank you, Your Honor. Thank you. All right, based on your background, experience, and training, can you tell the court, please, what services you provide that are required under the mental health?
Yes, we provide crisis services, pre-admission screening services, psychiatric services, outpatient therapy services, case management services. I have 17 clinical programs, employment services, community living support services. We have a program we call Supported Independence Program, which is billed under CLS also. We have a unique program that works for our community, which is called Personal Emergency Response Services. So we have a 24-hour monitoring system that people are on an open telephone monitor. It's to encourage and help people live independently that probably would be in an adult foster care home if it wasn't for that service. They can live independently in their own apartments with our support 24/7.
And this list of services that you've provided for the court, would you be able to successfully provide those under the terms of this RFP?
No,
And why not?
I don't believe so. Well, because we'd be unable to contract with folks. We live in a very rural area. It's very difficult to recruit staff. And we have to rely on other providers, even though they're very limited. We have very few contract providers in our northern rural area, but we must rely on the ones that are there to help provide services.
And without the Medicaid funding, if that were to be now reapplied according to the terms of the RFP, would your organization be able to survive?
No.
And why not?
Well, just one person in a contracted residential unit downstate, and average cost is about $156,000 a year for one person. That doesn't include inpatient hospitalization charges. Those are my two most expensive areas. That would eat up all of my general funds, and then there would be no money to take care of the uninsured or to take care of people's spend downs if they were on Medicaid.
All right, what do you mean by spend downs?
People, it's like a deductible, and some of them have very high spend downs, so they're not eligible for Medicaid until they've met those services, till they met that cost.
And how do you meet that cost as a?
Any services that they receive from us or physical health gets billed to Medicaid, and once they hit that, let's say they have a $1,200 spend down a month, once they hit $1,200, then Medicaid kicks in and we can bill after that.
What are you using to make up the funds in the meantime?
General funds. So to keep them in services every month.
All right. Are you required to respond to requests for information under the Freedom of Information Act?
Yes.
How about the Open Meetings Act? Are you
Yes.
controlled by the Open Meetings Act?
Yes.
What about your obligation to provide recipient rights?
Yes,
Do you have an obligation to do that?
absolutely. I have 3 staff in my recipient rights department.
And as part and parcel of your obligation to provide recipient rights, do you at times have to work with outside providers?
Per our contract, absolutely.
Oh, and what assurance do you have that outside providers are willing to be investigated by you under a recipient rights complaint?
They agree to that under their contract, and it's a contract violation if they don't participate and cooperate in the investigation.
Could you provide adequate recipient rights if you did not have the ability to contract with?
No, there would be nothing that would compel them.
Are you also subject to governmental immunity?
Absolutely.
And is that a benefit to your organization and your community?
Tremendously. I worked in the private sector for years, and no one in the private sector would take on, or very few people would take on high-risk clients that we have because of the liability. Even just the malpractice insurance rates that go up every time they would get sued by a family member of someone who is mentally ill that
And have you actually used that, the fact that you're a governmental entity benefit your ability to retain?
Especially my psychiatrist, yes, that's part, when we discuss that with them, when we're recruiting, that makes a huge impact on their decisions. And that's one of the reasons why they come and work for us. And I'm able to maintain consistent psychiatric services with the same doctors.
What about wraparound services for children and youth? Would there be an impact on those if this RFP were implemented?
Yes, yes, we contract out our wraparound program to Catholic Human Services, another provider in our community that we partner with.
And what is a wraparound program?
It's where staff works with the family and children with all the other providers that are providing services to that family, with the schools. They attend their IEPs. They help them be successful in different areas.
What's an IEP?
Oh, it's an educational plan. I should know. My daughter's a special ed teacher and I don't know the letters. I just hear her writing them all the time.
All right. And these things that you've identified, attending an IEP and
Yes.
having the staff work with Catholic Human Services, are there any billing codes under Medicaid for that?
Absolutely not. Working in the private sector, so much of what we do, that's why our rates are so high, is indirect to keep people stable and to keep them on medications, to keep them in the community and not institutionalized, hospitalized, or in jail.
You said something interesting. So not keep, that's why your rates are so high.
Yes.
Explain that for the court.
Just for example, part of services that we can bill for doesn't have anything to do with keeping the person stable in the community. Maybe the outpatient therapy session or the med review session with a doctor, but then our CLS staff or our case managers, they're out in the community, helping them keep their apartments clean so they don't get evicted, helping them make sure that they're grocery shopping and eating adequately and eating well, helping them. Some people, we have to help them. They live in an area where there's no power, electricity, or water. So we help them get water to their place of residence during the ice storm. This is what we do every day. We go out, we make sure people are taken care of. We make sure they're taking their medication. We'll drive out on a 2-track, not to a trailer house, to a litter trailer, like a camper, and give a person their injection, because they're so paranoid they won't come into the community. So that's what we have to do to keep them stable and to keep them living independently and out of an institution.
And those things that you just described, are there billing codes for Medicaid
No.
associated with any of those services you provide?
No, a lot of those services, we're transporting them. We have no transportation up in the 4 counties except in one small town. So we have to go transport them to bring them in so they can have their medication review, so that they can have their services at times.
Judge, I'm just gonna object for a moment, and sorry for going over, but if these are non-Medicaid services, I don't know how this is relevant if these are services not covered by Medicaid, because the RFP is for Medicaid.
Right.
So I don't know what the relevance of a lot of this is.
The setup question was, why are your rates comparatively high for her CMA? And I don't know, but I think she's coming around to explaining that an awful lot that's not funded by Medicaid winds up being wrapped up in what they provide. And so there's an awful lot of cost that doesn't get reimbursed by Medicaid, and yet it's got to be absorbed by the CMA.
Thank you. Thank you. And that's what you were explaining, is why.
Yes.
Your
Okay,
cost.
yeah, I
Yes.
understand. Let's move on, because I understand that point. There are a lot of administrative costs and just non-Medicaid reimbursable activities that you engage in as well. I've got it.
All right. Is there anything else about your review of the RFP that, should it be implemented, you think will detrimentally affect, number one, the structure of your CMA?
I'm going to object to the extent that the question speaks to a RFP being implemented. An RFP is a request for proposals. It's not something
Right,
that's
sure.
implemented.
I think it's probably best to describe it as the architecture of the RFP.
Thank you, Your Honor.
Could the architecture of the RFP be implemented? First of all, what impact would it have on your organization's survivability?
I think it would be extremely difficult for us to continue. We certainly couldn't continue to provide services like we do today. Also, the idea that it would be managed by some entity outside of our local control in our community and responding to what each county needs. Mount Morency County is very different than Alpena County. So we try to customize for what's needed in each county and work with county commissioners and other partners in the county. So I think that would be difficult to not have the Open Meetings Act, to not be sure and clear how recipient rights would work with a seriously persistent mentally ill and the intellectual developmentally disabled people who cannot advocate for themselves.
Now, how about the survivability of your organization based on the funding stream? The funding stream would change.
Your Honor, I'm gonna go ahead and put an objection to, this is good, it's cause for speculation.
Well, I expect she can talk about the centrality or not of Medicaid dollars to their operations. Let's just see if we can do this in one question and then move on.
Thank you, Your Honor.
Can you explain what impact, if the architecture of the RFP were implemented? What impact would it have on, and the funding stream were to change as indicated in the architecture of the RFP? What impact would it have on your organization?
We wouldn't look anything like we look today. We wouldn't be able to be as flexible in providing services, treating anyone where found. You know, I think somebody testified earlier, it's not unusual that we meet people we've never known, homeless people. They're found where found, so they're ours. If they wander into one of our counties and they need services, they belong to us.
You'd be able to provide all of those services that you're required to provide under the mental health?
No.
Thank you.
Cross-examination?
Yes, Your Honor.
Time here, 4:13.
Could you tell me where in the mental health code it uses the term local control?
It's part of our authority agreement with our county commissioners is to have a
My
local.
question, can you tell me where in the mental health code the term local control is used?
No, sir. I don't have the mental health code memorized.
Not used in the mental health code, right?
Yeah, it's part of our agreement with our counties.
Not part of your agreement with DHHS, is it?
No, it's not our contract.
And you're not an attorney, are you?
No,
And you work for the Northeast Michigan CMHA, correct?
correct.
And that's part of the I'm sorry, all these acronyms, NMRE PIHP.
Correct. Correct.
Yes. How much are you currently paid a year?
154,000.
And you've sat here today, and you've heard other testimony, but you're aware that there's likely to be changes in the contract from what's in the RFP.
Objection, any questions about changes in the RFP? Because that's not in front of the court. There's been no proposed changes. We're dealing with the issues in front of the RFP as they are right now. And talking about changes, speculative changes in the future should have no impact on this court's decision as to whether or not this RFP complies with the mental health code.
I think at the end of the day, that may be right, Mr. Cook, but it still seems to me that in light of the testimony that we heard from, excuse me, just a moment, I'll get to it. Ms. Gove, that the ultimate contract may not look exactly like the RFP. There may be some difference. Now, I get the fact that you've challenged the RFP. You can't challenge the contracts because they don't exist yet. But I'll let Mr. Beach pursue this a bit. This is certainly a point that I understand.
Good, thank you.
I don't think I need to spend that much time on it. Your Honor.
Yeah,
I think
right,
the court
please,
understands
right. I
it.
mean, some of these themes we've heard an awful lot already.
And
today.
I will keep that in mind for the rest of my questions.
Right, no, that's okay. But if you want an answer from her on that, you certainly may ask it, but I suspect she's going to say something that's consistent with what everybody else has said.
I'll just ask it in a shorter version. You're aware that there could be changes from what the terms are currently written in the RFP.
And it could go forward the way it is now.
It could.
Yeah.
And again, you don't know who the winning bidders could be, correct?
No,
It's possible they could be made up of a CMHSP or CMHSP regional entities, right?
Same objection. We're talking about possibilities now, Your Honor. Now we're going down the road further
Well,
about different constructs and
That's the kind of
possibilities.
questions Mr. Cook
No,
was
no, no, no,
asking
right,
about
right, right. I'll overrule the
possibilities.
objection. Look, I think we all understand, we've been doing this for weeks now. Obviously, it could be a PIHP or two PIHPs or more, but it could also be a university or it could be a nonprofit. So, I mean, none of this is a mystery to me at this point. If you want to ask the question, Mr. Beach, I'll let you have it. 'Cause
Yeah,
we've been going on about this for some
Right.
significant period of time, and I
So-
recognize that universities are going to be under restrictions that don't apply to CMHSPs and all of that.
So you're currently in, or your CMHSP is currently in Region 2, right?
Correct.
PHP, and that's NMRE, correct?
correct.
And the region or the PHP for the Upper Peninsula is North Care, correct?
Yes,
And the new region in the RFP called the Northern Mega Region or Northern Region could be formed if those two current PIHPs, if they came together and merged and submitted a bid, correct?
not the way they're set up now.
Okay, but North Care and NMRE currently cover regions 1 and 2, correct? And that's the new northern region, right?
Yes,
Okay, so if they came together and submitted a bid, it's possible that the existing PHPs could be the new PHP, right?
I don't know. The way we're set up today and our boundaries, we're not allowed to do that.
But it's possible, right, if they submitted a bid?
I have no idea what the possibilities are.
You also testified earlier that 87% of your funding comes from Medicaid?
Correct.
Can you tell me where you got that number from?
My CFO,
So it's hearsay. Do you have any documents supporting that?
not here with me today.
Okay. Are you aware that in the briefs that the Region 10 plaintiffs submitted, all of their funding percentages were around 65%? Is there a reason your funding for Medicaid is so high?
No foundation for that as to what somebody else's Medicaid dollars were.
Well, I don't know that I want to assume that those facts are true, but he certainly can ask if the benchmark seems to be 65%, whether there's some reason that their 89% is where it is. I just assume give her a chance to explain.
I know we have very little of third-party reimbursement. We rely, we have very few grants.
I think you were here earlier too when Sarah Lindsay testified.
I don't recall her.
I'm sorry, Sandra Lindsay?
Yes,
You testified, okay. All right. And she testified that the CMH SPs had a large number of funding sources. You testified earlier that all you get is Medicaid and a county match. Is that correct?
no, that's not my testimony.
So what other funding sources do you have besides Medicaid?
I said we do some third party. We have a grant with PASSAR. We have a Healthy Michigan grant. We do some COFRs with other CMHs when we're providing services for their people that are in our area.
And just to be clear, it was your testimony earlier that your rates are where they currently are because you provide a lot of other services that are not Medicaid eligible? Is Is that correct?
No, that's not my testimony. My testimony is that we have to cover our costs. And a lot of what our staff does are more indirect costs. We have a lot of travel time. We have a lot of windshield time that we can't bill for. We spend a lot of time tracking down clients, trying to find them in the community, make sure they're taking their meds or that they're showing up for their doctor appointments or their medical appointments.
And I'm sure you're aware that NMRE has not signed its contract with MDHHS.
No, I believe they signed their contract. They just redlined a couple of items in the contract they didn't agree and they wanted to negotiate.
All right, but they're currently under a transition clause, correct?
I don't know. I don't work for the NMRE. I just
Okay, but you
heard the
sat in
test.
court here today, right?
I heard that testimony,
Okay.
but I don't know that directly.
All right, so if they're under a transition clause that's going to expire in September, are you concerned about the fact that your PHP will not have funding and be able to serve beneficiaries?
That's our CEO of the PIHP's problem to worry about. I worry about Northeast right now.
And you're aware that it's possible for things like FOIA, Open Meetings Act, or for those things to be resolved through contracts with PIHPs and providers.
I'm not an attorney. I take your word for that.
All right, so you can't
don't know.
really tell us anything with regard to the legal aspects of the RFP because you're not an attorney and don't have that expertise, right?
No, but I have concerns about it the way it's written.
Right, and that's a good way to characterize your testimony. So what you've been saying today are about concerns and impracticalities of what you believe the RFP is going to do, but you don't know, right? Because you're not an attorney.
Well, and because you say it's all up for renegotiation.
Right, and it's up
Could
for
be anything.
renegotiation.
Could
So
be
you-
anything, or it could be the way it
Right,
is.
so you really can't help us that much at all today, can you?
Objection to that question. Can't help us at all. Object.
I don't have any further
Right, and
questions.
I think that was more a rhetorical flourish
Yeah,
than a
I
question.
appreciate, appreciate it, I guess.
All right, just a moment, please. Let me make sure I have the time down here. I do now. Mr. Cook, redirect examination whenever you're ready, sir.
Thank you. Ms. Sork, the scenario you portrayed about earlier in your direct examination, that your organization would not be able to exist the way it is now
Correct.
if the architecture of this RFP is implemented, remains the same.
Absolutely.
And that comes from your background, training, experience in this area and also with your own organization.
Correct.
The same with your testimony about your ability to contract. If you lose your ability to contract, your testimony remains the same, that you would not be able to provide this full panoply of services that you're required to provide under the mental health code. Is that right?
Correct.
Those things are based on your own experience.
Yes.
You don't need an attorney to tell you that.
No.
Okay. And this number, this Medicaid, I guess it's 83% or something?
87, I think.
87, thank you. Larry. You got that from your chief financial officer? Is your chief financial officer charged with the obligation to know these things?
Absolutely.
And that would be a business record that you relied
And
on?
report to the state. Yes.
Thank you. No further questions.
Any recross examination?
No.
Thank you very much. Just see, oh, that was quick. Okay, you may step down. Thank you very much, Ms. Sork. And of course, you're welcome to stay. You've been here all along. Okay, where are we? Do you want to call another witness? Can we get somebody on and off before 5 o'clock, or you want to call it a day? If we're running way ahead of schedule, don't feel like you have to fill the time up till 5 o'clock.
I'm not sure I can get someone so finish before.
How many more witnesses do we have coming, just to be clear about this? I think you said you were down to 3, but then you said you may have as many as 6. How you doing?
I think depending on how the testimony goes, that I can get
Sure, right, and that's what I'm trying to avoid. I mean, I'm not gonna invoke 403 on you, needless waste of time or whatever the language is, that we don't need to hear the same testimony again and again and again.
But all the testimonies is slightly different because it was a geographic area, but it's similar in scope.
Right, I get it.
So
But you are in the process of offering me a clear view of CMHSP's perspective, and I know Mr. Marchand's done some work on that too. So I don't want you to feel like you're coming up short, but I don't want you to feel like you have to tell me through 10 different witnesses basically the same thing.
Oh, sorry.
Oh, you know what? That's right. Oh, boy. Sorry, Mr. Trudeau, that was my fault. Were you picking that up or not?
Yes, I was.
Oh, great, okay.
It was just a little quiet, but I got it.
All right, great, thank you so much. Okay, go ahead, Mr.
Realistically, I think two more witnesses, depending on their proofs, you know, and how those proofs come in.
All right, and Mr. Marchand, I know we have one of your witnesses that you want to call as an expert.
Correct. And then there are.
Oh, hang on, we need to get a mic in front of you. Sorry.
Correct. We have one more definite. There are 6 on the maybe. If they do, they would be like 5 minutes. I mean, they're not long.
Are they from your side or are they
They're
all
from
adverse
the
witnesses?
state side,
What's that?
the state side.
They're adverse witnesses.
Correct.
Okay.
So we'd want just a little break to chat on whether we actually need them, which we're trying
Yeah,
to do.
I'll tell you
here.
what, why don't we go off the record for 10 minutes and put your heads together on this. The last thing I want to do is make a bunch of MDHHS people drive down to Grand Rapids tomorrow. I don't even know what the weather's going to be like if they
I
don't
don't
have to
either.
go.
Yeah.
I think it's not going to be great tomorrow.
Okay.
I remember thinking Monday's clear, Tuesday's not. I'm really glad that this was my road game today. Tuesday's
You
gonna
and
be a
me
home
both.
game. Yeah, right. So put your heads together. I'd like to reconvene on the record just in case there's anything else to cover. So at the other table, think about whether there's anything you want to raise for purposes of the record, and then we'll call it a day. I can't see any reason to put another witness on the stand today. We've done a huge amount of work. So let's go off the record now, Mr. Trudeau. We're not taking anything down until I tell you we're ready to go again. Okay, thank you very much, everybody. At ease, relax, walk around, whatever you want to do. You tell me when you're ready to go and
What
let's
time do you
plan.
want us back?
Whatever you want.
Oh, okay.
Well, I have to take care of Mr. Flagle. He's very important.
And then like, I got sent to, I interviewed corrections looking for that. Yeah. In the burnout rate.
I think so. It looks like everybody's here. Yes. Okay, why don't you?
Michigan Court of Claims is now in session.
Thank you very much, everybody, for working expeditiously, not only through the day, but just now, because everybody's back and it's been less than 10 minutes. Mr. Trudeau, we can go on the record again.
Okay, all set.
I'll indicate for the record that in relatively short order, the attorneys were able to return to the courtroom. I take that as a good sign. So if somebody would like to report to me where we are and what you need from me before we adjourn for the day, I'll be glad to hear from you.
So
As long as you're on a mic, I'm sorry about that. This is, this is something I have to keep
Yeah,
pointing
no
out.
problem.
Okay, thank you, Ms. Service. Go ahead.
So Mr. Ryan just approached and gave me a game plan for tomorrow. I just have not had a chance yet to chat with my team about our plans. So if you could give us like one more minute, that'd be appreciated.
Of course, yes. Okay, sorry, Mr. Trudeau. We'll go off the record for just a moment again.
No problem.
Need to hold everyone in suspense. I think we're very close. And you can all sit down, just relax. We're all friends here now. We've all been together all day and then before that. While we're off the record, I can tell you this, the puzzle that is the amicus submission is coming together. I've received 2 more pieces and now I think I have everything I need.
I think the briefing is now complete.
It is finished,
And
yeah.
it's all accepted. At
I'm
least on the
impressed that
motion-
somebody
on the
had time to
motion.
write the reply.
No. I mean, the filings have been accepted.
Oh, yes.
By the
yes.
clerk, yeah.
Hmm? They even point out that amicus briefs are regularly filed in this court, and sometimes before this judge, close friends, in cases of public significance. That's true. Now, then they list a whole bunch of my cases. All right. $37, $49, $59, $64, $67, $71, $78.
Yeah, I mean, that makes sense. Cause I don't think.
You know what I mean? We want to, yeah, but the pencil and breaking as well. I want to run out.
Okay, I can.
We should.
I haven't looked at all. I haven't looked at. So, have you already done her death transcripts? Like, do you already have her outline? I had it next week.
And I was kind of like, yeah, right. That might be why. But he's in the line because it's a big hill. It's a really big hill. You go and Jackson that right on and kids have infinite.
Yeah.
Well,
So I have here.
Living out there for.
Yeah.
You wanted to get you know, so it's like anyway, but
Would you want Aaron to?
yeah, I think it's the same thing.
Part of that.
No, those, yeah. Right. Yes.
Yeah.
I asked, like, you know, for like an outline that.
Someone else.
So we.
Generally, we have to disclose the subject matter. First question would be like, who are you doing?
Well,
What do you think it's like? We can, try to get you in the system. For what?
The law.
What are your qualifications?
So I gotta have Becker tomorrow, I'm gonna be the
Just think
state
you
building.
understand this question, this case.
Oh, yeah.
Meet us as the state
how-
building.
1:30 is the step, so one.
Yeah, I'll meet
Yeah.
at one. That way kind of up there.
Like what
Yeah.
methodology?
Might even do the Zoom. I might even tell him to make his way over. And, like, I'll just, you know what, because he's downtown too. So he's
Oh,
outside. So I
okay.
can just text back and forth.
Okay.
You know, like, well, if you want to, maybe just like, if you want to come out, I'll go
Okay.
over.
Okay. Oh.
You know, his own.
I think we're all set.
Yeah.
Yeah.
Okay, great. Mr. Trudeau, you ready to go?
All set.
We are once again back on the record. And at this point, before you say anything else, I did a quick calculation of the numbers. The plaintiffs used 145 minutes today, meaning you have 130 minutes left, a little over 2 hours. The defense used 99 minutes, which means you have 141 minutes to go. So you have 10 more minutes, 11 more minutes than the plaintiffs. Now, having said that, and having indicated that I've received the full set of materials on the amicus curiae filing, let me turn it over to the attorneys to see where we are from the plaintiffs. I think, Mr. Cook, you have a few more witnesses to go, maybe 2, maybe as many as 5, but probably closer to 2 than 5, right?
Closer to 2 than 5.
All right, and then Mr. Marchand or Mr. Ryan or Ms. Wixon,
We have 2. One is simply authentication, but defendants wouldn't stipulate, so.
Oh, is this that fight we're gonna have about the directors? Oh, it's something else.
It's a
Okay.
different fight. It's a different fight. And so, there's one on authentication of a document and then, our Carol Mills, whose step is.
Right, yes, right. Okay, so I take it you can easily finish within the remaining 130 minutes you have. Obviously, you have to spend some of that time on cross-examination, but that's well within what's possible, right?
That is certainly our hope.
Okay, right. As I say, I'm at your disposal for the next 2 days. Okay, let me look at the other table and see how we're doing. Is it you, Ms. Service, who's
Thank
gonna
you.
report? Okay, tell me what is happening on your table.
So we have 3 witnesses. One, Ms. Osmond, would be testifying tomorrow,
Okay,
and then the other 2 would be testifying Wednesday because their depositions are taking place tomorrow afternoon and Wednesday morning.
that's fine.
So I think from our perspective, if Mr. Cook has possibly 2 witnesses and then the Region 10 plaintiffs have the 1 state witness for authentication, we then could probably call Ms. Osmond and all be done, hopefully, before breaking around lunchtime, and then we could be done with the hearing for the day and all go to the depositions that afternoon.
That's fine. I certainly have plenty of other things I can do. I'm trying to clean up my opinions from case call last week, so that'd be beneficial to me. Although, as I say, I'll sit out there all day tomorrow if you want. Okay. The only other thing I'll say by way of a warning is it looks like it's going to be snowing here in Grand Rapids tomorrow, so sorry about that. My memory served me well. I'm not sure it's going to be a great travel day, but look, I'm not going to get mad at anybody if you're not there on time. Don't risk life and limb to make sure you're there by 9 o'clock. Okay, I want you there at 9 o'clock. I'll be there, but I'm not going to be upset if somebody has trouble because of the weather. Okay. All right, anything else we need to talk about before we adjourn for the day? Good. Thank you very much. And I appreciate everybody working so efficiently today. It's nice to report to Mr. Flegel, our head of security, that he has some time to set up the courtroom for oral arguments. Thank you, Mr. Trudell. We can go off the record now.
Thank
Okay,
you.
thank you.
Thanks so much, everybody. Appreciate it.